ಬಂತು. ಬಂತು. ಅದೆಲ್ಲ ಕುತ್ಕೊಂಡು ಮಾಡಿದೀವಿ ಸರ್. ನಾವು ಬರೀ ಅಲ್ಲಿ ಹೋಗಿದ್ದೆ.
ಹೋಗ್ಬಿಟ್ರೆ ನಿಮ್ಮನ್ನ ಬಿಟ್ಬಿಡ್ತಾರೆ, ನಮ್ಮನ್ನ ಹಿಡ್ಕೊಂಡು ಕೊಡ್ತಾರೆ.
ಏನು ತೀರ್ಥಂಕರಾಗ್ಲಿಲ್ವಾ?
ಬರಲ್ವಲ್ಲ ದೇವಸ್ಥಾನದವ್ರು ದರ್ಶನ ಮಾಡ್ಕೊಂಡು ಬರ್ಬೋದು ನಾವು. ಬೇಕಾಗಿರ್ಲಿಲ್ಲ. ಹೇಳ್ಬೋದು ಪೈಪ್ ಕುಡಿಯೋದು ಅವಾಗಿನ
ಕೊಡುತ್ತೆ
ಇಲ್ಲ
ನಂಬರ್ ತಗೊಂಡೆ. ನನಗ್ ಮಾಡಿದ್ದೀರಾ? ಕೊಟ್ಟಂಗಿಲ್ಲ ಸರ್, ಒಂದು ಪಾಪ ಕೊಡಿ. ಒಂದು ಇದು ನಿಮಿಷ ಕೊಡಿ, ಸೈನ್ ಹಾಕಿ ಕೊಡ್ತೀನಿ ಸರ್.
ಅಂದ್ರೆ ಅಂದ್ರೆ ನಮ್ಮ ಕೊಲಿಗ್ ಇದ್ರಲ್ಲೂ ಮೆನ್ಷನ್ ಮಾಡಿದ್ರೆ ವಾಟ್ಸ್ಆಪ್ ನಿಮ್ ಕಾಪಿ
Lord,
ಏನು ಸತೀಶ
I am moving matters for end of the list for this reason, my lord. Matter pertaining to, my lord, transfer through counseling. Lord, DPR has issued a circular which is pertaining to, my lord, all the departments, which applies to all the departments. My lord,
24 circular
25/6/2024. Lord, carves out one exception. That is, my lord, wherever there is act or rules are made by that department, particular department, Lord, transfer is governed under those, my lord, acts or rules.
that's an exception.
That is an exception. That carves out an exception that, my lord, wherever there is act or rules, they are governed under the act or rules of that department. My lord, such as, my lord, police department, medical officer, PDO,
Yes, department.
various departments have, my lord, issued act or rules by the very same department. Lord, the revenue department, no, my lord, issues an executive order superseding, my lord, the general transfer guidelines. My lord, revenue department is following those guidelines right from, my lord, 2001 to, my lord, till new policies framed on 31/7/2024. Now, my lord, we approached the tribunal. Lord, yesterday at, my lord, 4:45, our interim prayer is rejected and we are directed to, my lord, participate in the counseling. Very applications will become infructuous. Lord, counseling is scheduled today. Today.
Postpone to Monday.
Postpone to Monday.
Right. And the revenue department has carved out an exception only insofar as 3 cadres, not in respect of the entire
ಈ
department.
ಮಂಡೇ ವರೆಗೆ ಹೋಗಿದೆಯಲ್ಲ.
Monday, my lord,
Today is the final list.
Huh?
They are publishing the final list even as per the revised calendar today itself. Today itself.
When July 2024 or 24/6/24 ಅಲ್ವಾ?
25/6/2024.
It applies to all departments except where there is a statutory instrument, that is act or rules promulgated in the act which provide for such a transfer. How can you apply on the, is there any the order which is issued by the revenue department which Satish is, which is that date?
my lord, 31/7, 39/2024, my lord.
Is it a statutory order?
No,
Earlier, they have
No.
issued similar order and with.
it does not have statute report.
What the KAT has said?
That's KAT.
When you had to file the KAT, how many years, ಎಷ್ಟು ದಿವಸದಿಂದ ಆಗಿತ್ತು ಇದು ಆರ್ಡರ್ ಇದು ಫೈಲ್ ಯಾವಾಗ ಮಾಡಿದ್ರಿ ನೀವು?
22/10 it was circulated. All of us have approached on 24. My lords, yesterday evening at 4:45, it is rejected. The respondents who were on caveat, my lords, took time to file objections. It was given to us day before. Yesterday it was heard, and yesterday evening at 4:45, it is rejected. my lord.
ಇಲ್ಲೂ KAT ಇದೆನೋ?
ಇಲ್ಲ,
End of the list.
230. My lord,
230.
similar, I have 230.
230.
Same matters, my lord, about this.
Same, sir.
Same.
ಎಷ್ಟು ಜನರದ್ದಿದೆ ಇದು?
Around 25 people are there, Manoj. Petitioners are there.
Not the-
4 to 5 petitioners are. Writ
ನಾವೇ ಅದು
petitioners.
ಒಂದಿದೆ ಅನ್ಕೊಂಡು ತಗೊಂಡಿದ್ದೆ.
ಅಲ್ಲ, ಎಲ್ಲ ಒಂದೇ.
Only one argument, Manoj.
ಅಲ್ಲಿ ನೋಡಿ ಸ್ಕೂಟ್ನಿ ಎಲ್ಲ ಹಾಕೊಂಡು ಬಂದ್ರಷ್ಟೇ ತರಿಸ್ತಾರೆ.
Please.
Very
Malash,
ಆಗ್ಬೋದು.
Malash. Farm number 57 pending ಇದೆ Malash. Tahsildar LGC ಕೇಸ್ ಆಗಿದೆ.
Number ಆಗ್ತಾ ಇದೆ.
ಫಾರ್ಮ್ 57.
Yes Malash, pending ಇದೆ Malash. Farm
ರೆಗ್ಯುಲರೈಸೇಷನ್
LGC
ಆಫ್ ಗವರ್ಮೆಂಟ್ ಲ್ಯಾಂಡ್.
yes Malash.
ಏನಾಗಿದೆ?
Posting.
ನೆಕ್ಸ್ಟ್ ವೀಕ್.
Regular first appeal, my lord, with the report matter.
ಯಾವ್ದು?
RFA,
ಯಾವ ಇಯರ್?
2024. Fourth is the last date, my lord. The trial court has directed us to deposit the royalty amount. My lord, otherwise, my lord, the property is attached. Therefore, my lord,
ಥರ್ಡ್ ಹಾಕಿ.
ಅಲ್ಲ, fourth ಗೆ
ಗೊತ್ತಿಗಿರ್ಬೋದಾ?
ಬರೋದು.
ಓಕೆ. ಟೋಟಲ್ 7 ಇದೆ.
Yes,
ಪಂಡಿತ್ ಸಾಹೇಬ್ರು ಕೊಟ್ಟ.
ಹೌದು sir.
ನಾವೊಂದು ಡೇಟ್ ಫಿಕ್ಸ್ ಮಾಡೋದಪ್ಪ. ಅದೇ
Fifth ಗೆ ಹಾಕಿ sir.
ಫೋರ್ತ್ ಹಾಕಿ ಬರ್ರಿ.
ಮಚ್ಚ.
ಅವ್ರು ನಮ್ ಬೈದ್ರೆ ನಾನು ನಿನ್ನೆ ಕರ್ಕೊಂಡ್
ಇಲ್ಲ, fifth ಗೆ ಹಾಕಿ ಸ್ವಾಮಿ, ಬೇಡ. ಮಂಡೇಗೆ ಅವ್ರು ಯಾರು ಡೇಟ್ ಕೊಟ್ಟಿರ್ತಾರೆ ಆಲ್ರೆಡಿ. Fifth ಗೆ ಹಾಕಿ. ಮಚ್ಚ.
Serial number 43, my lord.
43.
Short accommodation.
ಯಾವಾಗ?
Any day next week, my lord.
ನೆಕ್ಸ್ಟ್ ವೀಕ್ ಆಗಲ್ಲ ಬ್ರದರ್.
Any day. Any day.
ಫಸ್ಟ್ ವೀಕ್ ಆಫ್ ಸೆಕೆಂಡ್ ವೀಕ್ ಆಫ್ ಜನವರಿ ಹಾಕ್ಬೋದಾ?
Interim order to be extended.
ಸೆಕೆಂಡ್ ವೀಕ್ ಎಂಟ್ರಿ ಮಾಡಿ ಟು ಕಂಟಿನ್ಯೂ ಎಟ್ ದ ರಿಕ್ವೆಸ್ಟ್ ಆಫ್
41 you lord.
41.
41.
ಏನು ಸಾರಥಿ?
I am appealing for some inconvenience.
ಸೆಕೆಂಡ್ ವೀಕ್ ಆಫ್ ಜನವರಿ ಎಂಟ್ರಿ ಮಾಡಿದ್ದೇನು?
Entry ಮಾಡು.
ಹೇಳೋದು
It will become infructuous. that is the-
ಎಂಟ್ರಿ ಮಾಡಿ ಟು ಕಂಟಿನ್ಯೂ.
Serial number 19.
ಅವ್ರು
Serial number,
ನಿಮ್ಮ ಇವ್ರಿಗೆ ತಿಳಿಸಿ.
ಇಲ್ಲ, government is
Okay.
there.
serial number 19, my lord.
Government is also friend only. Although we are taught in administrative law that government is the first enemy of the citizen. But in our country, we always said Raja Pratyaksha Devata. Yes.
Serial number 19, my lord.
Number 19.
19, 19.
19.
Yes, my lord. A small inconvenience, my lord. Preliminary hearing.
Entry ಮಾಡ್ರೇನ್ರ ಇದೆಯಾ?
ಇಲ್ಲ.
ಇಲ್ಲ. ನಾಳೆ after 4 weeks.
Serial number 31, my lord.
31.
31.
ಏನು ಎಲ್ಲರೂ ಹಬ್ಬ ಮಾಡ್ಲಿಕ್ಕೆ ಹೊಂಟ್ರೆ ನಮ್ಮನ್ನ ಬಿಟ್ಟು ಒಟ್ಟು ಟೈಮ್ ಕೇಳ್ತಾ ಇದ್ರು.
No, my lord.
ಹ.
Sir,
ನಾವೆಲ್ಲ ಓದ್ಕೆ ಬಂದಿರ್ತೇವೆ ಮತ್ತೆ ಓದ್ಕೆ ಕೊಡ್ಬೇಕು.
31. Any date, my lord. And also 39, my lord.
Third week of January.
Okay. 39 also.
ಎರಡು.
Senior is
ಒಂದು
out of
ಕ್ವೆಶ್ಚನ್
station.
ಬರ್ತದೆ.
Senior is out
Contestant.
of station, my lord.
Serial number?
39 also, madam.
All right. You
in
inform
30
your friend also.
Sure, my, it is
Ah.
there. In 39, interim order to be extended.
Entry ಮಾಡಿ.
Obliged.
My lord, list 2 serial number 8, my lord. For the
List 2.
appellate. Yes, my lord.
ಅರ್ಜೆಂಟ್ ಇದ್ರೆ ಅಷ್ಟೇ ತೊಗೊಳ್ತೇವೆ ನಾವು. ಇಲ್ಲದೇನು ತೊಗೊಳಲ್ಲ. ಲಿಸ್ಟ್ 2 ಸೀರಿಯಲ್ ನಂಬರ್
8, my lord.
ಫೈನಲ್ ಹಿಯರಿಂಗ್.
Yes,
ಏನು
my lord.
ತೊಗೊಳಲ್ಲ ಬಿಡಿ. ಆಲ್ ನೋಡ್ರಿ 8 to 9. ಫೈನಲ್ ಹಿಯರಿಂಗ್ ಲಿಸ್ಟ್ 2ದಲ್ಲಿ ನಾವು ಇಂಪಾರ್ಟೆಂಟ್ ಇರೋರು ಅಷ್ಟೇ ಕೂತ್ಕೊಳ್ಳಿ. ಇನ್ನು ಉಳಿದೋರು ಕೊಡೋ ಅಗತ್ಯ ಇಲ್ಲ. ಎಂಟ್ರಿ ಮಾಡೋರು ಇಂಥದ್ದೇನರ ಇದ್ರಷ್ಟೇ ಇರಿ. ಅದರ್ವೈಸ್ ವಿ ವಿಲ್ ನಾಟ್ ಟೇಕ್ ಅಪ್ ದೋಸ್ ಮ್ಯಾಟರ್ಸ್. ಎಸ್.
Orders matters, my lords.
Ah.
Serial number 3, my lords. Copy
Three.
has been, copy has
yeah.
been served, my lords. If any date may be given, I'm only seeking for a remand, my lords, because
ಅದೇನೋ ರೆಕ್ಟಿಫಿಕೇಶನ್ ಆಫ್ ಆಬ್ಜೆಕ್ಷನ್ ಇದೆಯಲ್ಲಪ್ಪ.
that, my lords, the copy has been served to the other side, my lords.
Serial number 2.
ಲಿಸ್ಟ್ ನಂಬರ್ 2. ಆಲ್ ಮಾಡ್ಬೋದಲ್ಲ? 2 weeks ಸಂಗಮೇಶ್?
My lords, may kindly, I have already served the copy, my lords. Any date, my lords, so that can be, I'm only seeking for remand. The single judge, my lords, I was not a party. And RTCs were in my name. I'm only seeking reconsideration so that it can be,
ಶಿವದೇವ್
my lords.
ಸೇಸಿಂಗ್ ಸ್ಟೆಪ್ಸ್
Steps have been paid and the
2 weeks.
counsel who appeared there have been served, my lords. Your lords, may
ಯಾರು
kindly-
ಸರ್ವಾಗಿದೆ? ಏನೋ ಸ್ಟೆಪ್ಸ್ ಅಂತ ಬಂದಿದೆಯಲ್ಲ?
Steps, counsel who appeared in before the learned single judge, my lords, he has been served, my lords. I was also permitted
ಅವ್ರ
to
ಹೆಸರು
serve.
ತೋರಿಸಿಲ್ಲ
Our Hesru,
ಅದು ಯಾರಿಗೆ?
Sheshgiri Rao, Sheshgiri Rao, my lords,
ಮಿಸ್ಟರ್ ಶೇಷಗಿರಿ ರಾವ್
has been served,
is said to have been served with the court notice
who appeared before the learned.
since he had appeared in the writ petition before the learned single judge. First of registry to show his name as appearing for
My lords, respondent number 5 to 18, my lords.
5
R 195
ಮತ್ತೆ
to 18.
1 to 5 ಗೌರ್ಮೆಂಟ್ ಇದೆ.
5 to 18, my lords.
5 to 18.
5 to 18.
5 to 18. Steps in respect of R1 ಯಾರು? R1 ಯಾರು?
R1 is state, my lords.
State.
ಹೌದು.
Learned DG is requested to accept notice for respondent number 1. ಕಾಪಿ ಕೊಡಿ ಅವರಿಗೆಲ್ಲ.
I will,
Call after 2 weeks.
any date, my lords.
weeks,
I'm only
but
seeking for
not-
a remand, my lords.
Pandit Saab will come to my chamber asking why have you fixed date?
Serial number 4, my lord. In the
4.
same list, serial number 4.
Huh.
Venkatesh Arbut is named to be shown.
ಎಲ್ಲಿ?
It's serial number R6 ಗೆ
Ah.
Venkatesh Arbut is name should be.
Learned panel counsel Sri Venkatesh Arbatti to appear for respondent number 6.
Look,
Call after 3 weeks?
it's 2 weeks. now.
2 weeks. 2 weeks. Petitioner to serve copy of the petition.
But sir,
On the- ಆಗಿದೆಯಾ? All right. Next.
great.
Serial number 5, your lordship, please.
5.
I appear for appellant.
Ah.
Anytime after like 10th November or
Application
10th November.
after 3 weeks.
Lord, serial number
On
36,
request. 1-3.
serial number 36 in first list, my lord. 36. That's it for respondent number 2. Or need to file
36.
objection in this, my lord. I'll inform the petitioner counsel, my lord. Kindly take it.
You are for respondent.
Please, respondent number 2. my lord.
ಮತ್ತೇನೋ ಡೇಟ್ ಏನೋ ಕೊಟ್ಟಿದ್ದೇವೆ. ಇರಿ ಅವ್ರು ಬರಲಿ. ಅವ್ರು
Please,
ಬಂದಾಗ ಕೊಡಿ.
please, please.
Yes, brother. ಎಲ್ಲಿ ಧನಂಜಯ್? ಏನ್ ಮಾಡ್ಬೇಕು? Notice, service of notice on R3 is held sufficient in view of postal Sharana. In view of, in view of postal Shira, which says about confirmation of delivery. Yes. Steps to be taken in respect of R4 and also deceased respondent number 5. Non-filing of necessary application and deceased of or 9-6 ಅನ್ನೋದಿಲ್ಲ. Or 5 and other deceased respondents. 6-9 ಇಲ್ಲ ಇದೆ. Production of death certificate in non-furnishing of memo death. The requirement of producing death certificate is dispensed with. Date of death ಬೇಕಾಗ್ತದೆ for counting limitation. Dispensed with if date of death is authoritatively furnished. Okay. ಅವ್ರಿಗೆ ಡೆತ್ ಸರ್ಟಿಫಿಕೇಟ್ ತಗೊಂಡು ಎಲ್ಲಿಂದ ತಗೊಂಡ್ಬರ್ಬೇಕು? ಅದು ನಾಟ್ ದಟ್ ಸಿಂಪಲ್. ಎಸ್ 16 ಅನಿಗ್ಜರ್ಸನ್ ಕಾಂಪ್ಲಿಮೆಂಟ್ ಮಾಡೋಕ್ಕಾಗಲ್ಲ. ಕಾಲ್ ಆಫ್ಟರ್ all synopsis and written arguments are accepted or taken on records.
In this, my lords, I have to file my synopsis, my lords, R1 and 2. A week's time may kindly be granted.
Respondents to file their synopsis and written arguments
Obliged.
within 10 days.
Obliged.
Call after 3 weeks. Okay. Next.
Copy is served, my lord. That is the only objection.
By the-
received the
Office objection is complied with. Yes.
Next week date.
Yeah.
Date may be fixed, but matter pertains to equivalence of qualification.
Selection of
Third week of January.
January.
Huh?
Selection.
Third week of January. ಯಾವತ್ತಿದೆ election?
ಅಲ್ಲ ಸಿಲೆಕ್ಷನ್
Selection. No difference.
Interim order.
Interim order to continue. Great.
Appear for the petition. I have received the copy, my lord. Kindly after festival, my lord. Next week, my lord.
Office objection comply ಆಗಿದೆಯಾ?
Tag in.
Office objection complied with.
I will file the synopsis and written
All
submission
after
next
2
week.
weeks
Please,
at the request of Nityananda.
my job.
Yes.
Lords, I appear for the petitioner.
Ah.
Service insofar as second respondent, my lords, is awaited.
ಕೋರ್ನಲ್ಲಿ. ಅದು ಅರಬಟ್ಟಿ ಅದರಲ್ಲಿ ತೊಳಿಕಾಟು. ಅದೇ
Court.
ಅದ್ರೆ ಅಲ್ವಾ? I3 for production of
Additional lords.
awaiting service. Await ಆಗ್ಲಿ ನೋಡೋಣ ಅವ್ರು ಕೇಳ್ಕೊಂಡು.
Yes, yes.
Await service.
Interim order may kindly be.
Interim order to continue
Obliged.
till next date of hearing.
Obliged.
Translation dispensary. Huh? Translation copy. ಏನ್ ಬೇಡ ಫೈಲ್ ಆಗಿದೆ. ಅಲ್ಲಿ ನೋಡಮ್ಮ ಆಫೀಸ್ ಅಬ್ಜೆಕ್ಷನ್ ಕಂಪ್ಲೈಡ್ ವಿತ್ ಅಂತ ಹೇಳಿ.
I am requesting for consideration of interim prayer.
ಹಾ.
Lord, matter is under the Land Grabbing Act. Lord, we raised a contention that this is not government land. My Lord, report was called for from the
Revenue
Tahsildar.
department.
Yes, my Lord.
Ah.
Without looking into the report says, my Lord, that it is private land. It is granted way back in the year 1962.
ಎಲ್ಲಿದೆ?
My Lord, please see, my Lord, annexure L, my Lord.
112.
Yes, my Lord, annexure M, page 89. Annexure M, page 89.
Sir, L is at page 112.
Sorry, my Lord. Annexure M, page 89. M, yes.
N.
M for myself.
You can say money.
M for myself. Annexure M, my lord, is a report given specifically at the instance of the special court itself, page 89, my lord, 89. 89, annexure M.
ಇಲ್ಲ ಬೇರೆ ಬೇರೆ ಏನೋ page, we are not on same page.
Lord, WP 7830 of 2024.
Correct. Is 89, huh?
Yes, my lord.
89 is government order, court order.
Court order, my lord. After that, my lord, there is a report given by the Tahsildar.
Torsi.
Sorry,
Whether Tahsildar says it's not a government land,
not a government.
show
land.
that, let us see.
Respond
Is it
number
true?
three, sir. Copy serve ಮಾಡಿಲ್ಲ ಅವ್ನು copy.
ಅವ್ರಿಗೆ ಒಂದು ಕಾಪಿ ಕೊಡ್ಬೇಕಲ್ಲ.
Copy serve ಮಾಡಿದ್ದಾರೆ.
ಇರ್ಲಿ ಇನ್ನೊಂದು ಕಾಪಿ ಕೊಡಿ.
ಅವ್ರು ಕೊಟ್ಟಿರೋದು.
ಗೌರ್ಮೆಂಟ್ ಕೊಟ್ಟಿಲ್ಲ.
ಕೊಡಿ ಇನ್ನೊಂದು ಕಾಪಿ ಕೊಡಿ. ಈ ಎರಡನೇ ಸರಿ ಕಾಫಿ ಕುಡಿಯಕ್ ಹೋದ್ರೆ ಶಾಪ್ನವನು ಇಲ್ಲ ಕುಡಿದು ಹೋಗಿರಿ ಬರೋದು ಕೊಡಲ್ಲ ಅಂತ ಹೇಳ್ತಾನೆ. ಪೇಜ್ 124 ಅಂತ ನೋಡಿ. ನಿಮ್ ಪೇಪರ್ಸ್ ನಿಮ್ಗೆ ಸಿಗ್ತಾ ಇಲ್ಲ, ನಾವು ಹುಡ್ಕೋದು ಹೆಂಗಪ್ಪ?
Page number 120.
124 ಅಂತ ಏನೋ ಹೇಳಿದ್ರು ಬ್ರದರ್. Is it true? 124 ನಲ್ಲಿ have you said, your officer said it is not a government land?
Page number 120, my lord. Specifically, a report was called for.
ಯಾವ ಪ್ಯಾರಾಗ್ರಾಫ್?
My lord, please see. My lord, right from para number 2, they speak about, my lord, the grant.
ಆ ಲೈನ್ ತೋರಿಸಿ ನಂಗೆ.
My lord, the second paragraph. ಪಟ್ಟಂದೂರ್ ಅಗ್ರಹಾಲ ಗ್ರಾಮದ ಮೂಲ ಜೋಡಿ ಇನಾಮ್ ಗ್ರಾಮ ಆಗಿದ್ದು ಮೇಲ್ಕಂಡ ಸರ್ವೆ ನಂಬರ್ 108/4
ಕಡತದ ಸಂಖ್ಯೆ ಹಾಲಿ ಗಣಕರು ಸದರಿ ದುರಸ್ತಿಯಾಗಿ ಎಷ್ಟು ದಿನ ಇದ್ದು
has been granted and ಅಂತ ಹೇಳಿ.
Yes, brother. If it is a granted land, it ceases to be a government land because of Mudukappa's case. Anyway, see this, it's your own record.
And order is
produced-
passed without reference to this.
ಇದರಲ್ಲಿ
It is your the concerned Tahsildar's order. He says it was a Jodi Inam and Inamdar is registered. Then once registration takes place, Mudukappa says it ceases to be a government land. Like occupancy and section 48, capital A of Land Reforms Act. Then why do you trouble him? How many cases are coming before us, identical matters? Every day, why they are coming here? Huh? Hmm.
62, there's a grant, my lord, next page itself. 62, it has been
3
granted.
to 62.
Yes, my lord.
The
3 to
special deputy
1962.
commissioner.
Yes, my lord. Has,
Commissioner order ಇದೆ, grant ಇದೆ.
grant agirada, there is a reference to that. And my lord, land is converted.
ಇದೇನು P&M, personal and miscellaneous.
Personal miscellaneous, inam abolition.
Learned counsel appearing for the petition. ಇದೇನು ಇದು
Submission,
ಬಂದಿದೆ?
sir. Yes, one submission, sir. ಇದು ಗ್ರಾಂಟ್ ಆಗಿಲ್ಲ ಸರ್ ನಮ್ ಸ್ಟೇಟ್ಮೆಂಟ್ ಅಲ್ಲಿ
ಹಾ.
ಪೇಜ್ ನಂಬರ್ 84 ತಹಸೀಲ್ದಾರ್ ಇಶ್ಯೂ ಮಾಡಿದ್ದಾರೆ ಸರ್ ಗ್ರಾಂಟ್ ಆಗಿಲ್ಲ ಅಂತ ಬಿಟ್ಟು ಇಶ್ಯೂ ಮಾಡಿದ್ದಾರೆ.
Have you said that this order is a forged document in your objection?
ಎಸ್ ನಾವು ಅಬ್ಜೆಕ್ಷನ್ ಹಾಕಿದ್ದೀನಿ ಸರ್.
ಎಲ್ಲಿ? Read. Read. Where have you stated about this?
ಪ್ಲೀಸ್ ಸರ್ ಪೇಜ್ ನಂಬರ್ 14 ಸ್ವಾಮಿ ಇಶ್ಯೂಡ್ ಬೈ ದ ಪಾರ ನಂಬರ್ 8 ಅದರಲ್ಲಿ.
No, you have to take up contention na?
ಎಸ್
On this annexure, which he has produced is a forged document. That is not their case.
In fact, it is
Correct.
give
Admit ಆಗಿದೇನಿಲ್ಲ.
again.
Learned counsel appearing for the petitioner, drawing attention of the court to Tahsildar's order dated 28/11/2023. A
Report.
copy whereof is produced at annexure M submits that the subject land is granted by the special deputy commissioner under the provisions of P&M.
Section.
Karnataka P&M is the prohibition, Norms Abolition Act,
Norms Abolition.
1954. 1954. Full stop. The Tahsildar has mentioned about the same in the said order at paragraph number 2. Full stop. Thus, a prima facie case is made out for issuance for grant of reprieve. Full stop. Next, in the above circumstances, interim order as prayed for is granted.
Obliged, my lord. Deeply obliged.
Brother, why all such matters are coming before us? You have taken up that contention. That's not the true letter. Then, Nodama, till next date of hearing, call this matter after 2 weeks. It is open to the other side to show the spurious, alleged spuriousness of the Tahsildar's order. In which event, not only the interim order would be discontinued, but petition itself will be dismissed.
It is a report, my lord, given to
We
the
do not know.
special.
ಅದು
land
ಸುಳ್ಳಿತ್ತು
grabbing
ಅಂದ್ರೆ
court.
ನಾವು petition
Yes.
dismiss ಮಾಡಿ. Next. ಅಂತವ್ರ forged document ತಗೊಂಡು interim order ತಗೊಂಡು ಹೋದ್ರೆ ಹಂಗ ಬಿಡ್ಲಿಕ್ಕೆ ಬರಲ್ಲ. Anyway, subject to that.
Yes, my
we'll
lord. It is a
decide.
report, my lord, given to the special court. ಅಲ್ಲಿಂದ ನಾವು ಸರ್ಟಿಫೈಡ್ ಕಾಪಿ ತಗೊಂಡಿದೀವಿ. It is a report given to the special court, not even to me.
ಅಲ್ಲೇ ಫ್ಯಾಬ್ರಿಕೇಟ್ ಮಾಡಿ ಒಂದು ಕಾಪಿ ಇಟ್ಬಿಟ್ಟಿದ್ರೆ ಗೊತ್ತಾಗಲ್ಲ ನಮ್ಗೆ ಏನೇನಾಗ್ತದೆ ಅಂತ.
ಅಲ್ಲ, it is a registrar has called for a report. In pursuance of that, a report is given directly to the special court.
At least special court should have considered
Yes,
that
that is,
aspect of the.
that is also not
Let us,
considered.
let us. Yes.
Here for the petitioner.
Yes, Satish.
Lord, the matter one in this. File my statement of objections.
ಎಷ್ಟು ಕೋಲ್ಡ್ ಮಾಡಿದ್ರಿ ತುಂಬಾ ಕೋಲ್ಡ್ ಆಗಿದೆ ಸ್ವಲ್ಪ ಎಸ್ ಬ್ರದರ್.
Lord, matter pertaining to my lord, disciplinary proceedings initiated against the petitioner. Lord, the petitioner was working as my lord, inspector of legal metrology.
ಏನ್ ಅರ್ಜೆನ್ಸಿ ಇದೆ
Urgency ಏನಿಲ್ಲ ಸರಿ.
ಕಾಲ್ ಆಫ್ಟರ್ ಕಾಲ್ ಇನ್ ದಿ ಸೆಕೆಂಡ್ ವೀಕ್ ಆಫ್ ಜನವರಿ. ನೆಕ್ಸ್ಟ್
Interim order
ಎಂಟ್ರಿ ಮಾಡ್ ಟು ಕಂಟಿನ್ಯೂ ಇದೆಯಾ?
ಇದೆ.
Interim order if obtaining is continued.
I may be
Okay.
permitted to comply with the office objections.
ಏನು SO ಮೇಲ
Statement.
Lord, I have
Meanwhile-
received, I have received my lord.
you have received office objection is come. Swearing ಆಗಿಲ್ವಾ?
File my,
In the meanwhile, office objections to be complied with by the answering respondent.
please, obliged.
Yes.
Please.
Yesterday's mood matter, my lords, I was.
That Shivdev it was.
Yes, my lord, and I have, my lords, the other additions also. My lords, I was required to, my lords, implead the other, the petitioners.
Yes.
If I'm permitted, I'll file the amended cost title. And about, my lord, the decisions, my lords, on which I'm placing reliance upon. My lords,
You were not party. Tribunal rejected,
Yes, ma'am.
High Court granted,
Yes.
where
However,
you were not a party,
where I was not a party, but though issue was in respect of English subject,
but not Hindi.
not in the entire notification is struck down. Not that the
Learned counsel appearing for the petitioners has filed the amended cause title
Yes.
by arraying the parties, persons who were parties to the writ petition,
petitioners before the petition.
who were petitioners in the subject writ petition.
Please.
First off, he submits that the list related to English teachers,
Yes.
English teachers, whereas there being no warrant, comma, an adverse order for the Hindi teachers has been passed. That too behind the back of the petitioners herein. First, the apex court in Shivdev Singh versus so and so has observed that where persons were not parties to the order passed in the writ jurisdiction, comma, can seek review thereof by filing separate writ petition. First, next part. In view of the above, a prima facie case is made out for issuance of notice and grant of reprieve to the petitioners who claim to be Hindi teachers.
Please.
First, next paragraph. In view of the above, interim order as sought for, ಏನಂತ ಕೇಳಿರಿ interim order?
My lords, to stay, my lord, the orders issued wherein we are asked to, my lords, are asked to be reverted back.
In view of the above, reversion of petitioners and other Hindi teachers,
Please.
who are not parties before this court, is stayed till next date of hearing.
Published.
Okay.
I'll take notice on the private respondents.
Private response. So,
Government advocates, government advocate
and
took
AG is
notice.
requested to accept notice for
My lords, 1 to 5.
1 to 5, huh?
1 to 5. My lords, those who are implicated, my lords, I'll take.
You have to
notice.
take notice. to-
Please.
Yes. It's maintainable, said we it's maintainable.
Please.
Shivdev Singh, Norma, AR 1963 and 64 Supreme Court.
My lords, 63, my lords, 1909. My lords, I have other decisions also, my lords, which are.
One padi sak.
Please.
Article 141 says, law declared by the Supreme Court. It does not say law repeatedly declared by the Supreme Court.
My lords, it was considered and one more ground is added, my lords, subsequently.
Ah.
Equity is also one of the ground.
Yes. ಅದೆರಡು ಹಾಕಮ್ಮ ಶಿವದೇವ್ ಸಿಂಗು ಮತ್ತು ಲೇಟೆಸ್ಟ್ ಆದ ಇನ್ನೊಂದು ಜಡ್ಜ್ಮೆಂಟ್.
More decision ಕೊಟ್ಟು.
ಆಲ್
Please.
Disciplinary benefit, your lord.
ಹಾ
You have sought for VR, your lordship. At
Huh?
the time of, you have sought for the VR, your lordship.
ವಿ ಆರ್ ಎ
We are voluntary retirement.
ಹಾ
That rules were not available to him. 1970 has abandoned the
ಸರ್ವಿಸ್
employment.
Ah.
Thereafter, in 2020, after 25 years, he files an application, lordship representation to consider replacement. That is not entitled to lordship.
ಹಿಯರಿಂಗ್ ಬೇಕಾಗ್ತದೆ
ಬೇಕಾಗಿ.
ಹಿಯರಿಂಗ್ ಬೇಕಾಗ್ತದೆ.
Understanding was that to hear, as he is
Not-
88 years,
In the last week of January 2024, interim order to continue.
could I request little early?
ಎಲ್ಲಿ ಸಾಧ್ಯವಿಲ್ಲ ರಿಮಟ್
ಅಲ್ಲಿ 88 years, he is on the.
ಎಷ್ಟು ವರ್ಷ 89 ಆಗ್ತಾರ ಅವರು ಜನವರಿಯಲ್ಲಿ
Would it be little early?
ಜನವರಿಯಲ್ಲಿ
Well, this-
25 ಇಯರ್ಸ್ ಆದ್ಮೇಲೆ ಎಲ್ಲ ಕೇಳಿ ನೆಕ್ಸ್ಟ್ ಎಸ್ ಯಶೋ
For respondent number 2, my lord.
ಹಾ ಏನಿದೆ ಎಲ್ಲಿದ್ದಾರೆ ಕೇಶವಮೂರ್ತಿ
The
Notice ಏನೋ
petition
ಕೊಟ್ಟಂಗಿದೆ.
itself is not maintainable, my lords.
ಕರೆಕ್ಟ್ ಬಟ್ ಅವ್ರು ಬೇಕಲ್ಲ ಮೇಂಟೈನೇಬಲ್ ಅಂತ ಹೇಳಿಕ್ ನಾವು
The
ಆ
earlier two,
ಇಶ್ಯೂ
three
ಅಡ್ರೆಸ್
occasions-
ಮಾಡ್ಲಿಕ್ಕೆ ಹಿ ಹ್ಯಾಸ್ ಟು ಬಿ ಹಿಯರ್ ನಾ ಕಾಲ್ ಆಫ್ಟರ್ 2 weeks. ಯಾಕೆ ನಾಟ್ ಮೇಂಟೈನೇಬಲ್ ಅಂತೀರಾ ಆ ಡೇಟ್ ಆಗೋಗಿದೆ ಅಂತ
Earlier 3 to 4 occasions it has come. before.
ಇನ್ಫೆಕ್ಚುಯಸ್ ಆಗಿದೆ
Infructuous, because they are claiming the amount to be paid to the DR 80, my lord. The amount which has been deposited before the district court,
They want that amount to be paid to the DR80. 1480 again, it was adjourned, my lords. They took time. Adjourned.
So
Thereafter, again on 22nd of October.
But as on today, it is pending.
Please, me.
Early, no, no. Call after 2 weeks
Please.
to enable counsel for the petitioner to come and argue. Huh? Yes.
My lords, additional document was placed on record to show that, my lord, in spite
Yeah.
of the interim
Not-
order.
Not before. Not before us, not before me. Or they have to keep out, not.
The interim order,
Interim order continue, Mark.
Please.
Interim order to continue till next date of hearing, call after 2 weeks. Next.
So petitioner's questioning, and actually A, L, and N. A is the case at order for
What?
2022. The genesis.
Yeah, awaiting service is there. 1 and 2. Vaishali.
Is that's that's a government. In the meanwhile,
One
they've
and two
issued a
document,
termination order they've issued, Your Lordship. Your Lordship may kindly see the genesis of the case goes back to the year 2001, when backlog vacancy rules were promulgated. Overlooking that, contract.
Hearing ಮಾಡಬೇಕಾಗ್ತದೆ.
Please, Your Lordship, but in the
Sorry.
meanwhile, they may not
ಈಗ.
terminate.
Present AG is requested to accept notice for respondents,
1 and
1 and 2. 3 ಯಾರು KPSC ಯಾರು?
KPSC have served the standing council, Your Lordship.
ಯಾರು ಸ್ಟ್ಯಾಂಡಿಂಗ್ ಕೌನ್ಸಿಲ್ ಯಾರಿದ್ದಾರೆ KPSC ಗೆ?
Your Lordship, I filed a memo to that effect.
So and so.
Yes,
Panel
Sinchana, Sinchana,
Sinchana. Shri.
I've served her.
Sinchama.
I filed a memo.
Panel council is requested to accept notice for third respondent KPSC. 4 to 12,
They are private respondents, Your Lordship.
ಅವ್ರಿಗೆ ನೋಟಿಸ್ ಹೋಗಕ್ಕಾಗತ್ತ?
Yes,
Issue emergent notice to rest of the respondents.
Your Lordship, Your Lordship, stay of annexure, any proceedings pursuant to L and N.
You had a benefit of interim order in
No,
the.
it has come up only once. No, I had no issue. I'm working.
Huh?
I was appointed pursuant to a recruitment notification issued pursuant to the directions of the Apex Court. From 2016, I've been working. Now 2024, there's
No, but the order impugned is January 22.
22, but they have not acted upon it till, no, may I?
Service ಆದ್ಮೇಲೆ ಬರ್ಲಿ.
No, no, Your Lordship may kindly see.
More than 2.5 years.
No,
ago,
that
but
doesn't matter.
Why?
What has happened, we were not even informed. And we were given, they have sent my name, Your Lordship, for promotion. They've given me time round thing. I'm there in the seniority list. Now suddenly in June 2016, 24, they've said that they're going to take action because they cannot include me in the supernumerary list. And they're going to take steps to terminate me. But after working, and at the age of 58, if they're going to terminate me,
I will call this matter next week.
please,
Next week ನೋಡ್ಕೊಂಡು ಹೇಳ್ಬೇಕು.
Please, ma'am.
All right.
in the meanwhile, let them not take any action, please, Your Lordship.
Next. Impleading application supported by affidavit is allowed.
Good morning, sir.
Petitioner is permitted to array the persons named in the application. Yes. ಆಗಿದೆಯಾ? ಇಷ್ಟಿರ್ಲಿ. Yes, sir. Yes, sir.
So I'm conscious that the matter has been posted for dispensation.
Dispensation will do
Near
that.
the urgency, my lord, I'm requesting because. this is-
Dispensation of producing these things is granted, but dispensation of justice, it takes time in this.
On the Kannada record. Yes. So that the-
Translation dispensed.
In near the urgency, my lord, I'm requesting your lordship to kindly. The order, my lord, is at page number 17, annexure A, my lord. The tribunal that has declined to grant the interim order merely on the ipse dixi of the other side, though have not been relieved as a matter of fact. Annexure 18, my lord, is the order which is challenged before the tribunal. Page number 49, 47, my lord. The appellant and 4 others, my lord, lodged a complaint against the principal of the college that students, my lord, were being engaged for evaluation of papers, the answer papers. On that complaint, my lord, action has been taken against the principal, that is found at page 45. I cannot find fault with it. In fact, it was my complaint. Kindly see page 45 for a moment, my lord. ವಿಷಯ ಈ ಸಂಸ್ಥೆಗೆ ಸಂಬಂಧಿಸಿದಂತೆ ಬೆಂಗಳೂರು ವೈದ್ಯಕೀಯ ಮಹಾವಿದ್ಯಾಲಯ ಮತ್ತು ಸಂಶೋಧನಾ ಸಂಸ್ಥೆಯ ಅಧೀನದ ಸರ್ಕಾರಿ ಶುಶ್ರೂಷಾ ಮಹಾವಿದ್ಯಾಲಯ
ಸಮಿತಿ ಏನ್ ಹೇಳ್ತಾರೆ?
ಸದರಿ ಸಮಿತಿಯವರು ಡಾಕ್ಟರ್ ಜಯಲಕ್ಷ್ಮಿ ಎನ್ ಇವರ ಮೇಲಿನ ದೂರಿನ ಕುರಿತು ವಿಚಾರಣೆ ನಡೆಸಿ ಪ್ರಿನ್ಸಿಪಾಲ್ರಿಂದ ಆಗಿರುವ ತಪ್ಪುಗಳು ಮತ್ತೆ ಮರುಕಳಿಸಲು ನೋಡಿಕೊಳ್ಳಲು ಸಂಸ್ಥೆಯ ಗೌರವಕ್ಕೆ ತಕ್ಕ ನೋಡಿಕೊಳ್ಳಲು ಎಚ್ಚರಿಕೆ ನೀಡಬಹುದಾಗಿದೆ ಎಂಬುದು ಸಮಿತಿಯ ವಿಚಾರಣೆ ವರದಿಯಲ್ಲಿ ಸೇರಿಸುತ್ತಾರೆ. An inquiry committee was constituted. They found her guilty. And this is the decision taken. That I'm not agreed by that. But complainant herself being
ಎಚ್ಚರಿಕೆ ಅಂದ್ರೆ ವಾರ್ನಿಂಗ್.
Yes, warning was given to her against the principal against whom 5 of us had complained. But annexure 8 and is the complainant herself is being sent out after 12 years and 4 months of service.
On that ground?
On that ground only, because your lordship may kindly see, it's on a complaint. ಮೇಲ್ಕಂಡ ವಿಷಯಕ್ಕೆ ಸಂಬಂಧಿಸಿದಂತೆ ಡಾಕ್ಟರ್ ಲಕ್ಷ್ಮಿ ಪ್ರಿನ್ಸಿಪಾಲ್ಸ್ ಮಹಾದೇವರು ತಮ್ಮ ಅಧಿಕಾರವನ್ನು ದುರುಪಯೋಗ ಪಡಿಸುತ್ತ ಮತ್ತು ದೂರಾಚಾರದ ಬಗ್ಗೆ ಸ್ವೀಕೃತವಾದ ದೂರುಗಳ ಬಗ್ಗೆ ವಿಚಾರಣೆ ನಡೆಸಿದ್ದು ವಿಚಾರಣಾ ಸಮಿತಿ ರಚಿಸಿ ಸಮಿತಿಯು ಸದರಿ ನೀಡುವ ವಿಚಾರಣಾ ವರದಿಯನ್ನು ಪರಿಶೀಲಿಸಿ ಈ ಕೆಳಕಂಡ ಮಾಹಿತಿ ಮತ್ತು ಪ್ರಸ್ತಾವವನ್ನು ಸಲ್ಲಿಸಲಾಗಿದೆ. ಪ್ರಾಂಶುಪಾಲನಿದ್ದ ಉತ್ತರ ಪತ್ರಿಕೆಗಳನ್ನು ವಿದ್ಯಾರ್ಥಿಗಳು ಮೌಲ್ಯಮಾಪನ ಮಾಡುತ್ತಿರುವಾಗ ಸದರಿ ಉತ್ತರ ಪತ್ರಿಕೆಗಳನ್ನು ಪ್ರೊಫೆಸರ್ ಮಮತಾ, ದಟ್ ಈಸ್ ಮೀ, ಸರಸ್ವತಿ ಸೋಯನ್ಸೋ ಉಪನ್ಯಾಸ ಕಸಿದುಕೊಂಡು ಇಟ್ಟುಕೊಂಡಿದ್ದು ಕೂಡಲೇ ಮೇಲ್ಕ ಗಮನಕ್ಕೆ ತರದೆ ಒಂದು ನಿರ್ದೇಶಕ ಕೇಳಿದ ನಂತರ ನೀಡುವುದು ತಪ್ಪಾಗಿರುತ್ತದೆ.
ನೋಡ್ಕೊಂಡು ಹೇಳಿ, ನೆಕ್ಸ್ಟ್ ವೀಕ್ ಮಾಡಿ ಪ್ಲೀಸ್. AGA requested to accept notice for first respondent. ಮೆಡಿಕಲ್ ಕಾಲೇಜಿಗೆ ಯಾರಿದ್ದಾರೆ? BMC ಗೆ
ಮಾಲಿ ಪಾಟೀಲ್.
Sri Mali Patil, learned panel counsel, is requested to accept notice for second respondent. Petitioner to serve copies of the petition along with all the documents on the learned AGA and on the panel council. Call this matter next week. Yes. All right.
I appear for the petition.
Yes, sir.
Not the appear for the cavator.
Yes, sir.
Question, my lord, before your lordship says.
Ah.
This is regarding the post to the additional drugs control. Additional drugs controller.
Okay.
Promotion to the post of additional drugs controller from the post of the deputy drugs controller. My lord, 4 years. The ACRs written by an unauthorized, an officer who is not authorized under the rules. At one go, my lord, the 4 years ACR has been written. Excellent has been given. So far as mine is concerned, the good, so far as the first year is concerned, the competent authority, page 201, if your lordship kindly take.
Read
201. Rules contemplates additional drugs controller.
ಒಂದು ಡೇಟ್ ಫಿಕ್ಸ್ ಮಾಡೋಣ, ಮಾಡ್ಕೊಂಡು ಮುಗಿಸ್ಬೋಣ ಅಂತ. ಹಿಯರಿಂಗ್ ಬೇಕಾಗ್ತದೆ.
Blood, only short question is uncommunicated records
Can be
have
liquidated
been
or not.
treated as a basis to deny my promotion. And K80 says, since the DPC has already considered once and rejected your case, therefore your right is barred. That is, my lord, incorrect. That is how the matter went to the.
Every time when that right arises, they have to consider.
No, it should be communicated to me. My
not
time
communicated
to,
to you.
no, it was not
What the
communicated.
tribunal said on that contention?
My lord, they say that it was earlier promotion has been given to me and I did not challenge it. It was not, promotion is different from the ACRs which are not communicated to me under Rule 9. And in earlier proceedings, the liberty has been granted. Page 137, my lords. Para 55, page 136, the third interlocutory application, the third respondent has failed to reject the reply of the state, simply stated that the state in its entire reply has contended DP has assessed the candidates in accordance with the rules, order, circular procedure. We have already held that the third respondent are not at all at any stage has challenged the evaluation made by the DP. Hence, the challenge to the reply of the state by the third respondent is not at all tenable in these proceedings, since there is no challenge by way of formal application by the third respondent in any independent proceeding before this tribunal as an original applicant. The third respondent has thus no local standard to oppose the reply of the state by the state, and the second respondent in these proceedings were at liberty to present their case with regard to the amendments made in the main application if the third respondent is pleased thereby. It is for him to challenge the DPC proceeding. As a respondent, my lord, I contended that these CRs, ACRs were not communicated. Liberty has been granted. Of course, my promotion has been set aside. Matter has been remitted to the political head to reconsider the case. Now we moved an application only on the ground under Rule 9 of the performance rules are not been communicated. That can't be the basis. 201, my lord, if your lordship is 4 years ACR written at one stretch by a person based on a government order who is not empowered to write the.
Where is that contention treated? The one which you have read now does not much relate to that contention.
No, this is.
Where is that contention treated?
Now, my lord, the tribunal says that once the DPC is considered, I am not challenging that.
Statement of objections, where you, this stand you have taken up.
In the petition.
I am the applicant, my lords.
You are the applicant.
Yes.
Where have you
This
taken
is
up
the
that
second
contention?
round confining only to the ACRs.
That's all right. You show that that contention was taken up in your application.
In my application, we have taken.
Where have you taken up?
Page 35.
It's 35.
Yes. 4 years were written at once, one go. Para 6, my lords. The four years 2019, 20, 20, 21, 21, 22, 22, 23, based on the government order of 2023. Rules contemplates every year he has to return. He was not working beyond a year.
Did you have any interim order at the hands of the tribunal?
There was no interim order. Now, my lord, during the pendency, he has been given as a drugs controller. My lord, 4 years at one go, writes a CR as outstanding.
You have taken up that contention.
Yes.
But tribunal, after considering all aspects, has said.
No.
You had no
the
benefit of interim order at all.
No. The tribunal says I have not challenged the DPC proceeding.
No, that's
The
the
first
ground.
prayer is to quash the DPC proceeding.
All right. Did you? pay
And
any
the
interim-
second, one submission.
Allah,
Second
answer-
finding is,
Come to
I'm
it.
sorry, my lord.
You have to answer court's question. Advocate should.
I'm
answer
sorry, I'm sorry.
court's question. Did you pray for any interim relief at the hands of the tribunal?
My lord, we prayed, my lords,
It was
but
not granted.
not granted. The matter is posted for,
You have not prayed.
no, for hearing an application order 7 rule 11 filed by the other side. The matter was heard on order 7 rule 11. Finally, the application disposed of.
Page 51. Sought for interim order.
Very unfortunate thing. And kindly see, my lord, paragraph 14 onwards, the tribunal says, I have not challenged the DPC proceeding.
You have challenged that also.
Yes, my lord, that is my main prayer.
No, Lord.
Your main prayer was for setting aside order of the tribunal dated 16/10/20. This is in the report.
That main prayer is page 50, my lord, if your lordship kindly take.
Five.
Page 50, 50. Declare that the proceedings of the DPC dated 6/3/2024 taking into account the action, the R2 recording the CR contrary to so and so. Now the tribunal says, I have not challenged the DPC proceeding.
Now what has happened?
He's been given additional charge.
Now he has been given an additional charge,
Double
not
charge.
only my lord, additional drugs controller, he is now a drugs controller also.
You were holding the post of?
Deputy drugs controller earlier.
Huh.
I was promoted to the post of additional drugs controller. That came to be set aside. Matter is remitted back to the minister. And the minister, without compliance of the direction of the CAT, passed a single order, placing him as the additional drugs controller.
Yes.
Only two facts.
Yes.
Now, the allegations now made pertain to the writing of the APRs. Now, these APRs were written post-COVID pursuant to a direction given by the government to write the ACRs in respect to the period during COVID period.
But he was not the reporting authority at all.
Sorry?
Person who wrote.
He was the reporting authority. That I will substantiate. There is no problem. That he was the reporting authority. In fact, I have credible information. I am trying to get the copies also. He lobbied for getting the best APRs. He requested the very same authority.
Is it a case before the tribunal? Was it your case before the tribunal that
No,
way?
before the tribunal, that situation did not arise.
Whatever
I could not.
pleadings are there?
No, I'll place it before the court also. Now, what I would respectfully submit is, now notwithstanding, may I request the court to kindly see the DPC proceedings for a minute. Just 1 minute, one page 56. Page 56.
56.
Yes.
Yes.
ದಿನಾಂಕ 8/1/2020 ಉಪ ಔಷಧ ನಿಯಂತ್ರಕರು ವೃಂದದ ದಿನಾಂಕ 1/1/20 ಪ್ರಕಟಿಸಲಾದ ಅಂತಿಮ ಜ್ಯೇಷ್ಠತಾ ಪಟ್ಟಿಯ ಕ್ರಮ ಸಂಖ್ಯೆ 32, 36, 37ರಲ್ಲಿರುವ 3 ಅಭ್ಯರ್ಥಿಗಳ ಸೂಕ್ತತೆಯನ್ನು ಸಮಿತಿಯು ಈ ಕೆಳಕಂಡಂತೆ ಪರಿಶೀಲಿಸಿತು. So it has awarded on the basis of the ACRs. It has whereas I have secured outstanding marks, outstanding grade. He was given Sadharana, ordinary, or Uttama, good. Kindly see the first column. That is that candidate is not before the court. Second candidate, I am the second candidate. In respect of the second candidate, Asadharana, 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 last 4 years. So I was awarded 17 marks. I am admittedly senior to him. There is no issue on that. And he was awarded 10 marks on the basis of the APRs. Now, thereafterwards, only my name is recommended. His name was not even empaneled for consideration. However, the Honorable Health Minister appointed him, ignoring the DPC proceedings, which were unanimous. So I challenged it before the court, before the tribunal. Kindly permit me to show what the tribunal has said at page 93.
He was not a party. He was also party. Yes, yes.
Yes, it was his promotion that was under challenge. Para 59 at page 138 may kindly be perused. Para 59 at page 138.
9. Page
138.
Yes.
We summarize our conclusions as under. The application is partly allowed. The notification dated 2/4/2024 as at annexure A1, appointing the third respondent, that is the petitioner hearing, to the post of additional drugs controller is set aside. Third respondent shall cease to hold the office. Second respondent shall hold charge of the post, etc., etc.
Controller.
Yes. Now kindly, then the subsequent direction may kindly be noticed. As regards the second prayer, I prayed for directly appointing me, but they said that is not being granted. The ends of justice will be served. by directing the appointing authority, namely the Honorable Minister, represented by the first respondent, to consider the DPC recommendations afresh. Take a decision in the matter within 3 months. This was challenged before this Honorable Court. Next page 140 is the judgment in that writ petition.
Challenge was negative.
Yes. The order of the tribunal is upheld. The operative portion is page 152.
Which paragraph you want?
Para 10 at page 147 may kindly be perused for a minute. The appointing authority has noted in the file as follows, quote, the recruitment authority has provided an opportunity to promote the position of their controller by selection from the available deputy controllers as per C&R rules, and the annual performance reports should be considered as part of this selection rather than being the sole criterion. Furthermore, considering the total service rendered in the department by the officers listed at serial number 2 and 3, Nazir Ahmad, that is the petitioner herein, at serial number 3, joined service in 93, while the officer in
So you were senior, you were plenty senior to.
I am senior to him. I have secured 17 marks as against 10 marks secured by him. Nevertheless, he came to be appointed.
Considering.
Can you see next page, last paragraph? Considering this background, as there is an opportunity for Umesh, this is the only reason given, as an opportunity for Umesh to hold higher positions, the recruitment authority has approved the promotion of Nazir Ahmad.
We'll fix a date.
No,
First week of.
I have no objection. All that I am saying is,
My lord, only
now,
one submission.
all the issues have become final.
My lord,
in the
only
earlier
one
proceeding.
submission.
Number one. Number two,
Tab-
he has also preferred an SLP before the Honorable Supreme Court against this order.
ಅಲ್ಲ ಅವ್ರು ಹೇಳೋದು ಇದು ರಿಲೆವೆಂಟ್ ಆಗೋದೇ ಇಲ್ಲ ಅಂತ.
ಅಲ್ಲ, ತಾವು ಹಿಯರ್ ಮಾಡ್ತೀರಿ objection ಇಲ್ಲ. More the merrier. I have
Lord,
no-
both of us, my lord, has been promoted to the post of a deputy drugs controller on the same day. He became a senior because of BK Pavitra's case. He belongs to a reserved community. That is the issue.
No, that,
Now-
that finding
now
is
that is
recorded
not
with
the
coordinate
issue.
bench. He is senior. He is recorded in the coordinate bench.
My lord,
No, that
my lord,
seniority
short
list is
question
there.
would be.
It is not under challenge.
My learned
My
friend
seniority is
has
not under-
claimed highest marks than me. Based on the ACR report, the government order and the rules contemplate only a proper person has to write. Now the drugs controller who comes in 2023 writes 4 years ACR as excellent for him, good for me, not communicated, and this was made available before the tribunal. As a respondent, I could not have challenged. The tribunal said, you challenge it in independent proceeding. We gone to the tribunal saying that ACR which was not communicated, despite the DPC decision, I am entitled to approach before this tribunal based on the Supreme Court judgment. We have also cited Justice Ram Jay's passage. Now, the tribunal says, there is no prayer to challenge the DPC. The tribunal says, I have not given a representation. We have given. The tribunal says, competent authority has written. Rule 12 contemplate no executive order can be issued which is inconsistent with the confidential report. Confidential report says only additional drugs controller has to write the ACR. There is already a GO issued. If the GO is already occupied, where is one more circular to write 4 years? at one go and give him excellent and say that yes, he is eligible. Not at any stage, a civil servant has got a right to correct his record of service if it is not communicated. Till today, it is not communicated. My representations are pending. The competent authority who writes an report complaint to the chief secretary, I have been prevented from writing this. 4 years post is kept vacant.
All right, call tomorrow. We'll read again after hearing the.
I'll file my objections. Court wants to hear, fix a date.
When were you served with the copy of?
But I will not rely on any other thing
When your client
except
was served?
ACR not communicate.
When was he served with copy of the petition?
Monday, day first.
Monday. Call this matter on Monday.
I may
Yes.
be permitted to file my objections.
Yes, in the meanwhile, objections may be permitted, file.
No, a hearing date may be fixed.
Huh?
Monday may not be.
Tuesday.
ಒಂದು hearing date fix ಮಾಡಿ ತಾವು hear ಮಾಡಿ.
Tuesday, Monday, better, Tuesday.
ಅಲ್ಲ,
But already he is being, now you are.
No, see, my promotion is now ordered and that has become final.
He has
That has
been
become-
given
that
ballot
is-
a bonus of additional.
That has become final.
If ACR is
And-
corrected,
And that issue
you
is
won't
pending
even
before
get
the-
additional post.
Professor, we'll give you time to file objections if you want to. And we'll fix a date of your convenience also.
Yes, ಆಗ್ಬೋದು. ಯಾವಾಗ
which-
ಡಿಸೆಂಬರ್ ಮಾಡಿ, ಡಿಸೆಂಬರ್. Next month I have some difficulty in the later part of next month. Because I'll have to secure some records from the government.
My lord,
But
this is
entry
too much,
ಮಾಡ್ಲಿಕ್ಕೆ
my lord. This is,
ಅಷ್ಟು long ಕೊಡ್ಲಿಕ್ಕೆ ಬರಲ್ಲ.
your lordship may grant.
ಡಿಸೆಂಬರ್ ಯಾವಾಗಾರು ಫಿಕ್ಸ್ ಮಾಡಿ.
ಅಲ್ಲ, ಅವ್ರು ಕೇಳೋದು ಎಂಟ್ರಿ ಮಾಡಿ ಕೇಳ್ತಾ ಇದ್ದಾರೆ.
ಎಂಟ್ರಿ ಮಾಡ್ರಿ, ಇದ್ರಲ್ಲಿ ಪ್ರಶ್ನೆನೇ ಬರೋದಿಲ್ಲ.
No,
ಇದ್ರಲ್ಲಿ ಪ್ರಶ್ನೆನೇ ಬರೋದಿಲ್ಲ ಬಿಕಾಸ್ ಐ ಆಮ್ ಪ್ರಮೋಟೆಡ್ ಅಂಡ್ ಐ ಆಮ್ ವರ್ಕಿಂಗ್.
the matter is covered by Gurdial Singh case.
Before the Supreme Court.
That is a different matter, my lord.
It is the same matter, same issue.
No,
I'll
issue is
demonstrate
different.
anyway.
The foundation is ACR.
ಆಯ್ತು, ಡಿಸೆಂಬರ್ ನಲ್ಲಿ ಒಂದು ಡೇಟ್ ತೊಗೊಳ್ರಿ.
ಯಾವ್ದಾದ್ರು
Then
ಡೇಟ್
ಮಾಡಿ
ಫಿಕ್ಸ್
ಮುಗಿಸ್ಕೊಡು.
ಮಾಡಿ.
My lord, it
No
is too long, my lords. I will put to great hardship.
ಯಾವಾಗಿಂದ ನೀವು ಫಂಕ್ಷನ್ ಮಾಡ್ತಾ ಇದ್ದೀರಿ ಪೋಸ್ಟ್ ನಲ್ಲಿ?
ನಾನು 27ರವರೆಗೂ ಸ್ವಲ್ಪ ಪ್ರಾಬ್ಲಮ್ ಇದೆ.
ಅಲ್ಲ, since how long your client is functioning in the post?
2 months. 2 months is been.
2 months.
Functioning is my
2 months.
instruction. Is additional charge may be stated.
2 months.
Additional.
My lord, additional
sir.
charge may be stayed, my lord, if that is the position.
Huh?
Now he is not only promoted to the additional drugs controller, he has been given a further, my lord, drugs controller based on this bonanza.
32.
Yes,
ಅದನ್ನ ಸ್ಟೇ ಮಾಡಿದ್ರೆ ನೀವು ಅಲ್ಲಿ ಉಳ್ಕೊತೀರಿ? ಇಲ್ಲ,
there are other 6 people who are eligible.
ಅವ್ರು ಬಿಡಿ. ಅದು how you are.
Now, your lordship may accommodate him, your lordship may call it at 11th or 12th.
ಅಲ್ಲ,
my lord.
ಅವ್ರಿಗೆ ಏನು
Max.
ಸಮಸ್ಯೆ? Otherwise he will not ask time.
It's not under rule 32.
ಇದೆ ಬರೋ ತಿಂಗಳಲ್ಲಿ.
Sorry.
You said that you have some difficulty.
Yes, yes.
November. Therefore he wants some date. One date fix ಮಾಡ್ಕೊಂಡು ಮಾಡಿ ಮುಗಿಸ್ಬೋಣ.
ಇಲ್ಲ, ಡಿಸೆಂಬರ್ ತುಂಬಾ ಲಾಂಗ್ ಆಯ್ತು. ಅದು ಎನಿ ಡೇಟ್
ಇಡೀ ಹೋಲ್ ನವೆಂಬರ್ ಬಿಸಿ.
ಇಲ್ಲ, ಫಸ್ಟ್ ಪಾರ್ಟ್ ಆಫ್ ನವೆಂಬರ್ ಐ ಆಮ್ ಅವೈಲಬಲ್, ಬಟ್ ಅಬ್ಜೆಕ್ಷನ್ಸ್ ಅಲ್ಲ ಅಬ್ಜೆಕ್ಷನ್ಸ್ ಹಾಕೋದು ಕಷ್ಟ ಆಗುತ್ತೆ. ಅದಕ್ಕೋಸ್ಕರ ಐ ಟು ಗೆಟ್ ದಿ ರೆಕಾರ್ಡ್ಸ್.
ಇಲ್ಲ, ನಾನು ಕ್ವಶನ್ ಆಫ್ ಲಾ ACR ಬಿಟ್ಟು ಬೇರೆ ಏನು ಆರ್ಗ್ಯುಮೆಂಟ್ ಮಾಡಲ್ಲ.
ಅಲ್ಲ, ಅದು ನಿಮ್ ಕ್ವಶನ್ ಆನ್ಸರ್ ಮಾಡ್ಲಿಕ್ಕೆ ಈ ಮಟೀರಿಯಲ್.
ಹೌದೌದು, ಅವ್ರು ACR ಕ್ವಶನ್ ಮಾಡ್ಲಿಕ್ಕೆ ಬರೋದಿಲ್ಲ ಅಂತಲೇನೆ ನನಗೆ ಡಾಕ್ಯುಮೆಂಟ್ಸ್ ಬೇಕಾಗಿದೆ.
ಆಯ್ತು, 12ಕ್ಕೆ ಹಾಕೊಳ್ತೇನೆ. ನೀವು ಇನ್ ದ ಮೀನ್ ವೈಲ್ ಡಾಕ್ಯುಮೆಂಟ್ಸ್ ಯಾವ ಡಾಕ್ಯುಮೆಂಟ್ ಹೇಳಿ ತರಿಸ್ಬಿಡ್ತೇವೆ ಅವ್ರ ಕೈಯಿಂದ, ನಿಮ್ಗೆ ಕೊಡಿಸ್ಬಿಡ್ತೇವೆ. ಹೇಳಿ ವಿಚ್ ಡಾಕ್ಯುಮೆಂಟ್ ಯು ವಾಂಟ್? ವಿಲ್ ಟೆಲ್ ದ ಗವರ್ಮೆಂಟ್ ಟು ಗಿವ್ ಇಟ್ ಇಮಿಡಿಯೇಟ್ಲಿ ಇನ್ ದ ಈವ್ನಿಂಗ್ ಟುಡೇ. ವಿಚ್ ಇಸ್ ದ ಡಾಕ್ಯುಮೆಂಟ್ ವಿಚ್ ಯು
ಅಲ್ಲ, ಇವತ್ತೇ ಕೊಡ್ತೇನೆ.
ಹೇಳಿ.
ಬಟ್ ಅಬ್ಜೆಕ್ಷನ್ ಅಲ್ಲಲ್ಲ, 12 ಆಗಲ್ಲ, 12 ಆಗೋದಿಲ್ಲ. ದಯವಿಟ್ಟು
ನೀವು
ನಾನು
ಅಂದ್ರೆ ನಮಗೆ ಡಾಕ್ಯುಮೆಂಟ್ ಇನ್ ದ ಮೀನ್ ವೈಲ್ ಕೊಡಲ್ಲ ಅವರು. ಹಾಗಾಗಿ ನಂಗೆ ಅಬ್ಜೆಕ್ಷನ್ ಹಾಕ್ಲಿಕ್ಕೆ ಟೈಮ್.
ಅಬ್ಜೆಕ್ಷನ್ ಹಾಕ್ಲಿಕ್ಕೆ ಆಗಲ್ಲ.
ಸಂಜೆ
ನೆಕ್ಸ್ಟ್ ವೀಕ್ ಒಳಗೆ ಅಬ್ಜೆಕ್ಷನ್ ಹಾಕ್ಲಿಕ್ಕೆ ಆಗಲ್ಲ. ಅವರು
ಹೇಳಿ, ಅವತ್ತಿಗೆ ಆರ್ಡರ್
ಕಾಪೀಸ್
ಮಾಡ್ತಿದ್ದಾರೆ.
ಕೊಟ್ಟ ಕೂಡಲೇ ವೀಕ್ ಆಫ್ಟರ್ ನೆಕ್ಸ್ಟ್ ಅಬ್ಜೆಕ್ಷನ್ ಹಾಕ್ತೇನೆ.
ಯಾವ ನಿಮ್ ಡಾಕ್ಯುಮೆಂಟ್ ಕೊಡಿ, ಲಿಸ್ಟ್ ಕೊಡಿ.
ಯಾವಾಗ ತಾವು 27 ನಂತರ
ವಿಚ್ ಡಾಕ್ಯುಮೆಂಟ್ ಯು ನೀಡ್? ವಿಲ್ ಡೈರೆಕ್ಟ್ ದೆಮ್ ಟು ಗಿವ್ ಕಾಪೀಸ್ ಇನ್ ದ ಈವ್ನಿಂಗ್ ಟುಡೇ ಟು ಯುವರ್ ಆಫೀಸ್.
ಅಲ್ಲಿ ಇವತ್ತೇ ಕೊಡ್ತೀನಿ, ಅಪ್ಲಿಕೇಶನ್ ಕೊಡ್ತೀನಿ.
ಅಲ್ಲ, ಯಾವ್ದು ನಮ್ಗೆ ಹೇಳಿದ್ರೆ
ಅಲ್ಲ, ನನಗೆ
ಕಾಲ್ ದಿಸ್ ಮ್ಯಾಟರ್ ಟುಮಾರೋ. ನೀವು ಅಪ್ಲಿಕೇಶನ್ ಕೊಡಿ, ಅದ್ರ ಮೇಲೆ ಆರ್ಡರ್ ಮಾಡ್ತೀನಿ.
ಅಲ್ಲ ಬೇಡ, ತಾವು ಹೇಳಿದ್ರು ಸಾಕು ಅವ್ರಿಗೆ.
ನಿಮ್ಗೆ ಏನು ಅಂತ ನೀವು ಹೇಳಿದ್ರೆ
ನಾನು ಕೊಡ್ತೇನೆ, ಇವತ್ತೇ ಕೊಡ್ತೇನೆ, ಅರ್ಜಿ ಕೊಡ್ತೇನೆ.
ಅಂದ್ರೆ ನೀವು ಏನ್ ಅಪ್ಲಿಕೇಶನ್ ಕೊಡ್ತೀವಿ ಅದು ನಾವು ಅದ್ ನೋಡಿದ್ರೆ
ಅಲ್ಲ ನಾಳೆ ವರ್ಕಿಂಗ್ ಡೇ ಅಲ್ಲ ತಾವು ಇಷ್ಟೊಂದು ಹರಿ
ಇಲ್ಲ
ಮಾಡ್ತೀರಿ
ನನ್ಗೇನಿಲ್ಲ ಹರಿ
ಮತ್ತೆ?
ಹರಿ ಪ್ರಶ್ನೆ ಇಲ್ಲ.
ನಾಳೆ ವರ್ಕಿಂಗ್ ಡೇ ಅಲ್ಲ ತಾವು ನಾಳೆ ತಗೊಳ್ತೀನಿ ಅಂದ್ರೆ ಹೇಗೆ?
ನಾಳೆ ಕೊಡ್ತೇನೆ ಅಂತ ಹೇಳ್ತಾ ಇಲ್ಲ,
ಹಾ.
ನಾಳೆ ನಿಮ್ಗೆ ಅವ್ರು ಕೊಡ್ಲಿಕ್ಕೆ ಹೇಳ್ತೀನಿ ಅಂತ.
ಇಲ್ಲ ನಾಳೆ ಅವರು ವರ್ಕ್ ಮಾಡೋದಿಲ್ಲ.
ಏನಿಲ್ಲ,
ಹಬ್ಬ ಅವರೆಲ್ಲರೂ
ಎನಿ ಪರ್ಸನಲ್
ಅವರೆಲ್ಲ ಹಬ್ಬ ನಾಳೆಯಿಂದ ಅವರು ಯಾರು ವರ್ಕ್ ಮಾಡೋದಿಲ್ಲ. ನಾನು ಅದಕ್ಕೋಸ್ಕರ ನಾನು ಹೇಳಿದ್ದು ನೆಕ್ಸ್ಟ್ ವೀಕು ನನಗೆ ಅಬ್ಜೆಕ್ಷನ್ಸ್ ಹಾಕೋದು ಕಷ್ಟ ಇದೆ. ಸ್ವಲ್ಪ ಡಿಸೆಂಬರ್ ಹಾಕಿ ನಾನು ಥರ್ಡ್ ವೀಕಲ್ಲಿ ಅಬ್ಜೆಕ್ಷನ್ಸ್
sorry,
ಕೊಟ್ಟು
but
ಅವ್ರಿಗೆ
I am
ಕಾಪಿನೇ
opposing.
ಕೊಡ್ತೀನಿ.
I am opposing. December I am opposing.
learned senior advocate Professor Ravi Verma Kumar seeks some date in the month of December for filing statement of objections. Learned senior advocate Mr. Lakshminarayana, appearing for the petitioner, vehemently opposes that such a long period cannot be granted for consideration of interim prayer. First off, we are in agreement with the version of learned senior advocate Mr. Lakshminarayana, and therefore call this matter on 12/11/2024 for consideration of interim order. In the meanwhile, it is open to the caveator to file statement of objection if he so chooses. Next.
Filed IA for dispensation of translated copies, my lord.
Dispensation granted.
Not relating to non-consideration of my interim prayer, my lord, I am before this honorable court. Page 18 is the order. Lord, I was placed under suspension, though I have not committed any misconduct. Lord, I had made out a prima facie case for interference by granting an interim order, my lord.
What was the charge?
Lord, the petitioner, while working as inspector of police, my lord, petitioner's wife's relative, my lord, approached him to file a complaint regarding Lord, fraudulently collecting 30,000 rupees by one Mr. Jasim. Lord, he took them to the Deputy Commissioner of Police Crime 2. Since he was not there, my lord, he orally inquired and he called upon the Jasim's father, who assured to sort out the problem, and the complaint was not filed. Lord, a report was submitted stating that without there being any complaint or without there being any directions from the higher authority, I could not have investigated the matter. That is the charge, my lord.
Lalita Kumari, they say it is open to police officer to conduct preliminary investigation. Then it runs counter to that. Lalita Kumari citation 2013.
Yes. 2014, madam, sir.
2014. Learned issue notice, learned DG is requested to accept notice for respondents. Interim order as prayed for till next date of hearing. Objection.
Please.
That runs counter to Lalita Kumari.
The petitioner was a applicant for civil services examination 2023. He sought reservation under scheduled caste and also persons with disability. My lords, regarding persons with disability, there was some difference of opinion between the two hospitals. Therefore, I am not pressing that. Because KIMS Hubli certified it as 40%, AIMS Delhi certified it as 29%. Ignoring that horizontal reservation, my lords, I am entitled to be accommodated in the vertical reservation of scheduled caste. The my lords would kindly turn to page 176. I have secured, my lords, 902nd rank. And persons respond number 4 and 5 who are appointed, they have secured 941 and 943rd rank. That horizontal feet, my lords, is the cutoff point, cutoff marks declared. For scheduled caste, it's come to 890. I have secured, my lords.
Page 176, you say.
176 says, my rank is 902. Vasant Kumar Ji. Respondent number 5 is 941. (943) is respondent number 4. and both of them have been allotted the IRS income tax, which my lords would get at page 223.
You said 941 is Pradumna Kumar.
Pradyumna Kumar, he is allotted to IRS IT at page 223. Again, it's serial number 831.
Against 831.
831. Service allocated, they clearly say rank is 941. SC, page 223, Manus. Allotted to IRS IT. Then next, Manus, serial number 830.
No, what happened?
No, Manus, I questioned it and I said, because Manus, the basic training is going on at Lal Bahadur Shastri Academy. And on 5th of December, Manus, the main training will start at Central, in the Central Institute of this Direct Taxes at Nagpur. What the tribunal does is, Manus, it at page 21, it admits the matter and defers the hearing to 27th of November, where I would irreparably suffer, my lords, if I lose the training. At least provisionally I should be allotted to training is what I prayed, my lords. Tribunal morally told that that amounts to granting of but what is identical question, my lords? The same tribunal has allowed application in case of Bhairappa.
It may be, but reasoning of the tribunal makes sense.
My lords, 27th November means, my lords, what should happen to my training, my lords, because now the training program is going on, and 5th December, the regular training starts at National Academy of Direct Taxes at Nagpur. What I am praying is this, my lords. If I am provisionally allotted to the training, my lords, otherwise what happens if I don't have the proper foundational training, I would suffer for rest of my service.
It amounts to virtually granting main prayer.
My lords, let them provisionally allot me to, and if I fail, my lords, I would not claim any. Tribunal reasoning, page 21. Page 21 ನಲ್ಲಿ
ಟ್ರೈಬ್ಯುನಲ್ ಅನ್ನ ಬೇಗನೆ ತಗೊಳ್ಳಿ ಅಂತ ರಿಕ್ವೆಸ್ಟ್ ಮಾಡೋಣ ಅಷ್ಟೇ. Before that date ತಗೊಂಡು ಮುಗಿಸ್ರಿ ಅಂತ.
All the time this ones. You, my lords, could direct notice to you, the central government and the UPSC here. After their appearance, if my lords fix a date, they are not, that would help. Otherwise, what happens is their serving itself becomes a big problem. I will serve on Deputy Solicitor General.
Shanti Bhushan is requested to accept.
And then, my lords, for
first respondent, UPSC garidara.
Vishnu D. Bhatt appears.
See, Vishnu D. Bhatt panel counsel is requested to accept notice for second respondent. Learned AGA for the third respondent. It is open to the petitioner. In addition to taking usual steps in respect of rest of the respondents, petitioner may serve copy of the petition on the counsel representing respondent numbers 4 and 5 before the tribunal.
4 and 5 are notice in avrige monne agiddaste. They, my lords, in the light of the prayer that I am seeking, 4 and 5 now steps tagoltini, but it may not be necessary also. Ultimately, if my lords are, meanwhile I will take steps.
Steps toli no.
The steps tagoltini nan.
Call this matter on 12th of November.
Great. The central government appears, my lords, is under the impression that a physically disabled person, he cannot be considered against the vertical reservation. That was the specific contention they raised in Bhairappa.
Correct, adu merits ಮೇಲೆ correct, but interim prayer ಕೊಡುವಾಗ ಬೇರೆ considerations ಎಲ್ಲ ಬರ್ತದೆ. ಈಗ ಪ್ರಾಬ್ಲಮ್ ಏನ್ ಮಾಡಿದ್ರಿ ನೀವು ಅಂದ್ರೆ 12ನೇ ತಾರೀಕು ಅದು ಬಂದಾಗ we cannot direct the tribunal to consider your interim prayer or to dispose of the main matter itself before 27th of November, because remaining period will be too short. Therefore, we say, anyway, you have chosen that option. Yes.
Because ಅಲ್ಲಿ first time 27th ಬಂದ್ರು ಮತ್ತೆ 3 ವಾರ ಮುಂದಕ್ಕೆ ಹೋಗುತ್ತೆ, because they would not file their objections. Minimum adjournment is 3 weeks, and where state government is a party, they take it only on Tuesday.
Next.
Appearing for petitioner, my lord. My lord, in this case, my lord, the petitioner seeking only writ of mandamus to direction of the petition respondents to consider the representation of the petitioners, my lord. But the petitioners claim
in representation.
My lord, the representation is annexure A12 and A13, my lord. The petitioner, my lord, page number 49, my lord. My lord, the name of the petitioners
One minute.
shown.
You have said 49. We have to see that. Or we should not see. To issue letter of appointment.
No, my lord, to
Huh?
consider my represent, in the event of any.
What was the representation?
My lord, representation, my lord, the petitioners, name of the petitioners shown in additional list, my lord.
ನೇಮಕಾತಿ ಆದೇಶ ನೀಡಲು ತಿಳಿಸಿರುತ್ತಾರೆ.
ಇದರಲ್ಲಿ
49 na?
Yes, my lord.
See your prayer in the second unnumbered paragraph of representation. ಆದರೆ ಉಲ್ಲೇಖ 3 ಕರೆಕ್ಟಾ?
Yes, yes, my lord, yes, my lord.
ಸದರಿ ಸಹಾಯಕ ಪ್ರಾಧ್ಯಾಪಕ ಹುದ್ದೆಗೆ ಸಂಬಂಧಿಸಿದಂತೆ ದಿನಾಂಕ 28-3-2019 ಕರ್ನಾಟಕ ರಾಜ್ಯಪತ್ರದಲ್ಲಿ ಪ್ರಕಟಿಸಿರುವ ಹೆಚ್ಚುವರಿ ಆಯ್ಕೆ ಪಟ್ಟಿಯಲ್ಲಿ ನನ್ನ ಹೆಸರು ನಮೂದಾಗಿರುತ್ತದೆ. ಸದರಿ ರಾಜ್ಯಪತ್ರದಲ್ಲಿ ಆಯ್ಕೆ ಪ್ರಕ್ರಿಯೆ ಪೂರ್ಣಗೊಳಿಸಿ ನೇಮಕಾತಿ ಆದೇಶ ನೀಡಲು ತಿಳಿಸಿರುತ್ತಾರೆ. ಆದ್ದರಿಂದ ತಾವುಗಳು ಹುದ್ದೆಗೆ ನೇಮಕಾತಿ ಆದೇಶವನ್ನು ನೀಡಬೇಕು. ಟ್ರೈಬ್ಯುನಲ್ ಏನು ಹೇಳ್ತಾರೆ?
On the ground of limitation, it is dismissed.
It is
hit by
additional list
no
expires.
amount. Yes, my lord.
ಏನ್ ತಪ್ಪಿದೆ?
My lord, my prayer, my lord, kindly see annexure A9, my lord. In this case, my lord,
Annexure
annexure A9, my lord, page number 44, my lord.
44.
In another case, my lord, the respondent authority issued appointment to some other persons, my lord. Those names are mentioned in the additional list published in the year 2017, my lord. And granted appointment in the year 2013, my lord, after lapse of 6 years, my lord.
This is 3/11/23.
Yes, my lord.
It operated which additional list?
18-1-19,
18/1/19.
my lord. Please, my lord.
Then what he says appears to be true.
My lord, additional list was 18-1-19, my lord.
Correct.
Lord,
You
he-
have issued appointment orders on
Lord, he-
3/11/2023.
He only makes representation, my lord. That is the finding of the tribunal. Tribunal, my lord,
No,
says that,
what he says is,
yes, my lord.
you have given appointment after 5 years, 4 years. Why are you denying that to me on the ground of delay? How tribunal treated it? Tribunal only said it has
Yes, my lord,
expired.
only delay, only ground of delay, my lord.
Lord,
It
it
cannot
has held, my
expire for
lord,
one
that
and see.
any
what
number of representation, my lord, will not cure limitation. That is what.
That's all right. But after 5 years, because after 4 years you have given appointment, you have operated the list, that gives legitimate
Then
expectation.
he has approached KT, that is also, my lord. He has approached KT in the year 4/1/24, he is given an application.
It cannot vary. Limitation is not chancellor's foot from 9 inches to 13 inches. It has to be some, why you see what he says is, after 4 years you have given operated that list.
Please,
Why
my
are you saying that it has expired now to me?
yes, my lord.
ಅದು ಈ ರೀತಿ ಒಂದು ತಪ್ಪು ಮಾಡಿದಾಗನೇ ಈ ಪ್ರಶ್ನೆ ಬರ್ತದೆ. ನೋಡ್ಕೊಂಡು ಹೇಳಿ.
Please,
He
my
is
lord.
right in saying that.
In
Tribunal
fact,
could not have said that for other people it expires and for me it expires and for other people it does not expire. Same rules.
State has not filed any.
I think ಈಗ ಮಾಡಿ. AG ಇದು ಆಗಿದೆ. ಇಷ್ಟೇ ಕೇಸ್ ಇದು.
Please, my lord, I understand.
ಒಂದು ಅಬ್ಜೆಕ್ಷನ್ ಹಾಕಿ.
Please, my lord.
All this matter in first week of, second week of January. Okay.
Lords, the petitioner, ex-serviceman not joined the services of the state, Lords, as a physical education teacher.
ಏನು ಅರ್ಜೆನ್ಸಿ ಏನಿಲ್ಲ.
10 years time bound ಕೊಟ್ಟಿದ್ರೆ 15 years ಕೊಡಿ ಅಂದಾಗ stagnation reach ಆಗಿದೆ ಕೊಡಕ್ಕಾಗಲ್ಲ ಅಂದ್ರು. At that time, I made a submission that it cannot be so because I have represented that I have not reached stagnation. Secondly, stagnation ಇದ್ರೆ ಬರಲ್ಲ ಅಂತ ಏನು provision ಇಲ್ಲ ಅಂತ ಹೇಳಿ that I made a submission. Respondents were directed, my lords, to secure instruction in the matter. My lord, if they.
Yes, brother, what is, it's a soldier's matter, ex-defense.
Please, your lordship, what has happened is.
Have you filed the objection statement?
No, your lordship, I have not filed.
You don't want to file or what?
We'll file it.
Call in first week of January 2024. In the meanwhile, it is open to the state to file statement of objections if it so chooses. If not filed, right to file one stands extinguished. Okay. Yes.
But matter pertaining to Lord suspension of the petitioner. Lord, the petitioner is a assistant teacher. Lord, appointed on 22.
What is the ground on which suspended?
Lord, the allegation against the petitioner is that, Lord, in the original select list, my name did not find place. Despite that, you are appointed and working for the last 11 years is the allegation. But I have been appointed on 22/12/2014. Probationary period is declared on 2/3/2017. But now the allegation is, my lord, my,
Show that.
please,
Show
lord, order of suspension is at page 134.
134.
Yes, 134. All that they are saying is, my lord, my name does not appear in the select list. Though appointment order is issued by the authorities, you have not been selected and appointed in a proper manner is the allegation, my lord.
Allah, not in any manner.
Yes,
Proper Allah.
yes, my lord.
You did not figure in the select list.
Yes, that is the allegation. Yes. My lord,
After how many years? Brother,
Please, Lordship.
On
What
what
has
grounds?
happened in this case, Your Lordship, 79 teachers who are appointed, Your Lordship, in additional list. Though that additional list submitted to the authorities, Your Lordships, were fabricated, fraudulent document. By virtue of that document, they obtained appointment, Your Lordship, and they continued also. Thereafter, Your Lordship, may kindly appreciate, it was handed over, the investigation was handed over to CID, and they were carrying out the investigation, Lordship. In the meanwhile,
they
they
say?
were suspended.
what the investigations?
Investigation regarding that, it's still under progress, Your Lordship.
Since how long it is under progress?
22, Your Lordship.
22. Whether these documents are fabricated
Yes,
or
yes.
not, is no
To show that, Your Lordship, it is fabricated,
Ah.
Your Lordship may kindly find 273 page. R2, Your Lordship, document.
273.
ಹೌದು.
ಎಷ್ಟು ಜನ ಇವರು?
ಇವ್ರೊಬ್ಬರೇ ಇರೋದೀಗ.
ಅಲ್ಲ, ಒಟ್ಟು ಅದ್ರಾಗ ಲಿಸ್ಟ್
79 ಇದ್ದಾರೆ.
79.
ಹೌದು, ಎಲ್ಲರ ಮೇಲೇನು ಇದೆ.
ಎಲ್ಲರನ್ನು ಸಸ್ಪೆಂಡ್ ಮಾಡಿ.
ಹೌದು, ಎಲ್ಲರಿಗೂ ಮಾಡಿ.
ಎಲ್ಲರನ್ನು ಸಸ್ಪೆಂಡ್
ಮಾಡಿದ್ದಾರೆ. Lord, I would concede, Lord, all of us
Even
are
against
placed.
those officials who fabricated also suspended, Your Lord.
ಸಸ್ಪೆಂಡೆಡ್.
Yes.
select list ನಲ್ಲಿ ಹೆಸರೇ ಇಲ್ಲ.
Lord, after 11 years.
Fraud fabrication ಇದ್ರೆ Lord Coke says no limitation. Fraud fabrication ಇದ್ರೆ
273 page. Your Lord.
May I make one submission?
See that Changalavarayan Naidu
Yes.
versus so and so. It says no limitation.
If there is fraud played, there cannot be any question of limit.
In
Lord,
fact, ಬರಲ್ಲ.
Lord, under the statute, my lord, under rule 10(5)(b).
ಅಲ್ಲ ಈಗ if you were singled out, would
No.
you have straightway granted?
No,
stay?
no, no.
All one whole set of people.
Lord, I am not.
At least you are beneficiary of the fraud. If not, if you are not complicit in that, you are beneficiary of the fraud.
Lord.
Beneficiary of, it is like eating the fruits of the poisonous tree or poisonous fruit of the tree, which either way in English language.
Lord,
ಎಲ್ಲರೂ ಮಾಡಿದ್ದಾರೆ, ಏನ್ ಮಾಡಕ್ ಬರಲ್ಲ.
Lord, as far as joint director and others are concerned.
ಯಾವಾಗ when are you going to complete the investigation?
That
You can't
CID
keep it ಪಂಚವಾರ್ಷಿಕ ಯೋಜನೆ
ಅಲ್ಲ,
ಮಾಡಕ್ಕಾಗಲ್ಲ.
CID ಅವ್ರು ಮಾಡ್ತಾ ಇರೋದು.
ಅದು ಯಾವಾಗ
Detail
ಮಾಡ್ತಾರೆ?
ಇದೆ.
They are under you. You tell which date they will be completing the investigation. It cannot go on like a periodic 5-year plan ಅಲ್ಲ ಅದು.
Lord,
Tomorrow I will calling this. You have to tell which date.
ಅಲ್ಲ, in the meanwhile, Lordship, R2, Your Lordship,
ಅಲ್ಲ,
270.
ಬಿಡಿ, ಅದೇ ಅಷ್ಟು ನಿಜ ಇರ್ಬೋದು. ನಿಮ್ಮ ಇನ್ವೆಸ್ಟಿಗೇಷನ್ ಯಾವಾಗ ಕಂಪ್ಲೀಟ್ ಮಾಡ್ತಾರೆ? You cannot go on doing it eternally. Eternal investigation is a torture to the citizen. Somewhere line has to be drawn. 2 ವರ್ಷ ಆಗಿದೆ. And how many years you have put in service now?
11 years. my lord.
11 years service ಆಗಿದೆ. ಈಗ ಸಸ್ಪೆಂಡ್ ಮಾಡೋದಿಲ್ಲ.
ಫ್ಯಾಬ್ರಿಕೇಟ್ ಇದೆ, ತುಂಬಾ ಡಾಕ್ಯುಮೆಂಟೆಡ್. 79 ಮೆಂಬರ್ಸ್ ಇದ್ದಾರೆ ಸ್ವಾಮಿ. They have to collect.
29.
29 ಇದ್ದಾರೆ. ಎಷ್ಟು ವರ್ಷ ಬೇಕು ಅಂತ ಇನ್ವೆಸ್ಟಿಗೇಷನ್?
79, 29.
79. We'll assume that way. You are right, he is wrong. How many years you need for investigation of this?
I will vary. Submit you.
Call this matter on 12th
211.
for soliciting the statement from the side of government as to within what period
the subject COD investigation would be accomplished. In as much as such investigation cannot go on eternally to the torture of citizens. Yes.
ನೋಡ
ಅವತ್ತು ಹೇಳ್ಬೇಕು, ಸ್ಟೇಟ್ಮೆಂಟ್ ಹೇಳ್ಬೇಕು. ನೋಡೋಣ ಹೀಗೆ ಮಾಡ್ಲಿಕ್ಕೆ ಬರಲ್ಲ ಇದು.
Yes.
ಎಲ್ಲರಿಗೂ ಮಾಡಿದ್ರು. ನಿಮ್ಗೆ ಒಬ್ಬರಿಗೆ ಮಾಡಿದ್ರೆ I would have stayed that, straight.
But on facts, my lord,
ನೋಡೋಣ ಬರ್ಲಿ.
only
12th
one
ಬರ್ಲಿ.
submission.
12th ಬರ್ಲಿ.
But one fact is, my lord, they have completed the investigation.
They have completed the investigation.
But my learned friend may verify, they have completed the investigation.
Make a statement.
I will verify.
Okay.
And trial has begun.
Has begun.
Yes. Trial has begun.
But trial begin ಆಗದಿದ್ರೆ ಮತ್ತೆ ಇನ್ನೇನಾಯ್ತು?
Disciplinary proceedings is also going on.
ಅದು ಎಷ್ಟು ವರ್ಷ?
ಕೇಳ್ತೇನೆ. I'll verify and submit you.
He shall also make a statement as to within what period the pending disciplinary proceedings will be accomplished. Okay. Yes, next. Yes.
In this case, my lord. In this case, my lord, challenged the KT order, my lord,
Huh?
that consider the representation for the promotion, my lord. That, my lord, in this case, my lord,
KT ಏನ್ ಹೇಳಿ?
KT rejected, my lord, dismissed said that consideration will be.
ಯಾಕೆ
Representation is A4, my lord.
Page number?
Page number 35, my lord. If I 36.
ಇಲ್ಲ, ಬರೀ. ಈ KT orders, CAT orders. First annexer. ಹೇಳ್ಬೇಕು ಆಫೀಸ್. ರೂಲ್ ಹಂಗೆ ನೋಟಿಫಿಕೇಶನ್. You know, what is the reason given by?
I have given the reason that, my lord, minor penalty was imposed to me. And I was recover the amount 6 lakhs from me, my lord. That for that challenging the KT, I appeared KT dismissed, my lord. I approached the High
Your
Court.
juniors, all your juniors were
Uh,
not promoted.
yes,
They were
ma'am.
placed under 32.
Based on that, 32 years, my lord.
ನಮತ್ತಾಯ್ತು.
Shekhar has promoted to me, who is junior to me, my lord. Who is co-accused to me, along with this DGOs, my lord, the minor penalties was imposed. They have given the representation in another case, my lord, they have challenged in Kalburgi bench, that was allowed, representation was considered, and he was promoted, my lord. Who is one of the accused in the same,
ಯಾರಿಗೆ ಪ್ರಮೋಷನ್ ಮಾಡಿ?
that, my lord, Prakash Jonganawar.
ಪ್ರಮೋಷನ್ 32 ನೋ?
Promotion, 32 nalle promotion. This is-
32 is never called promotion.
No, my lord, ada consider the representation ಮಾಡೋದಕ್ಕೆ.
ಅಲ್ಲ, your case is that you should be promoted on par with those who juniors who are promoted.
Yes, my
But they
lord.
are not promoted.
No, they are promoted, my lord.
How do you say that?
Rule
No.
32 lots.
It's a rule 32 position. ಹಂಗಾಗಿ ಸ್ಟ್ಯಾಂಡರ್ಡ್ ಬುಕ್ಸ್ ಅನ್ನು ಓದ್ಬೇಕು ಸರ್ವಿಸ್ ಲಾದಲ್ಲಿ. ರಾಮಜೈಸು, ಸಮರಾದಿತ್ಯ ಪಾಲು, VD ಕುಲಶ್ರೇಷ್ಠ ಅಂತವ್ರ ಬುಕ್ಸ್ ಓದಿರಿ ಪ್ರಾಬ್ಲಮ್ ಆಗಲ್ಲ.
Yes.
ಹಾ, ರೂಲ್ 30, the 76 or Ramajoyce in his services under the state has dedicated 2 paragraphs on that. It is not a case of promotion. All right, it is not a case of promotion, but
And
when
that
you
don't
place
only
juniors, when you place juniors in rule 32, why do you deny it to him?
Because
Ordinarily,
department
placing the 32,
your lordship, serious allegations are there against him.
but are those who have been already punished.
So that
ಅವ್ರಿಗೆ ಕೊಟ್ಟಿರಲ್ಲ.
information.
You cannot be that arbitrary. That was the old law. When Gulbarga in Dharwad, we have held in division bench, we said, although it is open to the, this is considered in the BN Dhotra versus, sorry, 2004 ILR Kodi. This aspect is considered. BN Dhotra versus Karnataka Land Army Corporation. Justice Najir Saibra judgment. ಅದನ್ನ ರೆಫರ್ ಮಾಡಿಕೊಂಡು we have held, even in rule 32, you cannot be that arbitrary. Because Justice Ramajoyce wrote, rule 32 is operated on different principles where seniority will pale into insignificance. That's a general proposition, yes. But you cannot pick and choose that way. We have, ನೋಡಿ ಧಾರವಾಡದಲ್ಲಿ Narayana Yaji has argued that matter before us about 3-4 years back. Okay,
Please,
have to
my lord.
bring that
Please.
judgment. You cannot be that arbitrary.
Please, let.
That in one more, that B.M. Dhotra, Basavaraj Dhotra
Please, my lord. I will.
versus Land Army Corporation. Not come account.
Please.
Learned AG is requested to accept notice for respondents. Yes.
Date, my lord.
Eh?
Any date?
Barely, not come
Please.
after 2 weeks. Yes, brother.
This is regarding to be considered.
Hmm?
This is regarding provisions list.
Regarding?
Provisional list he has challenged it. Board services cannot be, he's claiming from board he has transferred to PWD department, Your Lordship. He's claiming his seniority, what he has placed in board, Your Lordship. That he is not entitled to him. Past services he wanted to be counted.
Past service.
Please, Your Lordship.
Did he go to the board on his own or he was sent on deputation?
On his one, the option was given to him, Your Lordship.
Option is different.
No, he was selected, Lordship may kindly say, he was appointed in the board. In 2012, he appears for examination conducted by the KPSC and he selected as a executive engineer, Lordship. Now, from the date he joined the duty, Lordship.
That previous service to be counted.
That is the contention, Lordship. Our contention is that board past services cannot be taken into consideration.
But this court has held, Justice Dattu Sahib has held, Dr. Renuka Prasad versus Institute for Animal Husbandry, ILR 98 or 99 Karnataka. This view is rejected. Same contention was put forth. Just take out that judgment.
Please, Lord.
ನಮಗೊಂದು ಕಾಪಿ ಕೊಡಬೇಕು.
224 ಅಲ್ಲಿ ಕೇಳ್ತಾ ಇದ್ದಾರೆ ನಾವು 250
Identical point is considered.
I will look into it and I will make submission.
ನಾವು ಹೇಳೋವನ್ನೆಲ್ಲ ನೋಟ್ ಮಾಡ್ಕೋಬೇಕು.
ಮಾಡಿದ್ದೇನೆ.
ನಾವು ಓದ್ಕೊಂಬಂದು ಹೇಳ್ತೇವೆ, ಹಾಗೆ ಹೇಳಲ್ಲ.
ಪಬ್ಲಿಕ್.
And you can contradict also.
ಇಲ್ಲ ಇದು ಮಾಡ್ಕೊಂಡಿದ್ದೆ.
ILR 2000 Karnataka.
Please.
2000 Karnataka 256. Page number. Yes. Yes.
Public.
Appear for the petitioner in this case, Lord, this matter may be connected with another pending matter, my Lord.
Call this matter along with WP number.
2166 of 2022, my Lord. Sorry, my Lord.
Paper could.
Lord, one other discrepancy has crept in, my Lord's mind. Along with my name, the advocate for respondent number 3 has been shown as along with me.
Response, they man,
All two.
delete ಮಾಡ್ಬೇಕು.
I'll file objection in the meanwhile.
All, please. After 2 weeks or first week of January.
My Lord, that matter is 2022 matter, my Lord. I think to be connected with, my Lord.
Alla, correct.
That is, please.
January ಹಾಕೋಣ.
May I make submission, my Lord? That matter is listed on, I found out from the website that it is listed on 1411 for final hearing, my Lord.
Call this matter along with WP number so it's. ಅದು ಯಾವಾಗ ಬರ್ತದೆ ಬರುತ್ತೆ. Next.
Deeply obliged.
Okay.
But 23 and 24, I am for the petition.
Yes, Basaraj.
My Lord, matter may have to go back. There is a mistake on everybody's part. But what has happened is this. Under the IBC, a petition was filed for under section 9 by the corporate creditor against me. Then subsequently, the NCLT admitted the matter and the matter was, we took the matter before the NCLAT, before the NCLAT by the suspended director. During the pendency of the appeal, the suspended director resigned. Under section 168, your lordships are aware, the promoter can appoint the other director and he can continue. Now, therefore, on 14/10/2024, when the matter came before the appellate authority, we had already filed an application on 12/10/2024 for substituting the promoter in the cause list. The application unfortunately was not listed. Now the appellate authority says, because of the resignation of the sole suspended director, the company has become non-existent and dismissed the original appeal itself, where the NCLT had granted a substantial interim order. Now everything is diluted. Kindly see page 26. The application will have to be considered by the NCLAT, appellate authority. The application was not listed on that day. Page 26 may kindly be similar.
That application was not listed.
Not listed on we saw the cause list. It was not, it was filed on 12/10/2024. The matter came before the appellate authority on 14/10. Kindly see page 26.
I am of course, my lord, not here. I've not been implemented as a party.
He was
I am,
not
lord,
there.
the financial creditor.
For the,
Who
sir, just clarify, his application for intervening was not considered, yet to be considered by the, I have no problem with my friend arguing on a question of law, but kindly see page 26.
Lord,
Let me read, sir. Only one second.
I am responding to his lordship's question.
I'm
not
sorry. I didn't know
reacting
that.
to what
I'm
you're
sorry, I didn't know that. I didn't know that.
You are
I'm sorry.
respondent. You are paid
Illa,
for
you
respondent.
I'm
he
not
is
being
the-
arrayed as a respondent. I'm therefore ready with an intervention application, Lord, to
Lord, I have
intervene in
no
this
objection,
proceeding,
but
because
the-
now by virtue of the order of admission, it becomes a in rem proceeding. Once an admission order is made under the IBC code, as your lordships know, Supreme Court says.
I do not know. I was under impression only in 4 jurisdiction orders become rem under section 42 or 43 of the Evidence Act. One is probate, matrimonial, insolvency and admiralty.
Insolvency, this is insolvency proceeding.
This is insolvency
Insolvency.
proceeding.
You kindly see page 26. Ma'am. The instant company appeal, as it then was prepared by Mr. So-and-so, suspended director of Tarun Realtors, who is the creditor, debtor, seeks to challenge the NCLT Bangalore impugned order of 27/2023, which was admitted, passed in CP number so-and-so. An interim order was granted initially on 18/4/2024 by this tribunal, which continues to operate. It has been submitted by the respondent that the appellant, Mr. So-and-so, suspended director, has now resigned from the post of director. And as a consequence of his resignation, the present appeal is no more maintainable. In this scenario, as the appellant has become non-existing entity, the instant appeal cannot be permitted to be sustained and continued. Hence, the same is accordingly
Now, when there
dismissed.
is an application for substituting,
Yes, but
could have been.
the promoter is
Possibly
equally
may not make
interested.
an application for recall. I'll tell you lordship what the problem is. NCLAT has taken a view that a shareholder cannot maintain an appeal.
Shareholder cannot put.
Maintain an appeal challenging an order of admission because it's only an investor in the entity. And therefore, my lord has given a finding that no shareholder can file an appeal. It is only a director who can file an appeal. And therefore, once the director resigned, his resignation was not brought to the notice of the court at all initially. Apparently, an application was filed, my lord. Of course, I don't have a copy of the petition as yet and what they have filed.
We'll assume that the application was filed.
Possibly, my lord, it may have been filed.
Yes.
Now, even if that application was there on record, it really couldn't have been considered because the law has been declared by the NCLAT, at least for the
That
NCLAT,
application is by the shareholder.
by a shareholder. And today, my lord,
Basura, is it true that application was filed by the
Yes,
shareholder?
yes. Kindly see page, the definition of the word party in the appellate regulations framed under the IBC. Party means a person who prefers an appeal before appellate tribunal and includes respondent, any person interested in the appeal. But it is wide in nature. And also, my lord, there is a rule 19(6) says.
How these rules are interpreted by various high courts in the country?
That I have to verify, but the application
I
itself
wanted
is
to-
not, my lord, if the NCLT, the appellate authority rejects the application on merits, you have no locus standi. There ends the matter. The application itself was not considered. Now, what my friend wants to do is
Right to
surpass.
maintain. Supreme Court said, following Lord Atkins' judgment, Supreme Court said, if you have no right to maintain application, then you cannot assail the main order under Order 43, Rule 1, capital A of CPC, where you had no locus to maintain the
But
application.
kindly see section 168 of the Companies Act 2013.
ಅದಕ್ಕೆ ಅಲ್ಲ ಬೇರೆ ಹೈಕೋರ್ಟ್ಗಳು ಏನ್ ವ್ಯೂ ತಗೊಂಡು ಅದ್ ಕೊಟ್ರೆ That will be jurisprudential
We will-
support to
we'll-
us.
We'll assist you.
Suppose if already there are
But my
judgments.
friend should say the otherwise. My friend should say that my application itself was not maintainable before the NCLAT.
ಅದೇ
Kindly
ಅವ್ರ
see-
contention ಅದು.
That's what
I
I'm
will
saying.
my friend should enlighten me at least.
I have at least
Some
one
custom
authority
to-
to support it, and I'm
Judgment
told
is our-
NCLAT has taken.
NCLAT is-
NCLAT.
Any high court, NCLAT judgments, they do not become,
This, not for
they
your
do not have
lordships,
presidential value.
not for your lordships. I think for the NCLAT,
PU.
for the NCLAT, it's binding.
For
So far the
NCLAT,
NCLAT is
like-
concerned, NCLAT is bound by its own judgment.
ಅದಕ್ಕೆಲ್ಲಿದೆ? Where is the authority for that?
But NCLAT can't turn around and say, I will not follow my own order.
Under Article
Yeah.
214,
Salmon's jurisprudence treats this. He says, unless the law otherwise says, an authority which is not a precedent-laying authority is not bound by its own order or the principles on which its orders are construed.
except on res judicata.
Except on.
On
res
res
judicata.
judicata, that's all.
Yes, stop.
That's
Yeah,
all.
brother.
Then,
Under Article 214, the law declared by, I'm sorry, Constitutional Court is binding within the state jurisdiction.
that
and
of course
140.
not, goes without saying.
Yes.
But in an appellate jurisdiction law like this, while your lordship,
ಒಂದ್ರಲ್ಲಿ ಹಿಂಗೆ ಡಿಸಿಷನ್ ತಗೋಬಹುದು ಸೇಮ್ ಫ್ಯಾಕ್ಟರಿ ಮಿಸ್ಟೇಕ್ಸ್ ನಲ್ಲಿ
ಹಾ.
ರಿವರ್ಸ್ ಜಡ್ಜ್ಮೆಂಟ್
but it is,
ದಟ್ ಈಸ್ ಪಾಸಿಬಲ್
that will
ಅಂತ
be
ಹೋಲ್ಡ್
da-
ಮಾಡ್ಯಾರ.
of course, this order is appealable to the Supreme Court under section 62 of the IBC code. This order, my lord,
Order.
of the NCLAT is appealable to the Supreme Court under section 62. So section 62,
No, that will not serve purpose because NCLAT will say, we have already taken a view in that matter, therefore we'll reject this application.
But all I'm saying
I'm
is
saying
let
this
the
order,
application.
which is challenged before my lord today, is appealable to the Supreme Court.
Appealable to Supreme Court.
Supreme Court, under the IBC code, section 62 provides that the final order which is passed is challengeable before the Supreme Court, or any order, as a matter of fact, on a question of
If
law.
there is a violation of principles of natural justice and a mistake on the part of the NCLAT and myself in not bringing. Kindly see page 168.
You are not answering our question.
Yes, madam.
Answer your right to maintain the application
they-
because he has
according-
raised it.
Kindly see page
How
160.
Courts have treated this aspect. This is not that the first time it is coming before the court. There will be high court judgments on this. Just send.
Lord, I will bring, I
send
will
your
support.
colleagues to library.
Malad, it's the other way. My friend has to enlighten me that it is not maintainable. My submission is maintainable. Kindly permit me to read the rules.
What's the
Appellate
rest?
authority, Malad,
Listen, we'll read that, no issue.
Hmm.
We have always the love for reading. Point is, suppose if it is already treated by the high courts in the country, why we should again find out new, the manufacturer wheel again?
again, Malad, objection is not raised by me. Objection is raised by my friend that the application
Not-
itself
but
was not
not-
maintainable. Therefore, Malad, kindly see the rules.
ನೋಡ್ಕೊಂಬನ್ನಿ.
ಅಲ್ಲ, in the
ಆ
now,
rules ಅನ್ನ ಹೆಂಗ್ ಇಂಟರ್ಪ್ರಿಟ್ ಮಾಡ್ಯಾರ ಹೈಕೋರ್ಟ್ ಅದ್ ನೋಡ್ಕೊಂಬನ್ನಿ.
I will certainly assist. The reason is the entry matter is diluted without considering my application. The whole problem is,
We have answered your question now. If you establish that you have right to maintain that application,
but the rule itself
read
provides,
those provisions.
rule itself provides for
Saying
that.
that, but we are saying how courts have viewed those rules on the point which you also
Malad,
looked into.
Malad, it's very,
Because this
Malad,
matter
it
is
is
not
very
a-
easy. It's
There is
very
one more
easy.
difficulty for my learned friend. The application filed before the court, before the NCLAT, was some other entity. The writ petition filed is by someone else.
No, we have filed on behalf of the suspended director also.
The suspended director resigned. Therefore,
But the same applicant,
the same applicant who filed the application, which he says to substitute, is not the petitioner before your lordship.
it was not your application.
The petitioner before your lordship is the holding company of the applicant. He was not available. Monthly developer was not available. Therefore, what we have done is we have filed the petition on behalf of the holding company, which has 89% share in the applicant. And also the, Malad, to be on the
No,
safer
who
side,
had to file the application?
application was filed by
It's someone
Monthly
else.
Developers Private Limited.
Suppose if he is happy
Who-
with the order.
That writ petition is also filed today morning. Now, the whole problem is this, my lord, kindly see. Now, a person, my lord, who is not even a party to the proceedings comes and makes a submission that application itself is not maintainable. Now, I can demonstrate before your lordship on the face of it by going through the rules and 168 of the act, it is maintainable. Now, kindly see my predicament. Now, because of this, the IRP called a meeting on 28/10. Immediately he called a meeting. Now, if the assets are valued, and if the resolution plan is submitted, I'm gone. The company itself becomes liquidated. Then the argument would be the company itself is not in existence. Therefore, it's a mistake committed by the NCLAT in not considering the application.
Whose
What-
application?
The application filed by the
You. No.
the holding company is before lordship. We have also already filed the petition when the safer said he was not available. The applicant, The holding company of the applicant, which has 89% shareholding, is before your lordship now. The
ಇನ್ನೊಂದು ಪಿಟಿಷನ್ ಇದೆ.
petition ಹಾಕಿದೀವಿ. Now what I am saying is kindly stay the proceedings for some time. Let it come on Monday. We have already filed the petition today morning. What I am saying, if the IRP proceed, if we held the meeting on 28 immediately, but if the resolution plan is submitted, we are nobody.
Don't process the matter.
No, no,
till next
commit-
date.
yes, no, no.
2 weeks, nothing will happen.
No,
1
committee,
week.
let me just explain this. No. Committee of creditors was constituted after the order of admission was passed. They went, filed an appeal.
ಯಾವ ಸ್ಟೇಜಿಗೆ ಇದೆಯಲ್ಲ
ಹಾ.
ಅಲ್ಲಿಂದ ಮುಂದೆ ಪ್ರೆಸಿಪಿಟೇಟ್ ಮಾಡಬೇಡಿ.
That's all I am
That's it. In the meanwhile, you also look into the law. We will also look into the law. In the meanwhile, we will take up this matter on Tuesday.
On Tuesday.
Tuesday
Nothing will have.
ಅಲ್ಲಿ ತನಕ ಏನ್ ಮಾಡ್ಬೇಡಿ.
ಏನು
ಅದರ್ವೈಸ್ ಈಗ ಮೇಲೆ ಹಂಗೆ ಬಿಟ್ಬಿಟ್ರೆ ಮುಂದೆಲ್ಲ ಪ್ರೊಸೆಸ್ ಆಗಿ retracing the steps will be a big problem. in
Because
matters
not
like this.
to, that nothing will happen by Tuesday, that your lordship's meeting. Nothing will happen by.
That's all.
Okay, call this matter on Tuesday along with WP number.
FR number put it.
ಕೊಡಿ FR number so and so.
FR number 29665 of 2024.
Perfect. In the meanwhile, the ಏನು shall not be precipitated.
I also don't know what.
The
Let's-
proceedings pursuant to the order in question shall not be further precipitated. Okay. ಅಲ್ಲಿ
Will come with
ಬಸವರಾಜ್,
all the authority.
when we request,
Yes, yes, ma'am.
you should not say, other ಯಾರು ಹೇಳಿ. We want to know what courts have said on these things.
Yes, yes, yes.
Offend
Will
not
come with
guilty.
all guns
On the other
blazing
hand,
and swords drawn.
That should be the attitude.
With
ನಾವೇನೋ
all-
ಹೇಳಿದಾಗ ನೀವು ignorant
ಇಲ್ಲ, ಇಲ್ಲ, ಇಲ್ಲ.
ಅಫೆಂಡ್ ಆಗೋದಲ್ಲ.
Yes.
Oh, if I'm ignorant, I should.
No, no, I
try to
didn't
get
know, sir.
knowledge on that.
I didn't know, sir will take the fundamental preliminary objection. We will come with the guns blazing and swords drawn.
ಹಂಗಲ್ಲ ನೀವು
For your lordship.
ಬೇರೆ ಸ್ಟಾರ್ಟ್ ಮಾಡ್ತಾರೆ.
Yes, yes, sir, certainly.
ಅದು ಬಹಳ ಕೆಟ್ಟ ರೋಗ.
ಇಲ್ಲ, ಇಲ್ಲ. Will come.
Ignorance ಇದೆಯಲ್ಲ ಅದಕ್ಕೆ we are wedded to that.
But according to me, as per the
said
rules,
that
it is
you are
maintainable.
repeating.
My friend
Repetition
says
will
it
not
is not
help you.
maintainable without producing a single
Repetition will
judgment.
not help you. When court says.
Yes, yes,
what
certainly.
Courts have said on this, your
Yes,
duty.
It's
you
my
are-
duty,
you
my
are-
lord.
You are bound on duty.
Yes, yes, yes.
Is to spend time in the
Yes,
library.
yes, sir, certainly, certainly.
Yes.
We will do that, madam.
May I then request them to serve copies of the
Yes,
papers?
immediately.
Copy
madam. Certainly, certainly. Let the.
Otherwise ನಾವ್ ಹೆಂಗ್ ಗೊತ್ತಾಗುತ್ತೆ? ಸಣ್ಣ
But
ಸಣ್ಣ
we-
ವಿಷಯದಲ್ಲೆಲ್ಲ ಎಲ್ಲ ಮಾಡ್ಕೊತ ಕೂತ್ಕೊಂಡ್ರೆ
As
ಎಲ್ಲದಕ್ಕೂ
intervening applicant also.
ನಾವೇ ಬುಕ್ಸ್ ಹೇಳ್ಬೇಕು ಮತ್ತೆ ಹಂಗಾರೆ ನೀವೇ ಕೂತ್ಬೇಕು
ಹೌದು, ಹೌದು,
ಮಾಡ್ಕೊಂಡು ಹೋಗ್ಬಿಡ್ತೇವೆ ಎಲ್ಲ.
ಹೌದು, ಹೌದು. We will assist. We will assist your lordship.
Galvanized far by his notes, so etc. But he should not say that. ಬೇರೆ ಹೇಳಿದ್ರೆ ನಾವು ತಲೆ ಕೆಡಿಸೋದಿಲ್ಲ. He should not say.
ಇಲ್ಲ, ಇಲ್ಲ, we'll come back. I shall come back with the.
ಅವರಿಗೆ
Yes, sir.
ನಿಮ್ಮ ಕೌನ್ಸಿಲ್ ಅಂತ ಯಾರು ಇದ್ದಾರೆ?
Yes, sir. Maitrey Kannur.
ಶ್ರೀಮತಿ ಮೈತ್ರಿ, ಮಿಸ್
ಕಣ್ಣೂರ್.
ಮೈತ್ರಿ,
Miss Maitrey.
ಕಣ್ಣೂರ್. Is
Let them formally file an application for
appears for.
intervene.
ಯಾರಿಗೆ ಅಪಿಯರ್ ಆಗ್ತೇನೆ?
ಯಾರಿಗೂ ಇಲ್ಲ ಅದೇ ಪ್ರಾಬ್ಲಮ್ ಆಗಿರೋದು ಈಗ.
We are.
ಇಂಟರ್ವ್ಯೂನಿಂಗ್ ಅಪ್ಲಿಕೇಶನ್.
ಅದೇ ಒಂದು
Intervening
application
application
ಹಾಕ್ಬಿಡ್ಲಿ
for-
ಇಲ್ಲೂನು. I'm sorry.
ರಿಜಿಸ್ಟ್ರಿ ಟು ಪೋಸ್ಟ್ ಅದು ಪೋಸ್ಟ್ ಆಗಿದೆಯಾ ಇಂಟರ್ವ್ಯೂನಿಂಗ್ ಅಪ್ಲಿಕೇಶನ್?
Illa, it's just ready. It was filed only, I think, yesterday.
ಅಲ್ಲ ಅಲ್ಲಿ ಫೈಲ್ ಮಾಡಿದ್ದಾರೆ. ಕೇವೆಟ್ ಹಾಕಿದ್ದಾರೆ ಅವರು.
ಅಥವಾ ಇಲ್ಲಿ ಎಲ್ಲರ
ಅಲ್ಲ ಹಾಕ್ತೀನಿ ಇವತ್ತು after.
Yes, yes, in the court.
registry to post the contemplated intervening application in which Miss Maitreyi Kannur appears for intervener. Comma, if filed. All.
No place.
State ನೀವಿದ್ದೀರನಾ? ಎಮರ್ಜೆಂಟ್ ನೋಡಿ.
Registrar NCLT.
ಅವ್ರಿಗೆ
State.
Yes, yes.
State is not a party.
ಯಾರು NCLT ಗೆ ಯಾರು ಪೇರ್ ಆಗ್ತಾರೆ? DST ಪೇರ್ ಆಗ್ತಾರನ?
Mr. Kumar appears for NCLT registrar. He appeared in one matter before the division bench.
Sri Kumar, petitioner to take emergent notice to respondents. Two and three. All the respondents, full stop. In addition to taking usual steps, the petitioner to serve a copy of the petition on the panel counsel Sri Kumar, Anta Kumar.
N Kumar.
N
Kumar ಅಂತ ನಾನು ಸೇವ್
MN Kumar. MN Kumar. Appearing for the first respondent. All right.
Tuesday.
Tuesday. Call on Tuesday.
Yes. Can I ask for a hand delivery of the?
That's good. Memo ಕೊಡಿ.
My friend does not represent the CRP.
ಕೊಡಿ ಮೆಮೊ ಹ್ಯಾಂಡ್ ಡೆಲಿವರಿ ಕೊಡಿ ಏನು ಆರ್ಡರ್ ಕೊಟ್ಟ ಮೇಲೆ ಎಲ್ಲ ಆರ್ಡರ್ನಾಗೂ ಹ್ಯಾಂಡ್ ಡೆಲಿವರಿ ಕೊಡ್ಬೇಕು ನನ್ನ ಮಗ ಅದೇನು ಇಟ್ಕೊಂಡು ಕೊಡೋದು ಇರ್ತದ ನಾವು ಎವ್ರಿವೇರ್ ವಿ ಡು ನಾಟ್ ನೋ ವೈ ವಿ ಶುಡ್ ಬಿ ಫ್ರೂಗಲ್ ಇನ್ ಡೈರೆಕ್ಟಿಂಗ್ ಹ್ಯಾಂಡ್ ಡೆಲಿವರಿ as a matter of course if they make application straight away it should be given ಅಲ್ವಾ
ಹೌದು
ಅದ್ರ ಮೇಲೆ ಒಂದು ಆರ್ಗ್ಯುಮೆಂಟ್ ಎಲ್ಲ ಮಾಡಿ ಕೂತ್ಕೊಂಡ್ರೆ ಎಸ್
Same. It's
2324.
24 interestingly is filed by the person who has resigned.
Yes,
Bhaskaran.
no, he has
Now,
become wise
how
now.
do they maintain both the petitions or strictly?
No, he has
One is
become
by a
wise now.
person-
okay
One is by a person who has not filed the application. One
No,
is by the
Kal-
person who is not a director.
call this petition along this petition
Yapar.
together ಅವತ್ತೇ ಆರ್ಡರ್ ಮಾಡೋಣ
ಆಯ್ತು.
ಎಸ್ ಎಸ್
APA for the petitioner, my lord.
ಪ್ರಾಬ್ಲಮ್ ಒಂದು ಅಪ್ಡೇಷನ್ ಇರಲ್ಲ ಇವರಲ್ಲಿ ಅಪ್ಡೇಷನ್ ಇರಲ್ಲ ಅದು ನಮಗೆ ಕೆಲಸಕ್ಕೆ ಅಡ್ಡಿ ಬರ್ತದೆ ಆಮೇಲೆ ಅಪ್ಡೇಟ್ ಮಾಡಿಕೊಳ್ಳ್ರಿಂದಾಗನೇ ಅಫೆಂಡ್ ಆಗ್ತದೆ ನಾವು ಅಪ್ಡೇಟ್ ಮಾಡಿ ಹೋಗೋದು ತಿಳಿಯಲ್ಲ ಅವ್ರಿಗೆ ಅಫೆಂಡ್ ಆಗೋದು ಇದನ್ನ ಆಲ್ಟರ್ನೇಟಿವ್ ಫಾರ್ ಬೀಯಿಂಗ್ ಅಪ್ಡೇಟೆಡ್ ಅಂತ ಎಸ್
My lord, this is a case of transfer, my lord. I was working as additional director horticulture in Lal Bagh. My lord, I am transferred, my lord, to Kandaya Bhavan in Bangalore. My lord, there is,
ಕೊಟ್ಟಪ್ ಸರ್ ಅದೊಂದು ಬಾಗ್ಲ ತೆಗೆದಿಟ್ರಿ ಸಫಿಕೇಶನ್ ಆಗ್ತದೆ ಎಲ್ಲರಿಗೂ ಇಷ್ಟು ಜನ ಇದ್ದಾರೆ ಇದನ್ನು ತೆಗೆದು ಎಸ್
my lord, this is a case of transfer, my lord. I was working as assistant, additional director,
on what ground
my lord, on administrative grounds,
on administrative
on
on
administrative.
ground on what ground you had sought
My lord,
invalidation of the transfer order
my lord, on Malafide,
modified
Malafides.
Application they have filed it not served on us, your lordship.
My lord, it is served.
That
My lord, on the
applications for malafide subsequently they have filed.
No,
it
no,
to us.
I have filed an application, my lord, for
Think that-
summoning files. That also has been served, my lord, on the other side. If my learned friend wants my lord to look into, I'll provide him another copy. There is no
Sorry.
difficulty.
one more copy ಕೊಡಿ
Agboson.
what is the modified how that contention is treated by the tribunal
My lord,
Yara-
tribunal, my lord
118
holds,
Page 118,
ಒಂದು ನಿಮಿಷ 11
8, your lordship,
118
118. Para 4, your lordship.
para 4. my lord. On perusal of annexure A1 dated so and so, it reveals that applicant in case selection grade officer belonging to Group A cadre. As per the transfer guidelines dated so and so, the minimum tenure of Group A cadre is 2 years. The impugned order has been passed on 16/7/24, which makes it clear that the applicant has completed her minimum tenure in the present place. Secondly, the impugned transfer order has been passed during the general transfer period by providing suitable posting to the applicant, that too within Bangalore city only, as a special deputy commissioner, Bangalore city, in place of the private respondent, and private respondent has been posted in the place of applicant, and their transfers have been made in public interest and administrative exigencies. More so, the impugned transfer order does not violate orders passed by this tribunal in application so and so. Such being the fact, the applicant vide annexure F5 has given representation to the first respondent on so and so, stating that her mother is suffering from ill health due to physical disability and is taking treatment, and the applicant has to look after her mother. Considering the grievance urged in the representation, the applicant has been transferred within the city station or headquarters, and thus she can take care of her mother even at the transfer place. Further, on perusal of annexure R1 and R5, it reveals that the private respondent has already assumed charge at the transferred place on so and so, and it appears that the applicant has not handed over charge to the private respondent, and therefore the private respondent is forced to assume charge by signing the CTC. Considering the circumstances explained in by the applicant AAG appearing for the respondents, we hold that there is some force in his submission. Accordingly, we hold that applicant is devoid of merits and deserves to be dismissed, and hence dismissed.
where was the ground of modified
My lord, your lordship may kindly see my application, my lord.
no if the question of modified we are not sure whether it can be traded for by an official whose retention period is over. How courts have treated that question. If your retention period is over, question of mala fide will not arise.
My lord, the fact is like this, my lord. Previously, my lord, before my tenure was over, I was transferred, that was set aside. Then, my lord, immediately on completion of 2 years, I was transferred. Candidate, my lord, who is posted to my place, had just completed 3 months, my lord, in the previous posting.
No, if your period of 2 years is over, what is your right to cling on to
My
the
lord, I
place?
have no right as such. My lord, your lords may kindly see, my lord, one paragraph, my lord, which I have pleaded before the tribunal. My lord, I am not interested to stick on to a post, my lord. My submission is that, my lord, I was entrusted with an investigation pertaining to certain financial irregularities, my lord, in Kamanagundi. My lord, where, your lords may kindly see, my lord, I have stated in detail all those things. Page 25, my lord. My lord, starts from page 24. 24, last paragraph in 24. On instructions of the Director of Horticulture, a team from the Directorate consisting of the applicant, administrative officer and the first division assistant made a surprise visit to the office of the special officer at Kamanagundi on so and so. During the said surprise visit, on perusal of the records and the following irregularities on the part of the special officer by name Kuberachari were unearthed by the team headed by the applicant. Collection of entrance fee from the tourists by issuing fictitious tickets and pocketing the revenue so received. Installation of numbering machine unauthorizedly to number the tickets. Failure to account the revenue received from the tourists. Failure to account the receipts from 28th February 2021. Failure to maintain cash book ever since 28th.
All right, we have read that. And he is placed under suspension.
He was kept under suspension. My lord, immediately, my lord, the person who assisted me, my lord, who is the administrative officer, he also was kept under suspension, that was stayed. I was transferred. Another person, my lord, who was the part of the team, my lord, his additional charge was taken away. My lord, I am not in any manner, my lord, I am not at all interested to cling to this post. My lord, the revenue loss is in crores, not in lakhs, my lord. That's why, my lord, I was shunted out. When I was dealt, my lord, in such a manner, that's why, my lord, I approached the tribunal. Not that, my lord, my transfer from Lalbagh to, my lord, Kandaya Bhavan would affect my. That's why, my lord, I requested your lordship, my lord, by IA to summon 4 files. My lord, if your lordship may put me on terms, your lordship may peruse the file. My lord, if there is nothing, my lord, your lordship may dismiss my application. My lord, I am not interested to stick to the post of horticulture, additional director.
What do you say? Lordship may kindly see that is the only contention put forth is mother was ill. ಅವ್ರು ಹೇಳ್ತಾರೆ ಆಮೇಲೆ ಸೇಮ್ ಪ್ಲೇಸ್ ಕೊಟ್ಟಿದ್ದಾರೆ. If he was transferred to some other place, your lordship, matter would have been different in a general transfer. Her grievance is addressed to, and she has been placed in higher post. In better post she has been placed already.
Better, she appears to be a good officer who by her efforts has saved crores to the exchequer. And based on her report, you have suspended the guilty person, guilty officer. And why all of a sudden you want to shunt her out?
Not shunt her out, your lordship. She has completed 2 years, your lordship.
We understand. We understand.
Please, Lord.
But have you not continued many officials beyond the retention period? Day in, day out, we are seeing the cases. Otherwise, we will direct you to file the affidavit now, to give list of the officers who was retained after the expiry of the retention period. If ordinarily, as you rightly said, Varadara versus so in state of Karnataka, we will follow. But here is a case where an officer appears to be an honest officer, and based upon her report, you have suspended the guilty officer.
I will verify that, your lordship. To that extent, I have to.
Something is, we can't let down honest officers like that.
I will verify.
Saying that some quoting some rule, sending them. ಹಂಗ್ ಮಾಡ್ಲಿಕ್ಕೆ ಬರಲ್ಲ.
ಅದನ್ನ verify ಮಾಡ್ತೀನಿ.
In the meanwhile, you stay. Otherwise, you continue wherever you want her to continue, but permit her to continue the investigation. Now he says, And his voice is recorded here also. Twice, thrice he said, I will not cling on to. You permit her to continue the investigation. Otherwise, who will do all these things by taking risk? The officers, honest officers, take enormous risk in this corrupt system. And she has saved money. At least in all fairness, you should have said, ನೋಡಮ್ಮ ನಿನ್ನನ್ನು ಬೇರೆ ಪ್ಲೇಸಿಗೆ ಕಳಿಸ್ತೀವಿ, ನಿಮ್ಮ ತಾಯಿಗೆ ಹುಷಾರಿಲ್ಲ, ಆದರೂ ಸಹಿತ ನಿನಗೊಂದು ಅನುಕೂಲ ಮಾಡಿಕೊಡ್ತೀವಿ. And we will continue you as the head of the team investigating the matter. If you give an impression to us that only to ensure that she ceases to be investigating officer, then it's a case of mala fide, as you rightly said. Though it may be within the retention period. It is not that you are scrupulously adhering to the retention period. Because 24/6/2024 order at the paragraph 8 gives discretion to you to extend retention period or reduce retention period in A, B, C, D circumstance. Where have you addressed that one? Suppose if you go on doing this, then rest of the things will flare up.
Lordship may kindly have it next week on. I'll verify and.
There appears to
make
be
submission.
something. She
I'll
is
make some-
agitated.
My
He is
lord.
also agitated.
I will get the instructions and make some.
Rightly.
My lord, one more fact, my lord, I may permit it to bring to your lordship notice. My lord, I was transferred, other administrative officer was suspended, his suspension was stayed. In the meantime, Kuberachari's suspension was revoked.
Person whom you recommended
Yes.
that action should be taken.
Yes, my lord.
These things we only used to read in Alice in Wonderland. Such things would happen. All this matter on the other on the date kodi, short date kodi. Avat helbek, please, now you have heard and you can download it also. If officers and protect munde yarn protect ಮಾಡ್ತೀರಿ? What Supreme Court said in that famous case of Chief Vigilance Commissioner case, most of these arguments are covered by the judgment of the apex court. That CVC versus,
Yes, my lord.
Huh?
Kerala officer, my lord.
ಆ judgment ನಲ್ಲಿ ಈ contention ಎಲ್ಲ, of course, the retention period was not the point, but if a case is made out that even after retention period, there is some mala fide. Suppose scrupulously if you follow retention period, we have no problem at all. So many cases would not have come before us. ಹಾಗಾಗಿ ಆ ಬರೀ ರೂಲ್ ಆಫ್ ರಿಟೆನ್ಷನ್ ಪೀರಿಯಡ್ ಅನ್ನ ನೀವು ಯಾವುದೋ ಒಂದು ವೇದಿಕ್ ಮಂತ್ರ ಟೈಪ್ ಚಾಂಟ್ ಮಾಡ್ಕೊಂಡು ಕೊಡಕ್ಕಾಗಲ್ಲ. ಸಮ್ ಗಿಲ್ಟಿ ಆಫೀಸರ್ ನೋಡಿ, ಅವ್ರು ಸಸ್ಪೆಂಡ್ ಮಾಡಿದ್ರಿ, ಅದನ್ನ ಸ್ಟೇ ಮಾಡ್ತು ಸುಪ್ರೀಂ ಟ್ರೈಬ್ಯುನಲ್ ಕೋರ್ಟ್. ಇನ್ನೊಬ್ರನ್ನ ಇವ್ರು ಆ ರಿಪೋರ್ಟ್ ಮೇಲೆ ಯಾರನ್ನ ಸಸ್ಪೆಂಡ್ ಮಾಡಕೊಂತ ಮಾಡಿದ್ರೆ ಅವ್ರಿಗೆ ಸಸ್ಪೆನ್ಷನ್ ರಿವೋಕ್ ಮಾಡಿ ಯು ಟ್ರಾನ್ಸ್ಫರ್ ದಟ್. ಏನ್ ಅಡ್ಮಿನಿಸ್ಟ್ರೇಷನ್, though it's not our concern, but if too much bad water is brought,
That kind of impression is given.
giving on records it is being given, not just argument. ನೋಡ್ಕೊಂಡು ಹೇಳಿ
Please.
ಅಂತ ಆಫೀಸರ್ಸ ಇಲ್ಲ ಈಗ, ಎಲ್ಲ ಸಕಂಬಾಗೋದು ಹೆದರೋದು ಅವಾಗೆಲ್ಲ ಇಂಥದೇ ಇದ್ದಾರೆ. 13th November. Yes.
Respond.
ಏನ್ ಮಾಡ್ತೀರಿ ಪ್ರಶಾಂತ್ ಚಂದ್ರ?
ಅವ್ರೇನೋ ನಮ್ದು ಮಾರ್ಕೆಟ್ ವ್ಯಾಲ್ಯೂ ಬಗ್ಗೆ ತಮ್ಮ ಹತ್ರ ಡಾಕ್ಯುಮೆಂಟ್ ಅಂತ ಹೇಳಿದ್ರು. ಅದಿಲ್ಲ ಅಂದ್ರೆ ನನ್ನ ಆಪ್ಷನ್ಸ್ ಇದೆ.
But he's tried to get the document, madam, all the localities.
ನೋಡ್ರಿ ಅವ್ರು ಹೇಳ್ತಾ ಇದಾರೆ,
ಹಾ.
ಸುಮ್ನ ಅಮೌಂಟ್ ಇಸ್ಕೊಳ್ಳಿ,
ಆಯ್ತು.
ಮುಗಿಸ್ಕೊಳ್ಳಿ, ಮತ್ತ ನಾವು ಅಡ್ಮಿಟ್ ಮಾಡಿ ಅವರು ಅಷ್ಟು ಈಜಿಲಿ ಬಿಡಲ್ಲ. ಮತ್ತೆ ಅಡ್ಮಿಟ್ ಮಾಡಿ 5 ವರ್ಷ ಇಟ್ವಿ ಅಂದ್ರೆ ತುಂಬಾ ಮೇಸ್ಟ್ರಿಗೆ ಅನ್ಯಾಯ ಆಗ್ತದೆ.
ಹೌದು.
ಅದ್ರ ಬದ್ಲಿ ಮೇಸ್ಟ್ರಿಗೆ ಹೇಳಿ.
Please.
ಒಂದು ಶುಕ್ರ ನೀತಿಯಲ್ಲಿ ಒಂದು ಶ್ಲೋಕ ಇದೆ, ವೆರಿ ಆಫನ್ ಐ ಕೋಟ್ ಇಟ್. ವಿನಾಶಕಾಲೇ ಸಮುತ್ಪನ್ನೆ ಅರ್ಧಂ ತ್ಯಜಿತ ಪಂಡಿತ. ಊರ ಹೋಗುವಾಗ ಯಾವನು ಅರ್ಧ ಉಳಿಸಿಕೊಳ್ಳುವನೋ ಅವನೇ ಜಾಣ ಅಂತ ಹೇಳ್ತದೆ.
Yes, madam.
ನೀವು 5 ವರ್ಷ ಬಿಟ್ಕೊಂಡು ನೀವು ಹೇಳಿದ ಅಮೌಂಟ್ ಕೊಟ್ಟರು ಇವ್ರು ಹೇಳೋಕ್ಕಿಂತ ಕಡಿಮೆ ಆಗ.
We are ready, please.
ಒಂದು
Okay.
ಎಷ್ಟು ಅಮೌಂಟ್ ಕೊಡ್ತೀರಿ?
I make 2 offers. 1,50,000 is his amount. 10 ವರ್ಷ ಆಗಿಲ್ಲ ಇನ್ನು, 10 ವರ್ಷ ನಾನು ತಗೊಳ್ತೀನಿ. I am calculating at 30% interest.
ಫಾರ್ ದ ಪರ್ಪಸ್ ಆಫ್ 18 ಅಲ್ಲ 15 ಅಲ್ಲ 30%. ಇಟ್ ಕಮ್ಸ್ ಟು 75,000 per year ಏನೋ ಬರುತ್ತೆ. ಅಲ್ಲ 15 15 ವಾಟ್ ಎವರ್ ಇಟ್ ಈಸ್ ಇಂಟು 10 years ಇಟ್ ಕಮ್ಸ್ ಟು ಅಬೌಟ್ 4.5 lakhs ಪ್ಲಸ್ ಇನ್ ಪ್ರಿನ್ಸಿಪಲ್ 6 lakhs ಆಗುತ್ತೆ. 2.12 is already deposited in another court, writ petition. ಅದನ್ನು ಮೈನಸ್ ಮಾಡಿ ನಾವು ಉಳಿದಿದ್ದು ಕೊಡ್ತೀವಿ. ದಟ್ ಕಮ್ಸ್ ಟು ರಫ್ಲಿ ಅಬೌಟ್ 3.8 lakhs ಬರುತ್ತೆ.
ನೋಡ್ರಿ, ನಾವೊಂದು ಹೇಳ್ತೇವೆ.
ಆಗ್ಲಿ ಸರ್.
ನಾವು ಬರೀ ಅಂಪೈರ್ಸ್ ಅಲ್ಲ.
ಗೊತ್ತಾಯ್ತು.
We are participants in the judicial process.
Correct.
ನಾವು ಹಿಂಗೆ ಹೇಳ್ತೀವಿ ಅಂತ ನಮ್ಗೆ ಇಂಟ್ರೆಸ್ಟೆಡ್ ಅಂತ ಇಟ್ಕೋಬೇಡ್ರಿ.
ಅಲ್ಲ,
ಯಾವ
ನಾನು-
ಕೇಸ್ನಲ್ಲೂ ನಮ್ಗೆ
ಇಲ್ಲ,
ಇಂಟ್ರೆಸ್ಟ್
ಇಲ್ಲ,
ಇಲ್ಲ
ಇಲ್ಲ.
ಎಕ್ಸೆಪ್ಟ್ ಡಿಸೈಡಿಂಗ್ ದ ಮ್ಯಾಟರ್ಸ್.
ಅಷ್ಟೇ ಸರ್. ನಾನು ಐ ನಾಟ್ ಗೋಯಿಂಗ್ ಆನ್ ದ ಮೆರಿಟ್ ಆನ್ ದಟ್ ಅಷ್ಟೇ. ನಂದು ಆಲ್ಟರ್ನೇಟ್ ಆಫರ್ ಹೇಳ್ಬಿಡಲ್ಲ ಸ್ವಾಮಿ, ನಾನು ನೋಡಿದ್ಮೇಲೆ ಚೇಂಜ್ ಮಾಡಿದೆ ಅಂತ ತಾವು ಹೇಳ್ಬಾರ್ದು.
ಒಂದು ನಿಮಿಷ. ಎಸ್,
ಐ ಆಮ್ ರೆಡಿ ಟು ಗಿವ್ ಇಮ್ ಮೈ ಸೈಟ್ ಇನ್ ಅನ್ ಅಬಟ್ಟಿಂಗ್ ಲೇಔಟ್ ಆಫ್ ಮೈ ಓನ್.
ಸೈಟ್ ಬೇಕು. ಕರೀರಿ
ಕೊಡ್ತೀನಿ.
ಮೇಸ್ಟ್ರೆ, ಬರೀ.
ಐ ಪುಟ್ ದ ಸರ್ವೆ ನಂಬರ್.
ಅಲ್ಲಿ ಮಗ್ಲಲ್ಲಿರುವಂತ ಅಬೆಟಿಂಗ್ ಸೈಟ್ ಲೇಔಟ್ ನಲ್ಲಿ ಸೈಟ್ ಕೊಡ್ತೀವಿ ಅಂತ ಹೇಳ್ತಾ ಇದ್ದಾರೆ. ತೊಳಿ.
ಇಲ್ಲ ಸರ್,
ಹಂಗಾರೆ ದುಡ್ಡು ಇಸ್ಕೊಳ್ಳಿ.
ಅದರೊಳಗೆ ಬೇಕು. ಇಲ್ಲ, ಒಂದು 15 ಲಕ್ಷ
ಹಂಗೆ ಕೊಡ್ಲಿಕ್ಕೆ ಬರಲ್ಲ. ಒಂದು ಪ್ರಿನ್ಸಿಪಲ್ ಇರ್ತದೆ ಕ್ಯಾಲ್ಕುಲೇಷನ್ಗೆ. ನಾವೇನೋ ಆರ್ಗ್ಯುಮೆಂಟ್ನಾಗ ಅವ್ರಿಗೆಲ್ಲ ಸ್ವಲ್ಪ ಹೆದರಿಸಿ ನಾವೇನೋ ಒಂದು ಕಳ್ಸಿ ಜಸ್ಟಿಸ್ ಮಾಡೋಕಂತ ಹೊಂಟಿರ್ತೀವಿ. ಅದನ್ನ ಗಟ್ಟಿ ಹಿಡ್ಕೊಂಡು ಕೊಡೋದಲ್ಲ. ನಾವು ರೂಲ್ಸ್ ಬಿಟ್ಕೊಂಡು ಮಾಡಕ್ ಬರ್ತದ.
ಬಹಳ ಇಂಪ್ರೂವ್ಮೆಂಟ್.
ಅವ್ರು ನಾರ್ಮೇಟಿವ್ ಬೇಸಿಸ್ ಹೇಳ್ಯಾರ, ಯಾವ ಕಾರಣಕ್ಕೆ ಎಷ್ಟು ದುಡ್ಡು ಕೊಡ್ತೀವಿ ಅಂತ. ನಿಮ್ಗೆ ಆಪ್ಷನ್ ಕೊಟ್ಟು ನಿಮ್ಗೆ ಸೈಟ್ ಬೇಕು ಅನ್ನೋದು ನಿಮ್ ಕೇಸು, ಕೊಡ್ತೀವಿ ಅಂತ ಇದಾರೆ. ಸೈಟ್ ತೊಳಿ.
ಅದ್ರಾಗೆ ಕೊಡ್ಬೇಕು ಸರ್.
ಹಂಗೆ ಹೇಳಕ್ಕಾಗಲ್ಲ.
ಎಲ್ಲಿ ಹೇಳಿದ್ರು?
ಅದೇ ಬೇಕು ನೋಡಿ.
ಸೈಟ್ ಇದಾವೆ.
ಅವ್ರು ಹೇಳ್ತಾ ಇದ್ದಾರೆ. ಮತ್ತೆ ನೋಡಿ, ಮತ್ತೆ ಕೊಡಂಗಿದ್ರೆ ನೀವು ಅವ್ರು ಎಸ್ ಅಂತ ಇದ್ದಾರೆ. ಎರಡು ಆಪ್ಷನ್ ಸರಿ ಅನಿಸ್ತದೆ. ಒಂದ್ ಸ್ವಲ್ಪ ಈಗ ನೋಡ್ರಿ ಚೀಟಿ ಬಟ್ ಹಾಕ್ರಿ, ಮುಗಿಸ್ಬಿಡ್ರಿ. ಪ್ರಶಾಂತ್ ಚಂದ್ರ ಇಡಬೇಡಿ.
ಒಂದು ನಿಮಿಷ ಸರ್.
ಅಷ್ಟೇ ಆಗತ್ತದು. 1.5 ಪ್ಲಸ್ ಬರೀ ಇಂಟ್ರೆಸ್ಟ್ ಹಾಕಿದ್ರೆ ಅಷ್ಟೇ ಅಲ್ಲ ಅದು.
ಗೊತ್ತಾಯ್ತು. ಎಲ್ಲೋ ಒಂದ್ ಕಡೆ ಇಟ್ ಹ್ಯಾಸ್ ಟು ಬಿ ರಾಟಿಫೈಡ್.
somewhere see the sense of justice ಏನ್ ಗೊತ್ತಾ, ಅವರು ಫಸ್ಟ್ ಪಾಯಿಂಟ್ ನಾ ಹೇಳ್ತಾ ಇದ್ದೀನಿ, ವಿಚ್ ಐ ಆಮ್ ಸೇಯಿಂಗ್ ಇಟ್ ನಾಟ್ ಜಸ್ಟ್ ಫ್ರಮ್ ಕೃಷ್ಣ ದೀಕ್ಷಿತ್ ಪಾಯಿಂಟ್ ಆಫ್ ವ್ಯೂ. ಐ ಆಮ್ ಸೇಯಿಂಗ್ ಇಟ್ ಫ್ರಮ್ ಐಡಿಯಾ ಆಫ್ ಜಸ್ಟಿಸ್ ಬೈ ಅಮರ್ತ್ಯ ಸೇನ್, which secured him the Nobel Prize. It's a book famously written in contrast with the John Rawls theory of justice. ಅದಕ್ಕೆ ಮಾಡ್ಕೊಂಡು ಮಾಡಿದ್ದು. ಅವ್ರು ಹೇಳೋದೇನು ಅಂದ್ರೆ, ಒಂದು ಸೆನ್ಸ್ ಆಫ್ ಜಸ್ಟಿಸ್ ಅನ್ಕೊಂಡು ಎಲ್ಲ ಮನುಷ್ಯರ ಮನಸ್ಸಿನಲ್ಲಿ ಆಪರೇಟ್ ಆಗ್ತದೆ. ಹಾಗಾಗಿ ಜಜ್ಮೆಂಟ್ಗಳನ್ನು ಬರೆಯುವಾಗ ಸೆನ್ಸ್ ಆಫ್ ಜಸ್ಟಿಸ್ ಅನ್ನು ಅಡ್ರೆಸ್ ಮಾಡಬೇಕು ಅಂತ ಬರೀತಾರ ಅವರು. ಒನ್ ಆಫ್ ದ ಫೇಮಸ್ ಆಥರ್ಸ್, ಡಾಕ್ಟರ್ ಬಕ್ಷಿ, ಉಪೇಂದ್ರ ಬಕ್ಷಿ, ಅಂಡ್ ಗ್ರೇಟ್ ಪ್ರೊಫೆಸರ್ ತ್ರಿಪಾಠಿ, ಪ್ರೊಫೆಸರ್ ಅಜ್ಜಪ್ಪ, all they have praised him. It's a very good book, I tell you. From that, I am taking a leaf. Therefore, exactly arithmetical calculation prakara agalla. We can only quote Shakespeare's Merchant of Venice, where Portia says, one drop of, not even a drop of, only 1 pound of flesh to Shylock. Only 1 pound of flesh, but not shedding 1 drop of blood to the ground. It's not possible. Right? ಸ್ವಲ್ಪ ಅಡ್ಜಸ್ಟ್ಮೆಂಟ್ ಆ ಕಡೆ ಈ ಕಡೆ ಮಾಡ್ಕೊಂಡು ಹೋಗ್ಬೇಕು. ನಿಮ್ ಕ್ಲೈಂಟಿಗೆ ಇದನ್ನ ಹೇಳ್ತಾ ಇರೋದು ನಾವು. Through you.
ತಾವು ಮೀಡಿಯೇಟ್ ಮಾಡ್ತಾ ಇದ್ದೀರ.
You are a master in that.
ಸ್ವಾಮಿ, ಒಂದೇ ಒಂದು. What he has paid is 60% of the total amount. What Lordship probably has calculated the full amount of the site.
ಇಲ್ಲ, ನಾವು ನೋಡಿದ್ದೇವೆ. ಇಲ್ಲ, ಫುಲ್ ಅಲ್ಲ.
ನಾನು ಅದರ 60% ನಾನು ರೆಡಿ ಇದೀನಿ ಅಷ್ಟೇ. ಅಂದ್ರೆ 6 ಲಕ್ಷ ಆಗತ್ತೆ.
ಬರಲ್ಲ. ನಾವು ಅದಕ್ಕೆ ಈ ಅಮೌಂಟ್ ಅನ್ನ ಹೇಳಿದ್ದೀವಿ. ನೋಡಿ, ಎಂಥ ಒಳ್ಳೆ ಕೇಸ್ ಇದ್ರು ಸಹಿತ ultimately we are human beings. Judges are not computers. We are human beings. Sense of justice operates at the rock bottom of our mind.
I agree.
ಅದನ್ನ ನಾವು ಯಾವ ರೀತಿಯಿಂದ ultimately decisions are made by us. Then reasons are supplied subsequently to sustain the decisions. ಮನುಷ್ಯರು ನಾವೆಲ್ಲ something, he is a builder, we understand. But ಈ ಆರ್ಡರ್ಗಿಂತ ಫಾರ್ ಬೆಟರ್.
ಐ ಅಗ್ರಿ.
ಬಟ್
ಅವನೊಂದ್ಸರಿ ಕೇಳ್ಬೇಕಾಗತ್ತೆ ಅಷ್ಟೇ. ನಾನು
ಮಧ್ಯಾಹ್ನ ಕರೀಲಾ? ಮಧ್ಯಾಹ್ನ ಕರಿತೇವೆ. ಮತ್ ಮುಂದೆ ಹಾಕೋದ್ ಬೇಡ. ಈಗಾಗಲೇ
ಆಗ್ಲಿ ಸರ್. ಆಗ್ಲಿ ಸರ್.
ನೋಡ್ರಿ, ಅವ್ರಿಗೆ 10 ಲಕ್ಷ ರೂಪಾಯಿ ನಾವು ಹೇಳಿದ್ದೇವೆ. ನೀವು ಅದಕ್ಕೆ ಒಪ್ಪಂಗಿದ್ರೆ ಒಂದ್ ನಿಮಿಷ ಹೋಗ್ಬಿಟ್ಟಿರಿ. ಅವ್ರು ಒಪ್ಪಲಿದ್ರೆ ಆರ್ಗ್ಯೂ ಮಾಡಿ ಮುಗಿಸ್ಬಿಡಿ, ಇಲ್ಲೇ ಮುಗಿಸ್ಬಿಡ್ರಿ.
The maintainability according to section
ಬಿಡಿ ಅದನ್ನೆಲ್ಲ. ಆ ಮೇಂಟೈನಬಿಲಿಟಿ
10 lakhs is
ಹೋಗ್ಬಿಡ್ತದೆ
ready,
ಅವ್ರು
ma'am.
ಹೇಳೋದಕ್ಕೀಗ. Because he is gracefully saying will
Yes,
consider.
madam. 10 lakhs is ready.
ಅಷ್ಟ್ ಮಾಡ್ಕೊಡ್ರಿ ಮುಗಿಸೋಣ. ಈ ಜೀವನದಾಗ ಎಲ್ಲರಿಗೂ ಬಹಳಷ್ಟು ತೊಂದರೆ ಆಗ್ತದೆ. ಏನ್ ಮಾಡಕ್ ಬರ್ತದೆ? ಎಲ್ಲೋ ಜೂ ನೋಡ್ಲಿಕ್ಕೆ ಹೋಗಿರ್ತೇವಿ, ಅಲ್ಲೊಂದ್ ಯಾವ್ದೋ ಮಂಗಿನೋ ಎಂತದ ಒಂದ್ ನಮ್ಗೆ ಕಚ್ಚಿ ಬಿಡ್ತದೆ. ಅವೆಲ್ಲ ದೀಸ್ ಆರ್ ಲೈಫ್ಸ್.
Only one submission, sir.
ಇದರ್ ಏನ್ ಮಾಡ್ಲಿಕ್ಕಾಗಲ್ಲ.
Including the 2.2 which is into.
ಹೌದು
ಆಗ್ಬೋದು.
ಹೌದು
I'll care.
ಇನ್ಕ್ಲೂಡಿಂಗ್ ದಟ್ ಒನ್ ಓನ್ಲಿ. ನೀವು ಕನ್ವಿನ್ಸ್ ಮಾಡು.
ಮತ್ತೆ 10+2 ಅಂದ್ರೆ ಆಗ್ಬಿಟ್ರೆ ಅಲ್ಲ ಅದ್ ಮಾಡೇ ಇಲ್ಲರೂ ಕರ್ಕೊಂಡ್ ಬಂದಿದ್ದು ನಾವು, ಇಲ್ಲರೂ ಕೊಡೋದಿಲ್ಲ ಅನ್ಕೊಂಡಿದ್ರು ಅವರು. We have to tell the merits of the merit.
ಏನಪ್ಪ ಟೀಚರ್ ಏನೋ ಒಂದು 4 ಅಕ್ಷರ ಕಲ್ಸ್ಯಾರ ಮಕ್ಕಳಿಗೆಲ್ಲ, ಇಲ್ಲಿ ಒಂದ್ ಕಡೆ ಉಪಯೋಗ ಆಗ್ತದೆ. ಆಗ್ಲಿ 10 ಲಕ್ಷ ರೂಪಾಯಿ ಇಸ್ಕೊಳ್ಳಿ, ಬರ್ರಿ ಮತ್ಕೊಂಡು ಹೇಳಿ.
ಅಲ್ಲ ಕೇಳ್ಬಿಟ್ಟು
ಕೇಳ್ಕೊಂಡು ಹೇಳಿ.
obliged.
There is one more connected matter.
ನಂದು ಅದು ಲಿಸ್ಟ್ ಹೋಯ್ತಾ ನಂದು. Sometimes we throw the baby along with the bath water. ಲಿಸ್ಟ್ ಅಲ್ಲೇ ಇರ್ಬೇಕು. Yes, brother.
There is one more connected
All
matter.
this matter along with WP number in the second week of January 2025. Next. ಮುಖಂಡಪ್ಪ ಬನ್ನಿ. And for the respondent.
Matters regarding absorption, my lord, I need to take instructions, connected matters.
All in the second week of January at the request of. Yes. Andre? Head.
The only issue is here, my lord, with regard to grade pay.
Grade pay.
Grade pay, my lord, whether 4,800 or 5,400, it's a question, my lord. In fact, my lord, as per annexure A4, in page 66, my lord, he has been appointed as an administrative officer, my lord.
ಅಲ್ಲಿ 39/2022 order of the tribunal ಅದನ್ನ ಚಾಲೆಂಜ್ ಮಾಡಿದ್ರಾ? Come to page 36, 36.
36, my lord. Please, my lord.
Read para 3.
That is application number 511, my lord.
Yes.
Order.
Yes. On your submission, this order is made. How can you file appeal? Assuming there are some mistakes in the order. If an order is passed
that is-
consensually, no right of appeal.
Actually, my lord, that is coming in my way.
It stands in your way. It stands in our way also, if we want to give relief to you.
The problem is, my lord,
It favors his way.
no doubt, my lord, problem is advocate have, but
ಅವೇನ್ ಮಾಡಿ
throughout our case, my lord, you have filed a objection also, my lord.
ನೀವು ಫೈಲ್ ಕೇಸ್ ಅಗೇನ್ಸ್ಟ್ ದಿ ಅಡ್ವೊಕೇಟ್. ಆ ಸ್ಟ್ಯಾಂಡ್ ಇಂದ ನಮಗೆ ಅನ್ಯಾಯ ಆಗಿದೆ ಅಂದ್ರೆ
ಅಲ್ಲಲ್ಲ.
ಆಫ್ ಆಕ್ಷನ್ ಸಿಗ್ತದೆ. Advocates are covered under the Consumer Protection Act. Proceed against them. But when you say to the court or the tribunal,
And that is the-
ಈ ರೀತಿ ಇದೆ, ಈ ಪ್ರಕಾರ ಆರ್ಡರ್ ಮಾಡಿ
we-
ಅಂತ
we-
ಹೇಳಿದ ಮೇಲೆ
we have got responsibility.
ಫಾಲ್ಟ್ ಇದೆ. Consensual position ಆಗ್ತದೆ, which court will put only its seal to that. It may be, if merit ಮೇಲೆ argue ಮಾಡಂಗಿದ್ರೆ, you perhaps
They will give
available.
reasoning.
But because of your stand, you are stopped from contending that. ಅಲ್ಲಿ ಹಂಗ ಹೇಳಿ ಇಲ್ಲಿ ಬಂದು ಚಾಲೆಂಜ್ ಮಾಡ್ಲಿಕ್ಕೆ ಬರಲ್ಲ ಅಷ್ಟೇ. ಏನಿಲ್ಲ. That's why. ಹೌದು. ಆ ಆರ್ಡರ್ ನಲ್ಲಿ ಅವ್ರು ಹೇಳಿದ್ದು ಕರೆಕ್ಟೇ ಇದೆ. ದಿ ಟ್ರೈಬ್ಯುನಲ್ಸ್ ಆರ್ಡರ್ ಇನ್ OA 511 of 2021 ಇದೆ ಅಲ್ಲ, ಅದು ಸ್ಕ್ವೇರ್ಲಿ ಕವರ್ ಆಗತ್ತೆ. ಅದರ್ವೈಸ್ ಆಲ್ಸೋ
No, they referred, my lord, that Subramaniam case. There, my lord, our case is, my lord, it's a central exercise matter, so employee. But here, Doordarshan, my lord, there is a separate order, my lord, with regard to this grade pay, my lord.
ಪೇ ಮಾಡ್ಲಿಕ್ಕೆ ಬರಲ್ಲ.
That has not been challenged and that has not been discussed there in that case.
ಸಟ್ರೆ ಏನ್ ಮಾಡ್ಲಿಕ್ಕೆ ಬರಲ್ಲ ಇದು. ನಿಮ್ ಸ್ಟ್ಯಾಂಡ್ ಹಂಗಿತ್ತಲ್ಲಿ.
ಇಲ್ಲ, ತಾವು ಹೇಳಿದಾಗೆ ಆ 511 ಆರ್ಡರ್ ಅದನ್ನೇ ನಾವು ಚಾಲೆಂಜ್ ಮಾಡಿಲ್ಲ.
ಅದ್ ಮಾಡಿಲ್ಲ.
ಅದ್ ಮಾಡಿದ್ರೆ ಇದನ್ನ
ಇದು ಮಾಡಕ್
ವಿ ವಿಲ್ ಹ್ಯಾವ್ ಸಮ್
ಮಾಡ್ಲಿಕ್ಕೆ ಬರಲ್ಲ.
ಅದು ಅಬ್ಸರ್ವೇಷನ್ ಮಾಡಿ ಒಂದು
ಅಷ್ಟೇ ಬರ್ಕೊಳ್ಳಿ. The central government and its officials are knocking at the doors of writ court for assailing service tribunal's order dated 19/12/2022, whereby private respondents OA number 272/2021, ಕುತ್ಕೊಳ್ಳಿ, having been favored, the following relief has been granted to him, him or her? Him. First, para 5 ಇದೆ ನೋಡಿ, page 36, para 5. Yellow ಮಾಡಿ. Next para. Learned senior panel counsel appearing for the petitioners vehemently submits that the subject matter of the list which the tribunal treated in OA number 511/2021,
that is page number
disposed of on
2008
30 September 2022,
208 ಅಲ್ಲಿ ಇದೆ ಪೇಜ್ ನಂಬರ್ annexure F mine order
was a bit different case, and case of the private respondent did not fall within its precincts. Semicolon. That being the position, the panel counsel, that is his counterpart who appeared before the tribunal, committed error, and that error needs to be rectified by this court in its constitutional jurisdiction. ಬೇರೆ ಏನ್ರ ಇದೆಯಾ?
ಎರರ್ ಅಂತ ಹೇಳೋದು ಆ ವರ್ಡ್ ನಮ್ಮ ಕಲೀಗ್ಸ್ ಅಲ್ವಾ?
ಅಲ್ಲಿ appears to have committed, appears to appears to have wrongly stated to the contra. Semicolon. That being the position, a constitutional court cannot turn its Nelson's eye to the palpable mistake demonstrable from records, and therefore the impugned order of the tribunal warrants invalidation. First, Mr. Palla, representing the learned counsel, representing the private respondents, with equal vehemence submits that case of his client is substantially similar to the one treated in OA number 511/2021, semicolon. Very fairly, the counsel who represented the petitioners before the tribunal therefore had said, had taken the stand accordingly, semicolon. Even otherwise, a particular stand having been taken before the tribunal, comma, now it is not open to the petitioners to contradict the same. First, so contending, he seeks dismissal of the writ petition. Enaru bere enra idiya?
You know merits of the case, but not necessary.
First, he also submits that even on merits, the stand of his client is demonstrable, and therefore impugned order cannot be altered. Idna hakondu last line. Having heard the learned counsel for the parties and having perused the petition papers, we are broadly in agreement with the submission made by Mr. Valla on behalf of the private respondent herein. First off, it hardly needs to be stated that the advocates are not the mouthpieces of their clients, nor they are their loudspeakers. First off, they are officers of the court from the days of Lord Bacon, Francis Bacon. Full stop. Both on facts and on law, they are entitled to make fair submissions regardless of its impact on the interest of their clients. First up, an argument to the contrary would undermine the glory of institution of advocates. First up, in the above circumstances, this petition is liable to be and accordingly dismissed, parts having been made easy. ಅಲ್ಲಿ ಇಂಪ್ಲಿಮೆಂಟೇಶನ್ ಎಷ್ಟು ದಿವಸದಲ್ಲಿ ಮಾಡ್ತೀರಿ? ಮತ್ತೆ ಅದಕ್ಕೊಂದು ಕಂಟೆಂಪ್ಟ್ ಇದೆಲ್ಲ ಬೇಡ, ಎಷ್ಟು ದಿವಸದಲ್ಲಿ ಅಂತ ಹೇಳಿ. ಅವ್ರು ಎಷ್ಟು ಕೊಟ್ಟಿದ್ರು ಟ್ರೈಬ್ಯುನಲ್ನವರು?
ಅಲ್ಲಿ ಆಕ್ಚುಲಿ ಕ್ಯಾಲ್ಕುಲೇಷನ್ ನೋಡಾಗ ಇವ್ರ ಕೇಸಲ್ಲಿ ಜಾಸ್ತಿ ಬರಲ್ಲ, ನಮ್ಗೆ ಇದು ಆಲ್ ಓವರ್ ಇಂಡಿಯಾ ಇಂಪ್ಯಾಕ್ಟ್ ಆಗುತ್ತೆ. ಇವರದಲ್ಲಿ ತುಂಬಾ ನೆಗ್ಲಿಜಿಬಲ್ ದಟ್ ವಿ ವಿಲ್ ಡೂ.
ದಿ ಅಲ್ಲೊಂದು ಸೆಂಟೆನ್ಸ್ ಬರ್ಕೊಳ್ಳಿ.
2 months.
The benefit granted by the relief granted by the tribunal in terms of the mandate shall be accorded to the respondent within an outer limit of
2 months.
2 months. 2 months. And delay if brooked would carry interest at the rate of 1% per mensem for the first 2 months and 2% for the period next following. First off, the interest component may be extracted from the erring officials of the department personally. First off, last thing, we make it clear that the order of the tribunal and our order is confined to parties before us.
Please.
Yes, brother.
I'm appearing for
Huh?
petition, my lord.
ಏನು?
Rest time 2 weeks, sir.
ಏನಂತೆ?
He praying for
Rest
time,
time.
lord.
Time. ಯಾಕೆ ಏನಂತ ಬಹಳ ಸಿಂಪಲ್ ಇದೆ, ಬಹಳ
Senior friend,
Huh?
son is expired sir, today.
expired.
Yes. I request my lord to have this next week because
Next week
the
ಆಗಲ್ಲ
reason is
brother.
this, my lord. Only
ಬಹಳ
thing is
ಮ್ಯಾಟ್ರಸ್ ಇದಾವೆ. ನೀವು ಇದ್ದೀರ ಯಾವ್ದೋ ಒಂದು ಹೆವಿ ಮ್ಯಾಟ್ರಸ್. The second
lecturer
week of,
is, my lord, absorbed in the social tribal welfare department. Lecturers don't want to go back.
second
to
week of January. Second week of January. Yes. Yes.
This is regarding refixation of pay, my lord.
ಏನಾಗಿದೆ?
Annexure A6 was challenged before KT, my lord.
Ah.
That is in page 127 of the writ petition. Notional pay was fixed, my lord. The order of the KT is at page number 16, my lord.
Come
My lord,
to page
he
20.
was appointed as AE, my lord.
Come to page 20.
Please, my lord.
Last 6 lines from the bottom.
Yes, my lord.
The grant of retrospective, read that.
The grant of retrospective promotion is a discretionary action covered by rules made in this behalf under the 1973 enactment, which are 1978 rules. In terms of 1978 rules, where a government servant has been placed in independent charge of a higher post under Rule 32, KCSRs, to the which post he alone could have been posted, had been substantively promoted instead of placing in independent charge, and has held the post on independent charge basis until the substantive promotion to the said post, he is entitled to the benefit of retrospective promotion under the KSCS RPP rules 1978. In the instant case, the
It
applicant
was a
has
case
been-
of independent charge.
Yes, my lord. I was, in fact, my lord, placed under Rule 32 in 2009. That, my lord, I have
In
continued.
charge or independent charge?
In rule 32, in charge, my lord, independent
Independent.
charge.
Independent
Yes.
charge.
And,
Charge ಇದ್ರೆ full only in-charge allowance ಸಿಗ್ತದೆ.
ಇಲ್ಲ ಇಲ್ಲೂ ಕೂಡ in charge allowance ಕೊಟ್ಟಿರೋದು.
ಏನ್ ಡಿಫರೆನ್ಸ್ ಎರಡಕ್ಕೂ in-charge, independent charge?
My lord, I'll be discharging the duties of an assistant executive engineer, but
Okay.
not a regular promoter.
Okay.
Here, my lords, my promotion is considered on 16/4/2018. Though, my lord, I was placed under Rule 32 on 3/9/2009. I've continuously worked in the, till they consider my claim for promotion on a regular basis, my lord, with retrospective effect from 3/9/2009. Lord, they are not disputing it, my lord, they have accepted the promotion which is given to me with retrospective
Because
effect.
you have worked under that.
Yes. The observation of the Honorable Tribunal is also, my lord, the paragraph 4, 5 and 6, my lord. If my lords permit me to read the paragraph 4 to.
But independent charge allowance will be less than,
Yes, not a regular
because in
payment.
addition to your actual salary
Yes.
plus
And
independent charge.
also there is an observation of the Honorable Tribunal, my lords, with regard to deducting the additional, the charge allowance which was given to me. After that only my salary pay has to be fixed.
That you
is
have
the
to give
observation.
back. That you have to give back.
Yeah,
Charge allowance you have to give back.
yes, that they can deduct it and they can fix my salary in.
He is the only person entitled to be promoted to the next higher cadre, but not promoted, but placed in independent charge. Subsequently, when you give retrospective promotion, he is entitled, that charge allowance he has to give back. Whole salary he will take, arrears of
Yes.
salary he will take.
Yes.
But it is very sensible, because in one
My lord,
case,
my ground is that, my lord, after he withdraws the charge allowance, my lord, subsequently after the retirement, my lord, he cannot claim the
when
arrears
that
of-
money belongs to the citizen. See, in
Yes, my
one case,
Please, my lord,
Gujarat, High Court of Gujarat versus
please, my lord.
State of Gujarat. The Supreme Court say,
Yes, my lord.
even prisoners who are made to work in the prison as part of the punishment,
Please, my lord.
they should be paid the wages. ಅಲ್ಲಿಗೆ ಹೋಯ್ದೇವೆ ನಾವು ಡಾಕ್ಟ್ರಿನ್ ಅಗೇನೆಸ್ಟ್ ಬೇಗಾರ್ ಇದೆಯಲ್ಲ ಇನ್ ಆರ್ಟಿಕಲ್ 23 of the constitution.
Please, my
The
lord.
state of Gujarat ತೆಗಿರಿ, the High Court of Gujarat versus ಯಾವ್ದದು ಗೂಗಲ್ ನಲ್ಲಿ ಹೋಗಿ. Begar level, begar means making a person to work for the without remuneration or for lesser remuneration.
Please, my lord.
If that amount is denied to him,
Please, my lord.
that would be violative of article 23. 23 violate ಆಗ್ತದೆ.
Paragraph 7 of the judgment, my lords, of the Honorable Tribunal,
promoted,
page
my lord.
23. If my lords may, for a moment, my lord, it is expected, page 23, my lords. It is expected that pay fixation and arrears are accorded within 3 months of the order of promotion. It has not been done by the respondents. In the case of promotion to the cadre of Assistant Executive Engineer on 16/4/2018, it should have been ordinarily done at latest by 1/8/2018.
After deducting charge allowance.
Yes, that is the, my lord, observation made by the tribunal. I'm not denying it, my lord, and they have not disputed that, my lord, I have been given promotion in 2018 with effect from 2009.
Interest ಎಷ್ಟು ಆರ್ಡರ್ ಮಾಡಿದ್ದಾರೆ?
That may 8%.
ಇಂಟ್ರೆಸ್ಟ್ ಕೊಡೋದು ಬೇಡ. ಇಂಟ್ರೆಸ್ಟ್ ಬಿಟ್ಟಾಗಿ.
The retired official.
ಅಲ್ಲ
my lord,
ಕರೆಕ್ಟ್, ಏನಾಗ್ತದೆ ಗೊತ್ತಾ, ಇದ್ರ ಮೇಲೆ ಹೆಚ್ಚು ಲಾಸ್ ಸೆಟ್ಲ್ ಆಗಿಲ್ಲ. ಕಂಪ್ಲೀಟ್ ಇದು ಫಸ್ಟ್ ಆಫ್ ಇಟ್ಸ್ ಕೈಂಡ್ ಇದು ಈ ಜಡ್ಜ್ಮೆಂಟ್ ಆಕ್ಚುಲಿ. ಬಟ್ ವಿ ಅಕಾರ್ಡ್ ವಿತ್ ದಟ್ ಜಡ್ಜ್ಮೆಂಟ್.
I bow down to your lordship's observation.
Lord,
ಈಗ
2009
if you
my
agree
lord.
to give that money, then interest we will saying that you have argued very well.
My lord.
Ah.
May I make one submission, my lord? 2009, my lord, he was given independent charge
Correct,
under Rule 32, my lord.
correct.
He cannot claim from 2009, my lord, because he
Wait.
was placed in a
When did you place him in independent charge?
2009, my lord.
ಮತ್ತೆ ಅವಾಗಿಂದ ಕೊಡ್ಬೇಕಾಗತ್ತೆ. Because he has discharged in B.N. Dhotrar,
Yes, my
even
lord.
this aspect is, that was a matter which I had argued.
Please.
Even that aspect is considered. Independent charge ಅಂದ್ರೇನು? In charge ಅಂದ್ರೆ, though he did not answer it properly.
Please, my lord.
Independent charge ನಲ್ಲಿ, he functions in that post itself, not as a, day-to-day routine ಅಲ್ಲ. He
Only in charge.
discharged its substantive duties also.
responsibilities.
Substantive promotion yavag barat, that is, from then, my lord, he will be entitled for the.
No, under the rule, you have given him promotion with retrospective effect.
Yes.
Why you gave it? Because
Please, Lord.
he worked in that post in independent charge capacity.
You promotion from the
You have to give. Give the salary.
Salary is not.
Because
That's
of
a
BK
bekar.
Pavitra case was pending then, that is the.
That makes no difference. Otherwise, it will be offensive to Article 23, doctrine of Begar, which Dr. Ambedkar enacted that. See the debate on that, on Shirvai, covers in his 4th edition so beautifully, in 3rd edition, still more beautifully. ಅದೊಂದು ಯಾವ್ದೋ ಜಡ್ಜ್ಮೆಂಟ್ ನಾವೊಂದು ಬರ್ದಿದ್ವಿ ಅದ್ರ ಮೇಲೆ, ಬೇಗಾರ್ ಮೇಲೆ. ಎಲ್ಲಿದ್ದಾನೆ ಇವನು? Where is that? Doctrine against Begar. Take out that judgment. Interest bitcoin.
Interest 8%.
Interest
The
bitcoin.
cost is also imposed on the,
Cost to interest. Welcome.
I would request most lesser cost, interest maybe, Lord, maybe awarded, because he's already retired. He has been made suffer from Lord.
For the first time,
Please,
we are laying, in fact, that's the correct position.
yes.
But correct position has come to light now. Hangagi, some concession, it is like one free bite to the dog. Every dog will have one free bite. Only thereafter we finish it.
Please,
That
I'll
way.
leave it
Interest.
your, I'll leave it your lordship.
Prakram. The state government and its officials are knocking at the Kudali, please be seated, are knocking at the doors of writ court for assailing the service tribunal's order dated 22 June 2023, whereby the private respondent's application number 3896 of 2022, having been favored, a direction has been issued to the petitioners to pay the arrears of, correct. Begar. ನಾ ಡಿಸೈಡ್ ಮಾಡಿದ್ದ? ಓಕೆ. ಪಡಿ ಜಡ್ಜ್ಮೆಂಟ್ ಕೊಡು. AR 1998 SC 3164. Yes. A direction has been issued to pay to him the arrears of salary in the pay scale admissible to the post which he held with effect from 2009 on placement by way of independent charge under Rule 32 of KCSR. First, tribunal has also directed payment of the interest on the delayed dispersal of the amount payable, arrears of salary, and levied a cost of rupees 2,500. First, learned AGA appearing for the petitioners vehemently argues that the tribunal has grossly erred in granting relief of the kind, in as much as it was only a retrospective promotion, and during the period of retrospectivity, when the civil servant had held the post in question on independent charge, he has already received the charge allowance. First up, she also seeks to falter levy of cost and interest on the delayed payment of the arrears of salary. First, learned counsel appearing for the private respondent with equal vehemence justifies order of the tribunal making submission in support of the reasoning on which the said order has been constructed. First off, he banks upon decision of the apex court
in state of Gujarat versus Honorable High Court of Gujarat, AR 1998 SC 3164 and ರಿಪೋರ್ಟ್ ಆಗಿಲ್ಲ ಅನ್ನೋದು ಇನ್ನೊಂದು ನ್ಯೂಟ್ರಲ್ ರಿಪೋರ್ಟ್ ಕೊಡೋದ್ರದ್ದು and GM Puvaya versus Managing Director, WP number 2463, 2015, decided on so and so, so and so. Next one. Having heard the learned counsel for the parties and having perused the petition papers, we decline indulgence in the matter, broadly agreeing with the regions which the tribunal has assigned in the impugned order. First stop. When a person is placed on independent charge basis in a post, comma, under Rule 32 of KCSR, comma, it is not a case of promotion, is well settled. Full stop. However, where such a person being entitled to be promoted to the said post, but was not promoted, although he was made to hold the post on independent charge, comma, then the promotion he acquires with retrospective effect. Full stop. It is not a case of notional promotion. Full stop. A difference is maintained in service jurisprudence between notional promotion and retrospective promotion. Full stop. In the former, ordinarily, emoluments are not given to the employee, whereas in the later, the emoluments are denied only by way of an exception. Full stop. This accords with the doctrine against begar enacted in Article 23 of the Constitution of India. Full stop. Sirvai defines begar as under in his 4th edition, so and so, so and so. Full stop. Next paragraph. Learned counsel appearing for the private respondent is more than justified in banking upon the apex court decision in state of Gujarat versus High Court of Gujarat, and also GM Puvaya versus so and so, wherein this aspect of the said doctrine has been treated. Full stop. The apex court has gone to the extent of saying that even the prisoners serving the sentence cannot be denied minimum wages for the work they do within the precincts of the jail. Full stop. If that be so, the amount which would accrue to a civil servant on being given retrospective promotion constitutes his property, which cannot be taken away by the state, save by the procedure of law as enacted in Article 300 capital A of the Constitution. Full stop. This reasoning finds place inarticulately in the order of the tribunal. Right. Full stop. In the above circumstances, sentence. However, the above being said, comma, the learned EGA is right in telling us that no interest could have been given on the arrears of salary, nor the cost could have been levied. First stop. We'll say you agreed with that. Not mistake.
Consider.
Okay. Next paragraph. In the above circumstances, the petition being devoid of merits, although is dismissed, comma, the direction for payment of interest and levy of cost is diluted. Within what period you are making payment? ಅವಾಗ ಮಾತ್ರ ಇದು ಹೋಗತ್ತಿಲ್ಲ, ಇಂಟ್ರೆಸ್ಟ್ ಎಲ್ಲ ಅಷ್ಟು ಕೊಡ್ಬೇಕಾಗತ್ತೆ.
2 months.
2 months.
One more
Will be
ground, if my lords
3 months.
kindly permit me.
the order of the tribunal shall be implemented and arrears of salary shall be dispersed to the private respondent within an outer limit of 3 months.
Please.
Failing which, delay will carry interest at the rate of 1%. The failing which, the direction for payment of interest and cost would revive.
Grateful.
Your Lordship, kind permission, even the pay scale, my lord, it was between 67,500 to 1,04,000. Petitioner, my lord, respondent, my lord, he has reached to 1,09,300. So even on that ground,
Minus the
Minus.
charge allowance.
yes,
Minus the
I have
charge.
reached my scale, my lord.
Very
obliged, my lord.
One request, Lord, for hand
Ah.
delivery of the interim order, my lord.
Serial number. But not head delivery.
And permission, serial number 13, 37, Malo,
Serial number 13.
37,
ಮಧ್ಯಾಹ್ನ ಬರೋಣ.
next week.
ನೆಕ್ಸ್ಟ್ ವೀಕ್ ಫಸ್ಟ್ ವೀಕ್ ಮಾಡೋಣ ಅಂತ. ನಿಮ್ ಫ್ರೆಂಡ್ ಇದಾರ ಅದ್ರ ಡೇಟ್ ಫಿಕ್ಸ್ ಆಗಿದೇನೋ? ಡೇಟ್ ಫಿಕ್ಸ್ ಆದ ಮ್ಯಾಟ್ರ ಇರಿ ಅವ್ರು ಬರ್ಬೇಕು. ಡೇಟ್ ಫಿಕ್ಸ್ ಮಾಡಿದಾಗ ಅವ್ರನ್ನ ಕೇಳಿ ಮಾಡಿರ್ತೀವಿ.
The state is the only, only the state.
ಸ್ಟೇಟ್ ಇಸ್ ದ ಪಾರ್ಟಿ. ಕೇಳಿ ಕೊಡ್ಬೋದಾ ಬ್ರದರ್? ಅವ್ರೇನೋ ಟೈಮ್ ಕೇಳ್ತಾ ಇದ್ರೆ ಕೊಡ್ಬೋದಾ ನಿಮ್ಮ ಕಾಲ್ ಇನ್ ದಿ ಸೆಕೆಂಡ್ ವೀಕ್ ಆಫ್ ಜನವರಿ. ಎಂಟ್ರಿ ಮಾಡಿದೀಯಾ?
No entry.
ದೆನ್ ಥರ್ಡ್ ವೀಕ್ ಆಫ್ ಜನವರಿ. ಎಸ್ ಏನ್ ರಾಜಶೇಖರ್?
Serial number 35 on the pending inquiry suspension order was under challenge. The 6 months lapse ಆಗಿದೆ.
ಯಾವ್ದು ಸುಪ್ರೀಂ ಕೋರ್ಟ್ ಜಡ್ಜ್ಮೆಂಟ್ ವಿಚ್ ಸೆಡ್ ಶುಡ್ ಬಿ
They have
suspension.
reinstated-
ಚಾರ್ಜ್ ಬಟ್ ಚಾರ್ಜ್ ಇಸ್ ಗಿವನ್.
Charge is-
Charge memo is served.
Charge memo is-
ಅವಾಗ ಬರಲ್ಲ ಬಟ್ ಇಟ್ ಕಂಟಿನ್ಯೂಸ್.
Final hearing, I'll take time. Please, Your Honor. I won't do it.
Court officer, madam. Court officer?
45.
Court officer? Sir? ಏನು ತಗೊಂಬಿಟ್ರ ಎಲ್ಲಿ ಇವನ ಎದುರುಗಡೆ ಮಾಡೋದಿಲ್ಲ.
ಲಿಸ್ಟ್ ನಂಬರ್ 2 ಸರ್. ಯಾವ್ದು ತಗೊಳ್ಳೋದು? ಫೈನಲ್ ಇಯರ್ ಯಾವ್ದಿಲ್ಲ.
ಕೋರ್ಟ್ ಆಫೀಸರ್ ಸರ್.
ಅದು ರಾಜಶೇಖರ್ ಅವ್ರದ್ದೇ.
ಮೇಡಮ್.
ಸರ್
ಸರ್ ಇದು ಲಿಸ್ಟ್ ನಂಬರ್ 2.
ಸರ್
Serial number 8.
35 ಏನಾಯ್ತು ರಾಜಶೇಖರ್ ಅವ್ರದ್ದು?
ಲಿಸ್ಟ್ 2 ಸೀರಿಯಲ್ ನಂಬರ್ 8. ಯಾವ್ದು ತಗೊಳಲ್ಲ ಲಿಸ್ಟ್ 2? ಅದೇನಾಗಂದ್ರೆ ವೇಟ್ ಮಾಡೋದು ಬೇಕಾಗಿಲ್ಲ. Court officer, madam. Madam. ಮೇಡಮ್ ಆವಾಗಿಂದ ಹೇಳಿ ಹೇಳಿ ಅಂತ ಇದೀವಿ, ಏನು ಹೇಳ್ತಾ ಇಲ್ಲ. ಹೋಗೇ ಬಿಟ್ರಾ?
I'll appear before the court below.
If
That's
that is the
consumer
case, my lord, I may kindly be permitted to withdraw the amount subject to result of the district forum.
ಅವ್ರು ನಾನ್ ಸಕ್ಸೀಡ್ ಆದ್ರು ಅಂದ್ರೆ ಅಮೌಂಟ್ ಹೆಂಗ್
We will pay it that.
6 months.
We will pay that.
ಹೆಂಗ್ ಹೌ ವಿಲ್ ಯು ಪೇ ಸಪೋಸ್
Because my lord, since 11 years, my client is suffering.
ದಟ್ಸ್ ಸಿ ಕೋರ್ಟ್ ಅವ್ರೇನೋ ಇಟ್ಕೊಂಡ್ ಕೊಡ್ರಿ ಅಂತ ಹೇಳಿಲ್ಲ ಕೋರ್ಟ್ ಮ್ಯಾಟರ್ ಇಸ್
Plus, they have suffered till National Commission. They have no right to file writ petition according to section 67, my lord. They have to approach the Honorable Apex Court.
ಅಪೀಲೇಬಲ್ ಆರ್ಡರ್
Yes,
ಯಾವ್ದು ಸೆಕ್ಷನ್ ಕೊಡಿ
please, section 67 of the Consumer Protection Act, my lord, amended in the year of 2020 itself. Please, my lord.
ಓದಿ
Sir,
2020
please.
is it retrospective? This was which year?
With effect from 27/2020, my lord.
No, this order of the
Order is 2024,
order
No,
of
no,
the
the
first
order of the consumer forum is 19 to
2019.
19.
So if a right of appeal is a substantive right, it is always prospective in operation unless indicated to be retrospective. The three Supreme Court.
May I make submission? There is a judgment of the Supreme Court to say that it has to go to that court, this court.
It is a,
There is a judgment of the Supreme Court.
it says first you should exhaust writ remedy and then come
Yes,
to.
yes. That's why it was
They have
entertained in the office
exhausted the
also.
appeal remedy as well as revision before the
I-
Honorable State Commission and National Commission.
That's correct.
After rejecting the order of the National Commission, they, instead of approaching the Honorable Apex Court, according to section 67, they approached it by filing writ petition.
Sorry, on merit mal not. The right of appeal will not come in the way anta. Because Mr. Shankar in his CPC
Please,
has referred to
this minute.
one judgment of the apex court saying he has referred to Kerala High Court judgment whether a right of appeal by way of amendment aitala,
Please,
right of appeal is a substantive right. That has been the established
Please.
position. That amendment is prospective anta ಬರೆದಾರು CPC.
please.
ಹಂಗಾಗಿ ಈ amendment 2020 ಇದೆ. But cause of action is anterior to amendment.
But my lord, they have exhausted the appeal remedy as well as revision remedy.
Huh? Same view prospective ಅಂತ declare ಆಗಿದೆ.
Lord, they have exhausted the appeal remedy as well as revisional remedy. But means by challenging that revisional order, the section 67 says they should prefer an appeal before the Honorable Supreme Court.
All right, ground set. In ground set.
Lord,
Ah.
Lord, may kindly go to page number 120.
ಈಗ ಅವರು ಆಲ್ಟರ್ನೇಟಿವ್ ಸೈಟ್ ಕೊಟ್ಬಿಡ್ತೀವಿ ಅಂತಾರೆ ಯಾಕೆ ತಗೋಬಾರ್ದು ಮಗ್ಲಾಗಿರುವಂತ ಲೇಔಟ್ ನಲ್ಲಿ.
ಅಲ್ಲ
I mean-
ಅದು ಪಕ್ಕದಲ್ಲ my lord, they are saying that it is Bommanhalli village. It is totally outskirts to the entire Chalikere town itself.
ಅಲ್ಲೇ ನಾವು adjoining
Interior
ಅಂತ
place ಸ್ವಾಮಿ ಅದು.
Joining only. It's
adjoining
adjoining
ಅಂತ
only.
ಹೇಳ್ತಾ ಇದ್ದಾರೆ.
But I am means I am neighboring taluk, my lord, I know it very well.
ನಿಮ್ಮ ನಾಲೆಡ್ಜ್ ಅನ್ನು ಇದ್ರಾಗಿ ರೀಡ್ ಮಾಡ್ಲಿಕ್ಕೆ ಬರಲ್ಲ.
Because my lord, I know it
Personal
personally.
knowledge ಅನ್ನ
Please.
ನಮ್ಮ ಪರ್ಸನಲ್ ನಾಲೆಡ್ಜ್ ಅನ್ನು ರೀಡ್ ಮಾಡ್ಲಿಕ್ಕೆ ಬರಲ್ಲ. ಅವ್ರು ಹೇಳೋದು ಆ ಲೇಔಟಿಗೆ ಅಡ್ಜಾಯ್ನಿಂಗ್ ಇರೋಲ್ಲೇ ಕೊಡ್ತೀವಿ ಅಂತ ಹೇಳ್ತಾ ಇದ್ದಾರೆ ಅವರು. ಅದನ್ನ ರೆಕಾರ್ಡ್ ಮಾಡೋಣ.
Swami,
My lord, we will
I'm
examine.
giving instead of 1,200, 1,500 square foot. And I'm only asking for the remaining amount to be paid.
ಸುಮ್ನೆ ಕೇಸ್ ನಡೆಸ್ಲಿಕ್ಕೆ ಆರ್ಗ್ಯುಮೆಂಟ್ ಮಾಡ್ತೀರಿ.
ಆಗ್ಬೋದು.
1 ಲಕ್ಷ ಕೊಡಬೇಕಾಯ್ತು ಅದನ್ನ ಕೊಡ್ಲಿ ಎಕ್ಸ್ಟ್ರಾ ಅಮೌಂಟ್ ಕೇಳ್ತಾನೆ ನಾನು. That is to say 1 lakh more.
ನೋಡ್ರಿ 1,500 ನಿಮ್ಗೆ 30-40 ಕೊಡೋದಿತ್ತಲ್ಲ ಮೇಷ್ಟ್ರೆ, ಅರ್ಥ ಮಾಡ್ಕೊಳ್ಳಿ. 30-40 ನೀವು ತಗೋಬಹುದು. ಈಗ ಅವ್ರೇನಂತಾರೆ ಅದ್ರ ಮಗ್ಲಾಗೆ ಲೇಔಟ್ ಇದೆ ಅವ್ರು ಹೇಳ್ತಾ ಇದ್ದಾರೆ. ಅಲ್ಲ ನಮ್ಗೆ ಕೇಳ್ಕೊಳ್ಳಿ, ಅವ್ರು ಹೇಳಿದ್ದು ನಿಮ್ಗೆ ಹೇಳ್ತಾ ಇದೆ. ಯಾವಾಗ ಹೋಗಿದ್ರಿ? ಅವ್ರ ಮಗ್ಲ ನಾವು ಬರೀತೇವೆ ಅವ್ರ ಮಗ್ಲಲ್ಲೇ ಕೊಡ್ತಾರ ಅಂತ ಹೇಳ್ತಾ ಇದಾರಲ್ಲ. ಏನ್ ಹಂಗಾರೆ ನಾವು ಇದನ್ನ ಅಡ್ಮಿಟ್ ಮಾಡ್ತೀವಿ, ಒಂದ್ 5 ವರ್ಷ ಬಿಟ್ಕೊಂಡು ಬರ್ತದೆ ಬಿಡಿ, ಬರ್ಲಿ ಬರ್ಕೊಳ್ಳಿ. Matter requires consideration, issue deeper consideration, issue rule and stay of input orders. Okay. Next. ದುಡ್ಡು
It's my request.
ಬೇಡ ಅಂತೀರಿ, ಸೈಟ್
Lord.
ಕೊಡ್ತೀವಿ ಅಂದ್ರೆ ಬೇಡ ಅಂತೀರಿ. ಅಂದ್ರೆ ನಾವು ರಿಟ್ ಜುರಿಸ್ಡಿಕ್ಷನ್ ಆಗಿ ಏನ್ ಮಾಡ್ಬೇಕು ಕೆಲಸ?
We will examine the same.
ಅಲ್ಲಿ 5 ವರ್ಷ ಕಾಣ್ ಬರ್ಲಿ.
ಅಲ್ಲ, kindly accommodate.
No, we don't waste time. Yes, next. Don't waste time. So people, ನೋಡಿ
Lord.
ಅವ್ರು ಹೇಳಿದ್ರು ಸೈಟ್ ಕೊಡ್ತೀವಿ 30-40 ಬದಲಿ 30-50 ಕೊಡ್ತೀವಿ ಅಂತ
yes,
ಹೇಳಿದ್ರು. ಸ್ಟಿಲ್ ಮೇಸ್ಟ್ರಿಗೆ ಕೇಸ್ ನಡೆಸೋದ ಬೇಕಿದೆ.
ಇಲ್ಲ ಇಲ್ಲ.
ಹಾ ಇರ್ಲಿ ಬಿಟ್ಟು ಆಗ್ಲಿ, ಅಲ್ಲಿ ಬರ್ಲಿ, ಒಂದ್ 7-8 ವರ್ಷ ಆದ್ಮೇಲೆ ಬರ್ತದೆ. ಇರ್ಲಿ, ಕಾಲ್ ಇನ್ ಯೂಶುವಲ್ ಕೋರ್ಸ್. ಓಕೆ, ನೆಕ್ಸ್ಟ್.
Lord, I will make him correct that regarding that.
ನೋಡ್ರಿ ಟೈಮ್ ವೇಸ್ಟ್
30,
ಮಾಡ್ಬಿಟ್ಟು ಭಾಳ ಜನ
50.
ಲಾಯರ್ಸ್ ಕಾಯಿಸ್ಬೇಡ್ರಿ. ಒಂದೊಂದು ನಿಮಿಷಕ್ಕೆ ಟೈಮ್ ವೇಸ್ಟ್ ಮೊದಲೇ ಪ್ರಿಪ್ರೇಷನ್ ತೊಳಿ ತೊಳಿ. ಬರ್ಲಿ ಒಂದು 5-6 ವರ್ಷಕ್ಕೆ ಬರ್ತದೆ ತೊಳಿ. ಒಳ್ಳೆ ಜಡ್ಜಸ್ ಮುಂದೆ ಬರ್ತದೆ. ಓಕೆ ತೊಳಿ. ಅಲ್ಲಿ ನಾವೇನ್ ಮಾಡ್ಲಿಕ್ಕೆ ಆಗಲ್ಲ, ಜಸ್ಟಿಸ್ ಮಾಡ್ಲಿಕ್ಕೆ ಆಗಲ್ಲ. ಇದು ರಿಟ್ ಜುರಿಸ್ಟಿಕ್ಷನ್, ನಾವು ಆ ರೀತಿ ಮಾಡ್ಬೋದು, ಬಟ್ ತಿಳಿಯಲ್ಲ ಲಿಟಿಗಂಟ್ಸ್ಗೆ. ಓಕೆ, ಯಾವ್ದೋ ಒಂದು ಮೂವ್ ಮಾಡಿದ್ದಲ್ಲ, ಯಾವ್ದದು ಬಂದಿದೇನಾ ಅಂದವೇ? ಕೊಡಿ. ನಮ್ಗೆ ಜಸ್ಟಿಸ್ ಮಾಡ್ಲಿಕ್ಕೆ ಆಗೋದಿಲ್ಲ. ಹೆಂಗ್ ಪ್ರೊಸೀಜರ್ಸ್ ಎಲ್ಲ ಹೆಂಗಾಗಿದೆ ಅಂದ್ರೆ ನಮಗೆ ಇಂಥಲ್ಲಿ ಆಕ್ಚುಲಿ ಅವ್ರಿಗೆ ಸೈಟ್ ಕೊಟ್ಬಿಟ್ರೆ ಅವ್ರಿಗೆ ಅನುಕೂಲ ಆಗ್ತದೆ. ತಿಳಿಯಲ್ಲ ಅವ್ರಿಗೆ ಏನೋ ಭ್ರಮೆಯಲ್ಲಿ ಇರ್ತಾರೆ, ಇನ್ ಜಸ್ಟಿಸ್ ಆಗ್ತಾ ಇಲ್ಲ ಅಂತ ಅನ್ನುವಂಥ ಭ್ರಮೆ. ಹೆಂಗ್ ಮಾಡೋಣ ನಾವು ಕೆಲಸ ಮಾಡೋದು ಹೆಂಗೆ? ಹಂಗಾಗಿ ಏನ್ ನಾವು ಚಲೋ ಜಜ್ಮೆಂಟ್ ಬರ್ದು ಜಸ್ಟಿಸ್ ಡಿನೈ ಮಾಡ್ಕೊತ ಹೊಂಟ್ಬಿಡೋದು. ಬ್ಯೂಟಿಫುಲ್ ಜಜ್ಮೆಂಟ್ಸ್, ನೋ ಜಸ್ಟಿಸ್. ಮಾಡ್ಲಿಕ್ಕೆ ನೋಡಿ 30-50 ಕೊಡ್ತೀನಿ ಅಂತ ಹೇಳ್ತಾನೆ, ಮಗಳಾಗಿಂದ 8 ಕೊಡ್ತೀನಿ. ಸ್ಟಿಲ್ ದಿಸ್ ಮಾಸ್ಟರ್ ಸೇಸ್ we do not know. He thinks that he will live 100 years. ಬದಿಲ್ವಾ? ಸರಿ ಮತ್ತೆ ಸುರಾನ ಬರೀ ಸ್ಟಾರ್ಟ್ ಮಾಡಿ. Application. Yes. So your contention is confined to survey number 37. Rest of the things you are not concerned with that. Your case is that it is a private property, therefore it cannot be subject matter of partition. That's your case. And secondly, even otherwise, the cause is time barred. Correct? Variant argument idea?
No, they have suffered a decree for injunction. I have a permanent decree for permanent injunction against them.
ಇದ್ರ ಜೊತೆ ಅದು ಹೋಗ್ಬಿಡತ್ತಲ್ಲ, ಅದಕ್ಕೆ ಸಪರೇಟ್ ಆರ್ಗ್ಯುಮೆಂಟ್ ಬೇಕಾಗಲ್ಲ. Injunction ಇದೆ.
They say that the suit is filed on the ground that we are joint possession property. The court did not look into the judgment produced before the court where there is a permanent injunction granted in my favor.
Injunction ಪ್ರಶ್ನೆ ಬರೋದೇ ಇಲ್ಲ, because very definition of mean profits. You have read yesterday.
Maybe, but I can't. I'm only bringing to notice of the court.
We have understood that very claim for mean profits presupposes that he is not in possession of the property. Where is the question of mean profits?
You could not be in possession because I have purchased in 1970.
That's what.
That is one aspect of the matter. Other aspect is when he has suffered a expert decree against him in a suit filed by me for injunction, he has suffered a decree. 4 years prior to the suit. After suffering a decree, he files a suit for partition, second suit for partition.
Earlier suit.
Earlier, I have filed a suit. ಅಲ್ಲ ಅದಲ್ಲ, ನಾನೊಂದು ಸೂಟ್ ಹಾಕಿದ್ದೀನಿ, ಒಂದು ಸೂಟ್ ಹಾಕಿದ್ದೀನಿ, ಅದ್ರಲ್ಲಿ ಡಿಗ್ರಿ ಆಗಿದೆ
ನಿಮ್ ಪರವಾಗಿ.
ನಮ್ಮ ಪರವಾಗಿ.
ಹೌದಾ?
ಕೈಂಡ್ಲಿ ಟೇಕ್ ಟು 31 and 30.
ವಾಲ್ಯೂಮ್
3 ನಲ್ಲಿ ಬರ್ತದೆ.
ನಿಮ್ಮ ಪರವಾಗಿ ಒಂದು ಡಿಗ್ರಿ ಇದೆಯಾ?
ಡಿಗ್ರಿ ಇದೆ.
Decree for permanent injunction.
ಹೌದೌದು.
Decree for permanent injunction.
Yes. 510. Exhibit D 31.
510. Release from partial. Full issue ಆಯ್ತು, ಮುಗಿದೋಯ್ತು.
Expiry decree is that 510.
All right. Mr. Surana draws attention of the court to exhibit D31, which is an injunctive decree obtained by his client in OS number 64/2000, decreed on
Against the plaintiff and third defendant.
16 January 2004 against the respondent plaintiffs and the third
defendant.
third defendant.
The brother of the plaintiff.
Third defendant, who is none other than brother of
Which
Plaintiff.
plaintiff? Which plaintiff?
Plaintiff, only one plaintiff.
Brother of plaintiff. Okay.
So exhibit
same is-
D31 and D31 here are the records.
The same
Judgment
is
and
found at volume 3, page 510. Matte.
See, the trial court says when the issue is framed that whether they are in joint possession or not. In the face of the decree, they cannot claim joint possession of property.
No, because there is a decree.
Decree.
He submits
The
that.
consequences.
How the trial court has treated this decree?
Now, the reasons of the trial court are very, very
Precarious.
shallow. What the learned trial judge says is,
He further adds that in view of injunctive decree, where a finding as to his client being in possession has been recorded, comma,
on issue number
the
5.
decree for injunction could not have been entered against him at all. Okay, next point.
On this ground, I rely upon a division bench of this honorable court,
Ah.
where a partition suit is filed on the ground that I am in joint possession. And if it is found that is not the joint possession, suit has to be dismissed. 2001, Karnataka 384.
For the proposition, what is the proposition?
The plaintiff comes to the court
Third.
that the plaintiff is in joint possession of property. And if it is found that he is not in joint possession of property, then the suit has to be dismissed. He can't be relegated to 31-2.
He presses into service the proposition that where a plaintiff approaches the court on the premise that he is in the joint possession of the property, and on trial, if the court comes to the conclusion that his assertion is not true, comma, then his partition suit cannot be decreed. Full stop.
Paragraph 11.
He seeks places reliance on a coordinate bench decision in B.S. Malleshappa versus Koratagi Gere B. Shivlingappa. AR 2001, Karnataka 384.
84.
Paragraph
11, Roman 4. Paragraph 11,
Paragraph 11.
11, Roman 4. I will read Roman 4 only.
4. If the plaintiff claims that he is in joint possession of property in 6 partitions, separate possession, he categories get liable to claim court fee only if on evidence it is found that he was not in joint possession. The consequence is that the relief may be refused in regard to such a property. That was in relation to court fees.
That is true. But he categorized the suit under joint possession and pays a court fee of 200. So the court need not ask upon him to categorize suit under 35-1. The suit has to be dismissed. Because he has come to the court under 35-1. If the suit does not fall under, suit may be dismissed. On issue number 5, the court should have recorded a finding that they are not in joint possession, suit should have been dismissed.
Para 11, Roman small
4.
4. Okay.
Then kindly bear in mind that the plaintiff himself says he came to know of this property only in the year
Next point, we have understood. Go to
Nine-
next point.
1990.
Yeah.
And he was not aware of this property till the filing of the present suit.
All right. Huh? Yes. go to
Kindly
next
go
point.
to page 12, my lord,
Page 12
page 12
of,
of the plaint.
you have read it yesterday, na?
Alla,
He said, we have been excluded from possession.
No, that is not done.
Ah.
This is another aspect of the matter.
Next point.
The scheduled properties are not the subject matter of suit in the middle.
Paragraph?
Paragraph 7 ಅಲ್ಲಿ, next page at page 12, from the bottom 10 lines.
How it begins?
From bottom, the scheduled properties are not the subject matter of the suit referred to supra. from the bottom 10th line.
The scheduled properties are not the subject matter of the suit related to supra.
The
Refer to
plaintiff
supra.
came to know about the fact that the scheduled properties are the not subject matter of the suit proper recently. The plaintiff to go know about the scheduled properties are also joint family properties only on obtaining the revenue records. Thereafter, the plaintiff has verified the suit.
Came to know that the scheduled properties are the joint family properties. Immediately thereafter, the plaintiff has approached the honorable court for necessary relief. Idrinda, what you want to derive from this?
What he says is he was not aware that these properties are joint family properties. He came to know recently at the time of filing of the suit after obtaining revenue records. So therefore, he was ignorant about this property according to him.
Even if I am ignorant of my properties, I continue to be owner of the
True.
property.
No, he says,
Ah.
in the, see, please read this averment in regard to the other evidence. That he says from the time of my grandfather Chikkachindanna, we have been possession of suit properties.
So inconsistent plea ಆಗ್ತದೆ ಅಂತ. Because law is an owner need not know his properties. Tata may not know where all his property are situate. Still he continues to be the owner.
What I, my subject.
Only for variance ಗೆ variance ಪ್ಲೀಗೆ ಆರ್ಗ್ಯೂ ಮಾಡ್ಬೋದು ಇದನ್ನ ಈ ಪಾಯಿಂಟ್. ಅದೇ
Joint possession.
because that question arose before an English court, which summoned on jurisprudence treated in under the chapter ownership, where a particular person had lost a golden ring in a well. Then long after, somebody found that. This person brought an action to retrieve the ring. The argument was, he did not know of the ring at all. The House of Lords repelled the contention, saying that for being the owner, the knowledge of the thing owned is not a prerequisite.
It's true, my lord, but.
But for that, the first one, no. Second one you can take up.
Many a times we may not.
Parkali. All right.
Many a times we not know.
All right, you have said that, Parkali. Surana draws our attention to the last part of the averments at plaint averments at para 7 at page 12 to the effect that the plaintiff's assertion that he has been in possession of the property and the other assertion that he came to know of these properties being ancestral joint family properties only in the recent past is hit by plea invariance. Full stop. ಹೆಂಗೆ ಕಾನ್ಫ್ಲಿಕ್ಟ್ ಎಲ್ಲಿದೆ? ಅವರಿಗೆ ಈ ಪ್ರಾಪರ್ಟಿ ನಾ ಮೊದಲಿನಿಂದ ಇದ್ದೇನೆ ಅನ್ನೋದು ಒಂದು ಸ್ಟ್ಯಾಂಡ್. Now we'll juxtapose the other version. I came to know of the fact that these are the joint family properties. ಆ ಫ್ಯಾಕ್ಟ್ ಆಮೇಲೆ ಗೊತ್ತಾಯ್ತು ಅವನಿಗೆ. It is not that he was not in possession of the property.
My submission is that the plea that Chikkachindanna was the owner of the property from the time immemorial and continuously till today is only a plea advance for the purpose of taking a chance in the suit with the courts. Otherwise, this sentence would not have come. And this property.
What is ಗೊತ್ತಿರಲಿಲ್ಲ ಅಂದ್ರೆ ಅದು ಜಾಯಿಂಟ್ ಫ್ಯಾಮಿಲಿ ಪ್ರಾಪರ್ಟಿ ಅಥವಾ ಅಲ್ಲ ಅನ್ನೋದು ಗೊತ್ತಿರಲಿಲ್ಲ ಅಂತ ಹೇಳ್ತಾರೆ ಅವರು. ನಾ ಪೊಸಿಷನ್ ಆಗಿಲ್ಲ, ಪೊಸಿಷನ್ ಆಗಿದ್ದೇನೆ ಅನ್ನೋದು ದ ನಾಲೆಡ್ಜ್ ದಟ್ ಇಟ್ ಈಸ್ ಅನ್ ಜಾಯಿಂಟ್ ಫ್ಯಾಮಿಲಿ ಪ್ರಾಪರ್ಟಿ ಎಲ್ಲಿ ಕಾನ್ಫ್ಲಿಕ್ಟ್ ಆಗ್ತದೆ ಅಂತ ಲಾಜಿಕಲಿ. ವೇರ್ ಇಸ್ ದಿ ಲಾಜಿಕಲ್ ಕಾನ್ಫ್ಲಿಕ್ಟ್? One may be in possession of the property without knowing that it is joint family property.
Say, his plea is that Chikkachindanna continued to be the owner. He does not know that the property was lost by Chikkachindanna and we purchased the property in the year 1970 and all that.
Then conflict. We do not agree with this proposition. Yes, next.
See, in 1970 we purchased it.
All right.
Now question is, when we purchased the property, see, there is no evidence on record that the property was the joint family property.
That's a argument.
Yes. Then kindly see,
Yes.
I have filed the application for bringing on record few documents that are all registered documents and revenue documents.
Now which you have filed application under 4127,
Not so. ಅದಕ್ಕೆ my friends have not filed any objections.
ಅದೇನು documents ಅವು?
Documents are old document. That is, one is the IL and RR. First document is the IL and RR,
ಎಲ್ಲಿ page number?
page number 14 of the IA. IA file.
Paper book ಕೊಡಿ. ಅದು in support of
IA
what?
1 of 23.
ಆ documents in support of what? Those documents
Yes.
you want to rely upon?
Now, they challenge my vendor's title in the cross exam. I'll come to that. See, I have purchased from the two vendors. I have purchased the property under the sale deed from two vendors. They challenged the very title of my vendor in the
That is,
cross examination.
D13 and D23 or 26 ಅದು?
D18 and D33 ನಲ್ಲಿ ನಾವೇನ್ ಪರ್ಚೇಸ್ ಮಾಡಿದೀವಿ ಅದನ್ನ ಕ್ರಾಸ್ ಎಕ್ಸಾಮಿನೇಷನ್ ಚಾಲೆಂಜ್ ಮಾಡ್ತಾರೆ.
ಹಾ.
That your vendor did not have title to sell the you ಅಂತಂದು. So therefore, they say that I have not, the vendors had no title to sell to me. That is the stand taken in the cross examination.
Correct. How this evidence is relevant for that?
Relevant is that these are the documents which are old documents and we have been able to trace it, which traces the title to the property.
Which year document?
These are all old documents. One is
Old means what? Old is a very elastic word
Yes.
in English.
1950, the IL and RR records of 1950.
1950.
50.
ಯಾವುದು? ಕೊಡಿ.
First
Application ಕೊಡಿ. That is anterior to exhibit D18 and
These are documents anterior to all these four documents.
what they say? ಕೊಡಿ, application ಕೊಡಿ.
The ILR entry. Nineteen 27 is entries.
1927.
ಹೌದು.
Mentioning whose name? ಯಾರ ಹೆಸರನ್ನು ಮೆನ್ಷನ್ ಮಾಡ್ತಾವು?
ಈ ಟಾಪ್ ಅಲ್ಲಿ ತಾವು ಸರ್ಟಿಫಿಕೇಟ್ ಕಾಪಿ ತಗೊಂಡ್ರೆ ಟಾಪ್ ಅಲ್ಲಿ 37 ಸರ್ಕಾರಿ ಅಂತಿದೆ ಇಲ್ಲಿ.
ಪೇಜ್ ನಂಬರ್?
ಪೇಜ್ ನಂಬರ್ 14 ಅಲ್ಲಿ.
14. ಏನಿದು?
Left hand what? Island, index of land and records of rights.
ರೆಕಾರ್ಡ್ಸ್ ಆಫ್ ರೈಟ್?
Yeah.
ಹಂಗಿಲ್ಲಲ್ಲ ಇದು.
Before RTC ಅದೇ ಬಂದಿರೋದು. Before RTC was introduced, there used to be a records of rights and index of lands.
It's under Mysore Land Revenue Code.
Before, I think it came into force in 1947.
No.
Independence ಆದ್ಮೇಲೆ
It came into force in 1964.
ಅದಕ್ಕೆ
Before
ಮುಂಚೆ
that, there was
IL and
Mysore
RR.
Land Revenue Code.
ಅದಕ್ಕೆ ಮುಂಚೆ IL and RR ಇತ್ತು.
ತೋರಿಸಿ ನಮ್ಗೆ, ನೀವು ಹೇಳಿದ್ರೆ ಆಗ್ಲಿಲ್ಲ ಅದು. ನಮ್ಗೆ ತೋರಿಸ್ಬೇಕು, ನಮ್ಮ ಇಂಪ್ರೆಷನ್ ಹಂಗಿಲ್ಲ.
I will give the document.
ಏನ್ ಡಾಕ್ಯುಮೆಂಟ್ ಇದು?
These are the entries made
ಹಾ.
of the lands purchased by the persons in the
ಯಾರ
revenue
ಹೆಸರಿಗೆ?
record, just like RTC record.
ಯಾರ ಹೆಸರು?
Before RTC,
ಯಾರ ಹೆಸರಿಗಿದೆ?
37, ಚಿನ್ನಪ್ಪ ಗುರೆಡ್ಡಿ.
ಪೇಜ್ 37
ಅಲ್ಲ, ಸರ್ವೆ ನಂಬರ್ 37 ಎದುರುಗಡೆ
ಯಾವ
page 14 ಅಲ್ಲಿ
ಯಾವ ಪೇಜ್ ಓದ್ತಾ ಇದ್ದೀರಿ?
14.
14.
That is the old record.
ಹಾ.
ಚಿನ್ನಪ್ಪ ಗುರೆಡ್ಡಿ ಅಂತಿದೆ.
ಒಂದ್ ಸ್ವಲ್ಪ ಶಂಕರ್ ಅವರೇ ನೋಡ್ಬೇಕು ತಾವು. ಜಸ್ಟ್ ನೋಡ್ಕೋಬೇಕು.
Column 7.
ಯಾರ ಹೆಸರಿದೆ?
ಚಿನ್ನಪ್ಪ ಗುರೆಡ್ಡಿ ಬ್ರಾಕೆಟ್ ಅಲ್ಲಿ
ಎಲ್ಲಿ?
ಜಸ್ಟ್ ಅಬೌವ್ ರಾಮಯ್ಯ ಗುರೆಡ್ಡಿ ಬೇರೆ ಮುನಿಸ್ವಾಮಿ ಬಿನ್ನಪ್ಪ ಅದು ಬೇರೆ ಚಿನ್ನಯ್ಯ ಗುರೆಡ್ಡಿ. ಅದಕ್ಕೆ ರೆಕಾರ್ಡ್ಸ್ ಆಫ್ ರೈಟ್ಸ್ 157 ಅಂತ ಹಾಕ್ತಾರೆ ಕಾಲಮ್ 9 ಅಲ್ಲಿ.
ಚಿನ್ನಯ್ಯ ಇಸ್ ಫಾದರ್ ಆಫ್ ಯುವರ್ ವೆಂಡರ್.
No, my vendor purchases the property from Chinnaya. The grandfather. The grandfather of Gopalida. Grandfather, opposite. ಅದನ್ನ ಕಾಲಮ್ ನಂಬರ್ 9 ಅಂತ ತಾವು ನೋಡಿದ್ರೆ 157 ನಂಬರ್ ಕೊಟ್ಟಿದ್ದಾರೆ ಬ್ರಾಕೆಟ್ ಅಲ್ಲಿ. against name of Guru Chinnaya.
ಯಾವ ಇಯರ್ ಇದು?
This is of the year, Canada signature date is 20th/6/27. Column 10 Canada, Barona Canada date is 20th/6/1927.
Yes, right.
ಕಾಲಮ್ 8 ಒಳಗೆ ಡೇಟ್ ಇದೆ 17/5/45. ಕ್ರಯಪತ್ರ ಕಾಲಮ್ 8, ಕಾಲಮ್
17/5/45.
45.
ದಿಸ್ ಇಸ್ ಆ ಟೈಮ್ ಮಾಡಿದ ಎಂಟ್ರಿ ಇದೆ. ಹಕ್ಕಿನ ಸ್ವಭಾವ. ಈಗಿರೋ
ಅದಕ್ಕೆ
ಹಕ್ಕಿನ
kindly-
ಪ್ರಕಾರ ಇದೆ, ಅವಾಗ ಸ್ವಭಾವ ಅಂದ್ಕೊಂಡಾರ ಅವರು. ಈಗಿನ ರೆಕಾರ್ಡ್ ನಲ್ಲಿ ಹಕ್ಕಿನ ಪ್ರಕಾರ ಇದೆ.
That is the relevant column. 10 is.
So 17/5/1945. This is because of Kraya, some sale deed has taken place.
ಅದು registration number 3244 of 26/27.
Correct.
Registration number ಅದು.
Registration ಅಂದ್ರೆ sale deed.
3244
Sub-registrar.
Commissioner registration number.
ಹಾ.
3244/20th/6/27.
It's a mortgage.
Mortgage. Mortgage. This mortgage deed I have produced at page 22.
ಇದು ಈಗ ಎಕ್ಸಿಬಿಟ್
Exhibit mark ಆಗ್ಬೇಕು ಈಗ.
ಇಲ್ಲೇ ಇದೆಯಾ ಈಗ ಅದು? ಏನಂತ ಇದೆ ಅದರಲ್ಲಿ ಮಾರ್ಗೇಜ್ ಡೀಡ್ ನಲ್ಲಿ?
This the original propositor has mortgaged the property. He calls himself as the son of Gurappa. In this ILR and error also, there is a Chinnappa is described as son of Gurappa.
ಗುರೆಡ್ಡಿ ಅನ್ಕೊಂಡು ಇನ್ನೊಂದ್ ಕಡೆ ಇದೆ.
Reddy, Gurappa, and they say Nanjundappa. But the fact remains that property is one and the same.
ಎಲ್ಲಿದೆ ಡಿಸ್ಕ್ರಿಪ್ಷನ್ ಆಫ್ ಪ್ರಾಪರ್ಟಿ?
Schedule ಅಲ್ಲಿ.
ಟೈಪ್ಡ್ ವರ್ಷನ್ ಇದೆ ಪೇಜ್ 16 ಒಳಗೆ.
ಹಾ.
ಟೈಪ್ಡ್ ವರ್ಷನ್ ಕಣ್ಣಿಗೆ ಸುಖ ಆಗುತ್ತೆ.
ಪೇಜ್ 22. ಮೂವತ್ತೇಳನೇ ನಂಬರು ಖುಷ್ಕಿ 9 ಎಕರೆ.
Entire 9 acres is 21 guntas. Original 9 acres, 21 guntas. Mortgage in 1927. Typed copy I have produced it.
ಇನ್ನೊಂದು ಇದು ಇದೆಯಲ್ಲ ಏನದು?
Thereafter, he sells the property to this Muniamma. On 4/9/51, typed copy at page 29. 31 copy are produced.
ಅವ್ರೇನು ಅಬ್ಜೆಕ್ಷನ್ ಹಾಕಿಲ್ಲ ಇದಕ್ಕೆ?
ಹಾಕಿಲ್ಲ. And then
ಹಾಕಿದೆ ಅಂತ ಹೇಳ್ತಾರೆ.
ತೋರಿಸಿ.
ರೆಕಾರ್ಡ್ ನೋಡಿ ಹೇಳಿ.
ಅಲ್ಲ ಇದ್ರ ಮೇಲೆ ನೀವು ಹೇಳ್ಬೇಕು, ಯಾಕಂದ್ರೆ at the hearing Supreme Court said when the matter is being heard, we have to treat the application.
If the application is rolled,
Additional evidence under 4127, Supreme Court said in 2006 that it should be treated when the main matter is being heard on merits.
and conclusion has to be reached that without this document, no judgment can be pronounced. Constitution bench.
Correct. ಹಂಗಾಗಿ ಇದ್ರ ಮೇಲೆ ನೀವು ಹೇಳ್ಬೇಕು, ಇದು this is a private document placed in the public office.
Yes.
Copy, certified copy of the private document, therefore it partakes the character, and is more than 30-year-old. So it partakes the character of the public document itself.
My lord will have to pronounce on relevance
Correct.
and its direct link to the pattern issue. And it has the tendency to resolve the issue.
Now, provided you have taken up a stand on that, by oral argument that cannot be said.
You have the duty, I am arguing, I am answerable, like that. You can't say that I was not there.
Because since the apex court said we have to hear that application along with the main matter, we are asking this question. Mr. Surana draws our attention to application in IA number
IA number 1 of 23. 1 of 23.
1 of 2023. filed under order 41, rule 27 of
7th
CPC,
January 23 accurate.
seeking leave of the court to produce additional evidence. Produce certain documents by way of additional evidence. First off, he also points out that there is no objection filed to the said application. First, he took us through the index of records. Certified copy either. Certified copy issued on 20 September 2022 by Tahsildar Grade 2 of Bangalore Dakshina Taluka. Which mentions name of Chinnaya,
Chinnaya bin
son
Reddy.
of Reddy
Against
at column 7,
against survey number 37.
comma. A registered mortgage deed dated 17/5/1945 at column number 8. ಅದು 10 ಅಲ್ಲಿ ಏನದು ಕಾಲಮ್?
Encumbrance.
And the encumbrance is reflected at column 10.
ಅದೇ ಮಾರ್ಗೇಜಸ್ ಮುನಿಯಪ್ಪ ಮತ್ತು ಮಲ್ಲಯ್ಯ ಅಂತ 300 ರೂಪಾಯಿಗಳ ಆಧಾರ ಮಾಡ್ತಾರೆ.
It speaks of survey number 37 at measuring 9 acres
21 ಗುಂಟೆ.
9 acres 21 guntas. Full stop. A copy of the said a certified copy of the said mortgage deed is also produced.
That is obtained on 5/1/23.
Comma, the same having been obtained on 5/1/2023 from the jurisdictional sub-registrar's office. ಮುಂದಿನ document ಏನದು?
Then now there is a sale deed executed by this Chikka Chinnanna.
Sale deed executed by
Chikka Chinnanna in respect of 6 acres of land on 4/9/1951 in favor of Muniyamma.
ಚಿಕ್ಕ ಚಿನ್ನಣ್ಣ ಯಾರು?
ಅದೇ
ಚಿನ್ನಯ್ಯನೇ.
ಪ್ರಪೋಸಿಟರ್. ಚಿಕ್ಕ ಚಿನ್ನಯ್ಯ ಚಿನ್ನ ಎಲ್ಲ ಒಂದೇ.
ಚಿಕ್ಕ ಚಿನ್ನಣ್ಣ SINNA. ಚಿಕ್ಕ
Property is same. See, the name is described.
You are not in witness box. I'm
not-
not cross-examining you.
Please.
Kindly look at page 29.
ನಾನು ಹೇಳ್ತಾ
Page
ಇದ್ದೀನಿ.
29. ಚಿಕ್ಕ ಸಿದ್ಧ ಅಲ್ಲ ನೇಮ್ ಸರಿ ಯಾಕೆ ಮಿಸ್ಟರ್ ಅಬ್ದುಲ್ಲಾ ಶರೀಫ್ ಅಂದ್ರೆ ಇಟ್ ಕಾಂಟ್ ಬಿ. ಚಿಕ್ಕ ಸಿನ್ನಣ್ಣ SINNA.
ಸನ್ ಆಫ್ ಯಾರು? ಸನ್ ಆಫ್
ಚಂದ ಬರ್ದಿಲ್ಲ ಅದನ್ನು.
ಬರ್ದಿಲ್ಲ.
ಬರ್ದಿಲ್ಲ.
ಆ ಡಾಕ್ಯುಮೆಂಟ್ ನಲ್ಲಿ ಇವರ ಮಗ ಅಂತ ಬಂದಿಲ್ವಾ? ಸಾಮಾನ್ಯ ಓಲ್ಡ್ ಡಾಕ್ಯುಮೆಂಟ್ ನಾಗೆಲ್ಲ ಇರ್ತಿತ್ತು.
ಎಷ್ಟು ಓಲ್ಡ್ ಇಂಡಾಸ್ ಮೇಲೆ ಚಿಕ್ಕ ಚಿನ್ನಣ್ಣ ಅದರಲ್ಲಿ ಇದ್ದಿದ್ದು ಚಿನ್ನಣ್ಣ ಚಿನ್ನಯ್ಯ ಇವರೇ ಬಳೆಗುರೆಡ್ಡಿ. But the property, the same property is transacted. You see, if there is some mistake in writing the name, it does not mean that sale deed is void.
We are not saying that, but while let us tell the truth.
Very well. Then they say truth is visible. I can't read anything else than what is there.
He also draws our attention to another document, which is a certified copy of the sale deed dated
4/9/51.
4/9/1957 alva. 57 alva ಅದು.
51.
51 ಅದು. 51.
47 mortgage deed, 51 sale deed at page 29. Page number 29.
51. Which comprises of 6 acres of land in survey number 37.
Sold in favor of Muniyamma.
Sold by one Chikka Chinnanna in favor of
Muniyamma.
Muniyamma, wife of Nanjappa.
Muniyamma, wife of Nanjappa. First off, Surana says, this Chikka Chinnanna is none other than Chinnaya alias Chikka Chinnaya.
Because the property is same.
In as much as the document refers to the very same property and buyer's identity not being in dispute. Because you have not dispute. First. However, learned senior advocate Mr. Shankar orally submits that this Chikka Chinnanna, there is no evidence on record to say that this Chikka Chinnanna is none other than Chikka Chinnaya alias Chinnaya. First. But ಬೇರೆ document ಏನು?
When there is a mortgage deed executed by.
Notice extent ಬೇಕಲ್ಲಿ. The extent is
6 ಎಕರೆ.
6 ಎಕರೆ ಅದು ಬಂದಿಲ್ಲ.
ಬಂದಿದೆ.
6 ಎಕರೆ.
ಹೋದ್ರಿ ಒಂದ್ಸರಿ ಬಂದಿದೆ.
Very sorry.
Then there is a mortgage deed
ಹಾ.
executed by the plaintiff's father and Gopal Reddy. And Gopal Reddy's father, Allah? Gopal Reddy's father. Page 34.
ದೊಡ್ಡ ಗುರೆಡ್ಡಿ ಅದು.
Purchaser. Allah, the
ಕೃಷ್ಣ ರೆಡ್ಡಿ.
Chinnappa. Kindly see page 34.
41 is typed copy ತಾನೆ?
ಹೌದು. ಅಲ್ಲಲ್ಲ. 34 is typed copy.
34 is typed copy.
Mortgage deed. Mortgage deed at the page 32. Page 32 mortgage deed.
ಹಾ.
ಇದರಲ್ಲಿ for 500 rupees, the mortgage is created by both the sons of Chinnappa. Fourth line.
Sons of ಚಿನ್ನಪ್ಪ.
Fourth line ಅಲ್ಲಿ ಸೋಮಸುಂದರ ಪಾಳ್ಯದ ಗ್ರಾಮವಾಸಿ ಚಿನ್ನಪ್ಪನವರ ಮಕ್ಕಳು ಆದ ಕೃಷ್ಣಪ್ಪ ಮತ್ತು 30 ವರ್ಷ ವಯಸ್ಸಿನ ಮುನಿಸ್ವಾಮಿ ಮೇಲ್ಕಂಡ ಕೋಆಪರೇಟಿವ್ ಸೊಸೈಟಿಗೆ ಬರೆದುಕೊಂಡ ಮಧ್ಯಾವಧಿ ಸಾಲ. They mortgaged 2 properties.
ಕೃಷ್ಣಪ್ಪ ಯಾರು?
Krishnappa is the brother of this plaintiff's father.
He is Krishna Reddy. Plaintiff's father is Krishna Reddy, not Krishnappa.
ಅಲ್ಲ ಒಂದು ಕ್ರಾಸ್ ಎಕ್ಸಾಮಿನೇಷನ್ ದಲ್ಲಿ ಕೃಷ್ಣಪ್ಪ ಕೃಷ್ಣ ರೆಡ್ಡಿ ಒಂದೇ ಅಂತ
ಅಲ್ಲ, he may known by that name. In all records, revenue records is Krishna Reddy. I mean, that is my case. In all the revenue records.
Your client has admitted.
Krishna Reddy.
Your client has admitted in cross examination in 2009.
He has admitted that he is also known by that name. That is possible, but in documentation, the name is different, Krishna Reddy. In all the revenue records is Krishna Reddy. Now, we are here, not ಅಂದಾಜಿನಲ್ಲಿ ನಾವು ಮಾಡ್ತಾ ಇಲ್ಲ, accurate ಆಗಿ ಮಾಡ್ತಾ ಇದ್ವಿ. When the evidence is to be read, it has to be read as the records stand.
No, your client has admitted, Mr. Shankar, your stand is unsustainable
Admitted
because
is known by that name.
at 3 places in his cross examination, he has admitted that Krishna Reddy and Krishnappa are one and the same. I have seen the paper. Perhaps I will show that. Wait for one.
No,
minute.
please don't take the trouble. Don't take the trouble. I am not denying my lord's question.
ಇದೆ.
He is known by that name ಅಂತ ಹೇಳ್ತಾರೆ.
ಅದೇ ಮತ್ತೆ ಅದು ಅರ್ಥ ಏನು? ಅವರು ಒಂದೇ ಅಂತಾನೆ.
No,
ಇಲ್ಲ ಒಂದ್ ಕಡೆ ಅವ್ರು ಅವರೇ ಅಂತ ಹೇಳಿದ್ದಾರೆ.
no.
ಇನ್ನೊಂದ್ ಕಡೆ ಆ ಹೆಸರಿನಿಂದನೂ ಅವ್ರು ಕರೆಯಲ್ಪಡ್ತಿದ್ರು ಅಂತ ಹೇಳಿದ್ರು.
The fact that he is known socially or in the society in that manner is not an issue. What is the issue is when documentation comes, his real name alone comes. ಅಲ್ಲದೆ ಉರ್ಫ್ ಅಂತ ಬರ್ಬೇಕು. That is not there.
Next, Surana
This is a
relies upon a certified copy of another mortgage deed dated
51ನೇ ಇಸ್ವಿ ತಾರೀಕು 2 ಮೇ. 2nd May
5/1958,
51.
58, 1958. Whereby Krishnappa
and his brother,
and his brother Munishami,
both sons of
both
Chinnappa,
sons of Krishnappa,
plus
sorry,
sons of Chinnappa.
Chinnappa, have mortgaged just property,
Two properties.
inter-alia, the land in survey number 37,
37/2, 3 acre 5 gunta,
bar 2, measuring
3 acre 5 guntas.
3 acre 5 gunta, 3 acre 5 guntas.
And 36/1.
ಅದೇನ್ ಸಂಬಂಧ ಇಲ್ಲ ರೀ. ಅದೇನ್
Now
ಸಂಬಂಧ?
kindly bear in mind, this Chikka Chinnanna sold 6 acres. Prior to this,
ಚಿಕ್ಕ ಚಿನ್ನಣ್ಣ ಸೊಲ್ಲಿ, yes.
sold 6 acres in 1951. What remained is 3 acres and odd. 3 acres and odd is, see, the mortgage here.
Okay, first off, yeah, he adds that this piece of that survey number is after the sale deed dated.
Sale deed by executed by Chikka Chinnanna,
Date ಹೇಳಿ.
dated 4/9/51.
Dated 4/9/1951. ಅದೇನು ಇದು
ಇದು 6 ಎಕರೆ ಮಾರ್ತಾನೆ.
ಮಾರ್ಕ್ ಆಗಿದೆಯಾ?
Chinnaya sells 6 acres.
ಅಲ್ಲ, ಅದು ಮಾರ್ಕ್ ಆಗಿದೆ ಏನಂತ ಆಗಿದೆ ಎಕ್ಸಿಬಿಟ್.
ಅಲ್ಲ, ಈಗ ಮಾರ್ಕ್ ಮಾಡಬೇಕು, page 29.
ಅಲ್ಲ, ಇದಾಯ್ತು.
ಅದೇ.
ಈ 1951 ಹೇಳಿದ್ರಲ್ಲ, ಅದು ಸಹಿತ ಮಾರ್ಕ್
ಮಾರ್ಕ್ ಆಗಿಲ್ಲ,
ಇದರಲ್ಲೇ ಬಂದಿದ್ದು,
ಬಂದಿದೆ.
which is already referred to. Full stop. Mr. Shankar raises issue as to identity of the executants. Okay.
Now, the
Next
land
step.
is same, what remains is sold.
ಮುಂದಿನ ಹೇಳಿ.
Then kindly turn to page 41. I have produced
41.
certified copy of the sale deed dated 20th/9/1965.
41. ಇದ್ಯಾವ್ದಿದು?
Sale deed dated 20th/9/1965.
65.
65. What Muniamma purchased in 1951 a portion is sold.
ಎಷ್ಟು? 1 ಎಕರೆ 26 ಗುಂಟೆ ಎಷ್ಟದು?
1 ಎಕರೆ 20 ಗುಂಟೆ.
20 ಗುಂಟೆನಾ?
ಹೌದೌದು.
ಅದು 1.5 ಎಕರೆ ಆಯ್ತು.
ಇದೆ, ಅಲ್ಲ ಇದೆ. ಪಾಸ್ ಆನ್ ದಿ ಚಾರ್ಟ್ ಮೇಲೆ.
ನಿನ್ನೆ ಕೊಟ್ಟಿದ್ದು ಇದೆ. Yet another document is a certified copy of registered sale deed dated 20 September 1965, whereby Muniamma sold 1 acre 20 guntas
in favor of
Krishna Reddy alva?
Krishna Reddy, son of Dodgur Reddy.
Krishna Reddy, son of Dodda Gurreddy. ಮತ್ತೆ
Another sale deed at page 48, dated 19/3/68. Muniamma purchased 6 acres, so she sold 1 acre 20 guntas. Remaining land is sold under this sale deed dated 19/3/1968 in
The-
favor of
other document is certified copy of the sale deed dated
19/3
19/3
1968
1968.
9.5. top it.
in favor of Hanuman Shetty, that same Muniamma.
Whereby the said Muniamma, ಎಷ್ಟು ಎಕರೆ ಇದು?
See, 1 acre 20 guntas sold earlier, remaining extent is sold here.
Huh?
Remaining extent,
ಎಷ್ಟು?
3 ಎಕರೆ 24 ಗುಂಟೆ.
Muniamma sold the remaining extent of land in survey number 37.
7.
That is 4 acres, 3 acres.
3 ಎಕರೆ 24 ಗುಂಟೆ ಪ್ಲಸ್ 1 acre 12 ಗುಂಟಾಸ್.
ಅದು ಮೊದಲಿಂದ 1 acre
ಇದರಲ್ಲಿ ಮುನಿಯಮ್ಮ ಸೇಲ್ ಮಾಡೋದು 2 ಐಟಮ್.
ಎರಡು ಇದರಲ್ಲೇ ಸೇಲ್ ಆಗಿದೆ.
2 ಸೇಲ್ ಅಲ್ಲ. 1 acre 20 guntas is sold out of 6 acres. Remaining land 4 acre and odd is sold under this deed.
That comes to what?
4 acres, 36 guntas.
4 acres, 36 guntas. To one
Narayan Shetty, son of Anand Shetty.
Narayana Shetty.
ಹೌದು 12, 24, 36 ಗುಂಟೆ. 4 ಎಕರೆ 36 ಗುಂಟೆ.
Son of Hanumanta Shetty.
Hanuman Shetty. Now, from this Krishna Reddy son of
ಅದಕ್ಕೆ ಗೋಪಾಲ್ ರೆಡ್ಡಿ is a witness.
ಯಾವುದಕ್ಕೆ?
Page 51 ಬನ್ನಿ.
21.
Which is this Gopal Reddy in your family tree ದಲ್ಲಿ ಒಂದು ಗೋಪಾಲ್ ರೆಡ್ಡಿ ಅಂತ ಇನ್ನೊಂದು ಅವ್ರೇನೋ ಬೇರೆ ಯಾರು?
ಎಂ ಗೋಪಾಲ್ ರೆಡ್ಡಿ ಇವರು.
ಇವರು
ಎಂ ಗೋಪಾಲ್ ರೆಡ್ಡಿ.
No, SM
ಗೋಪಾಲ್ ರೆಡ್ಡಿ.
ಬೇರೆ.
ಬೇರೆ.
ನಿಮ್ಮಲ್ಲಿ ಯಾರು ನಿಮ್ಮ ಜಿಯಾಲಜಿಕಲ್ ಟ್ರೀ ತೆಗಿರಿ.
ನಮ್ದು ಗೋಪಾಲ್ ರೆಡ್ಡಿ, ನಮ್ದು ಇದು ಎಂ ಗೋಪಾಲ್ ರೆಡ್ಡಿ ಅಂತ ಹೇಳಿದ್ರು.
ಇಂಥ ಒಂದು ಎರಡು ಕೇಸ್ ಆಗುತ್ತೆ ಹುಚ್ಚಾಸ್ಪತ್ರೆಗೆ ಹೋಗಾಟ. ಎಷ್ಟು ಅದೇ ಹೆಸರೆಲ್ಲ ಡೂಪ್ಲಿಕೇಶನ್ ಆಫ್ ನೇಮ್ಸ್.
So there is no, now we have to see the evidence. We don't know who are the witnesses.
ಅಲ್ಲ ನಿಮ್ ಕೇಳ್ತಾ ಇದ್ದೇವೆ ಅದಕ್ಕೆ.
ಅಲ್ಲ ನಾನು ಹೇಳೋದಕ್ಕೋಸ್ಕರ ಎವಿಡೆನ್ಸ್ ಇರ್ತಾನೆ ಹೇಳಕ್ ನಾನು. There is no evidence on record. Who are the witnesses? But these are the old documents. It is difficult many times to answer the.
ಇಲ್ಲ. Three reasons payment is not. More than 30 years.
ಎಲ್ರಿ ನೆನ್ನೆ ಇರ್ಲೇ ಇಲ್ಲ ನೀವು.
Even 27, they are treated on par with suit. ಅವರು section ಹಾಕೊಂಡು ಈ ಡಾಕ್ಯುಮೆಂಟ್ಸ್ ಮೊದಲಾಗಿ ಪ್ರೊಡ್ಯೂಸ್ ಮಾಡಿಲ್ಲ.
See, we are the LRs.
Where have you stated?
We have stated in the affidavit. We are the LRs.
ಇಷ್ಟೇನಾ ಬೇರೆ ಇದೆಯಾ ಡಾಕ್ಯುಮೆಂಟ್ಸ್ ಇನ್ನು?
ಆಮೇಲೆ ಎನ್ಕಂಬ್ರೆನ್ಸು ಅಷ್ಟೇ ಇರೋದು. ಎನ್ಕಂಬ್ರೆನ್ಸು ಅದು.
Pursuant to these registered conveyances by way of sale deeds and mortgage deeds, entries in the encumbrance register are also marked. First off, the encumbrance certificates issued on 19/11/2022 and 28/11/2022 are also produced. They are 3 in number. First, we repeat, no objections are filed by the other side to this application. Although orally, some contentions were taken up with regard to identity of executants because of the a little variation in the names, such as Chinnaya being called as Chikka Chinnanna or Chinnappa, Krishnappa being called as Krishna Reddy, Gureddy being called as Gurappa. Gurappa adane adu ididdu?
ಹೌದು.
Gurappa. First, okay.
how such documents to be treated by way of additional evidence? Mr. Shankar, in your book, you have written two judgments. It is not that in every case the court should remand the matter. And there are two options which you have quoted. I have
Keep
just
the original
reproduced.
file, appeal file here, call for a limited remand.
Even for that you have said, that is not the only thumb rule. You have written in your CPC, saying, you have written in your CPC, yes, that is not the thumb rule. Of course, in your words you have written, you have quoted two judgments also. There you say, the court can call for evidentiary report from the court below of its choice, or if there is prima facie material vouching the evidentiary material, court can straightway mark the document, more particularly when no objections are filed by the other side. We are holding what you have written to you.
In one of the cases, the honorable registrar was directed to record evidence and submit to the court. That's also that is, this honorable court would record evidence through the honorable registrar or limited remand so that the delay could be.
What is the law on the point?
I'll pass on the judgments, madam.
ಏನಂತ ಹೇಳ್ತಾರೆ?
In the circumstances in which we are placed, my submission is the additional evidence may be permitted because these are the LRs of the parties and these are the very old documents,
Certified copies of.
certificate copies.
ಹಂಗಾಗಿ rule 90.
Presumption is not applicable to certified copies.
Section 90 is not applicable.
The matter is clear and pronouncement is, I think.
The presumption applies to the
Certified
certificate
copies also.
Well, it's position is
Section 90, what we have been taught in law school is, section 90 of the Evidence Act, which enacts the rule of validity, presumptive validity.
rule of caution.
No, rule of presumptive validity in respect of documents which are 30 years or more old is in respect of originals.
The first judgment I rely upon is 30 years old document.
Again, a document avashyakate. The question is not that.
Yes,
That is everybody knows in the court hall. Question is whether that section 90 applies to certified copies of the documents. What is the law on the point? What Amir Ali and Sarkar say?
It should be original, it should come from proper custody and it should be the lawful.
ನಮ್ಗೆ ಏನ್ ಗೊತ್ತಿಲ್ಲ ಈಗ.
Well, I am a student, therefore I am saying it from the principle, basic
I
principle.
am a student under a student now. So you have to teach us law. Now,
But
our
this is-
impression, reading
Yes,
Rupert Cross on evidence, is that the ordinarily such a presumptive rule, which is there in English law of evidence also, is that such a presumption does not extend to
Custody.
certified copies, but original.
custody and lawful,
Original documents coming from proper custody.
and it should not be a stolen document, therefore lawful possession. Stealthily it should not come to the court, it should be lawful possession. Number with, he must have the power and custody.
Gujanagide view, 1971 Supreme Court says, even if a stolen document comes, what the court has to see is it a genuine document and whether it is admissible.
That is
71 Supreme Court.
That is under 142 minute. That's under
Illa,
142.
no, not on 42.
But they
No,
have,
no,
the-
no, no.
they
No,
have
sir,
the
no,
power
sir, no,
to
sir.
do it, but nobody else
Supreme
can
Court
imitate.
rejected that contention.
Uh,
71 Supreme.
But
Yes, next.
custody and it should be original.
Like it partakes the character of original because the original is
They're
better.
asking, ಹಂಗೆಲ್ಲ ಹೇಳೋದ್ ಬೇಡ, ಹಂಗೆಲ್ಲ ಸುಮ್ಮನೆ ಲೂಸ್ ಆರ್ಗ್ಯೂ ಮಾಡಬಾರ್ದು. Whether that presumptive rule applies to certified copies of the documents, ಅಷ್ಟೇ ಹೇಳ್ಬೇಕು. ಸುಳ್ಳೆ ಟೈಮ್ ವೇಸ್ಟ್ ಮಾಡಬಾರ್ದು.
I'll come back to the honorable court.
All, that's good thing. ಇಷ್ಟು ಜಡ್ಜ್ಮೆಂಟ್ ಕೊಟ್ಟಿರಲ್ಲ, ಯಾಕೆ ಕೊಟ್ಟಿರಿ ನಾವು? ನಾವು ಓದ್ತೇವೆ ಬೇಡ ಅಂತಲ್ಲ, ಬೇಕಾದಷ್ಟು ಟೈಮ್ ಇದೆ ನಮಗೆ. ಆದ್ರೆ ಯಾವ್ದು ಪ್ರಪೋಸಿಷನ್ ಹೇಳ್ಬೇಕು, ಈ ಪ್ರಪೋಸಿಷನ್ ಇಂಥ ಜಡ್ಜ್ಮೆಂಟ್ ನಲ್ಲಿ ಇದೆ, ಹಂಗ್ ಕೊಡಿ ನಾವು ತೋತೇವೆ. ಹಿಂಗೆಲ್ಲ ಕೊಟ್ಟು ತೊಳೋದಿಲ್ಲ ನಾವು.
ಅಲ್ಲ, kindly,
ಅದನ್ನ ನಾವು ಚುರುಮುರಿ ತಿನ್ನಕ್ ಉಪಯೋಗಿಸ್ತೇವೆ ಅಷ್ಟೇ.
kindly turn to
With due
para
respect.
13 of the judgment. madam.
ಏನಂತ ಹೇಳ್ತಾರೆ
Para 13,
ಹೇಳಿ,
certificate copy ಬೇರೆ ಇರ್ತದೆ.
ಹೇಳಿ,
2021 AR 899.
ಓದಿ ಪ್ರಪೋಸಿಷನ್.
There is a presumption that a registered document is validly executed. A registered document therefore prima facie valid now. The onus of proof thus would be on the person who leads the evidence to rebut the presumption. In the instant case, the respondent has not been able to rebut the presumption.
Presumptive validity of
registered document.
registered document which is compulsorily registrable. 2004 Supreme Court. Surana submits that a document which is compulsorily registrable under section 17(1) of Registration Act 1908, if registered, raises a strong presumption as to its validity. AR
AIR 2021,
2021,
899,
SC 899,
89, para 32,
para 32.
and,
Next,
and para 60.
all right, next.
Next is,
Therefore, he submits that the formal proof of execution should be dispensed with. Okay.
the next is that when no evidence is led about to say that this is a joint family property by the plaintiff, defendant need not need any evidence.
Next point. Mr. Surana next argues that although there is presumption of joint Hindu family, existence of joint although there is a presumption of jointness of family amongst Hindus, it does not extend to the property being joint Hindu family joint family property, and in the absence of evidence, plea cannot be treated. Yes.
I rely upon 2003 Supreme Court 3800.
AR 2003 Supreme Court 2800 paragraph.
Paragraphs 17, 18.
Okay, next.
Next
point.
judgment is also on the same point.
Same point, mal repeat duplication mabadi.
2007.
Only Article 141 says, again we are saying, it says law declared by the Supreme Court, not law repeatedly declared by the Supreme Court.
All the three judgments are on the same point.
All right, one day helbek. I choose one. We will not duplicate law.
Then the other judgment is 2019 6 Supreme Court, page 82.
For the proposition?
Order 41 Route 27.
That we have seen, Bidi.
Idರಲ್ಲಿ para 32 ನಲ್ಲಿ, if there is a reference of the documents which are produced before the court, if there is a reference of a particular document which is produced before the court, but that document which has referred to is not produced, it can be admitted in the evidence.
That's all right.
Therefore, in the sale deed, in the sale
Question
deed,
is not that. It can be produced by way of additional evidence is one thing. Question is whether formal proof of execution is required or not. On that position, Sindh High Court judgment ide, ಸ್ವಲ್ಪ ನೋಡ್ಕೊಂಬಂದ್ರೆ ಅನುಕೂಲ ಆಗ್ತದೆ. There is a Sindh High Court judgment ide ಅವರ ಮೇಲೆ, ಒಳ್ಳೆ judgment ide, which Amir Ali and Woodruff
and Amir
mentioned that. ಅದು ನೋಡ್ಕೊಂಬನ್ನಿ.
Monday.
Any number of judgments, 41, 27. Mr. Shankar has written
I have given about
plethora of judgments on that.
I have given about
But ಈ ಪಾಯಿಂಟ್ ಅನ್ನ ನೀವು ಆನ್ಸರ್ ಮಾಡಿ.
series of judgments on the admissibility of the document.
ಅಲ್ಲೆಲ್ಲ ಏನ್ ಹೇಳಿದ್ದಾರೆ ಗೊತ್ತಾ? ಇಷ್ಟೇ ಹೇಳಿದ್ದಾರೆ. Production of additional evidence with leave of the court under 4127 is permissible at any stage of the proceeding. Number one. Number two, where such application is moved, the application has to be treated along with the main matter after giving an opportunity to the other side. But our point is production
whether formal evidence is required or not. I followed it.
Of execution is.
I followed it. I followed it.
ಅದನ್ನ ಕೊಡ್ಬೇಕು.
2000?
I think only Sindh High Court has treated, to my limited knowledge, reading, only Sindh High Court has treated this aspect of the matter.
The Constitution bench has said it has to be additional evidence admitted without objection. The party cannot challenge it and it has to be admitted.
That is not the
ಅದು
proposition.
ಮುಂಚೆನೆ ಹೇಳ್ಬಿಟ್ರಿ. That is paragraph 21 ಇದೆ Constitution bench.
ಅದೇನು ಅಪ್ಲೈ ಆಗಲ್ಲ. ಯಾಕಂದ್ರೆ ನೀವು ಅಡ್ಮಿಟ್ ಮಾಡ್ತಾ ಇಲ್ಲಲ್ಲ ಈಗ. ಅದಕ್ಕೆ
ಅದು
ಆಯ್ತು.
admission of document, ಅದು objection as to the admission of document ನಲ್ಲಿ ಅದು ಬೇರೆ at the time of trial. Suppose if the party keeps quiet and allows the admission of the document to the record, subsequently he cannot turn around and say,
Yes.
this document ought not to have been admitted. ಅದ್ರ ಮೇಲೆ ಇದು additional evidence ಮೇಲೆ ಅಲ್ಲ ಅದು.
Once marked,
Sin
cannot
the-
be objected to later stage on the ground of.
1959 sin, my lord?
Huh?
59 sin the?
Yeah, sin the old judgment ಅದು before partition ಅಂತ.
ಅದೇ 59 sin the ನಾನೇನೋ ಒಂದು.
ಇಲ್ಲ, ಇಲ್ಲ.
Not good.
90s ಅಲ್ಲಿ ತುಂಬಾ ಬಂದಿದೆ.
ಹೌದು, ಬಹಳ ಬ್ಯೂಟಿಫುಲಿ ಟ್ರೀಟ್ ಮಾಡ್ಯಾರ. That has remained in my memory pond very strongly. That proposition is so beautifully treated. Well, it is not that in every case the formal execution, proof of execution should be sought for. Where it should be sought for, where it should not be sought for. Beautifully.
Stamp duty,
Ah.
relevance, admissibility and registration. These are that is the 84 Supreme Court.
ಅಲ್ಲಿ ಒಂದು aspect ಅಂದ್ರೆ Supreme Court said in number of judgments, if a document which is compulsorily registrable is registered, then presumption of validity.
Yes, how?
Those who want to attack that, you should place the material to show that it could be a presumption, the object of presumption, familiarly rights, withdraw familiarly right under 114 of the Evidence Act. The object of presumption is to dispense with the proof.
ಅಷ್ಟೇ, at that moment.
That's it.
ಈಗ-
Unless rebuttal opportunity ಇದೆ.
Yes,
ನೀವು
okay.
ರಿಬಟಲ್ ಏನು ನಿಮ್ಮ ಅಬ್ಜೆಕ್ಷನ್ ಹಾಕಿಲ್ಲ ನೀವು ಇದಕ್ಕೆ ಅಪ್ಲಿಕೇಶನ್ಗೆ
But the appeal has been orphaned.
ನೋಡ್ಕೊಂಡು ಹೇಳಿ. But Supreme Court said, a document which is stolen and produced, if otherwise admissible, should be admitted by the court. For stealing, you can take action against him.
ಅದು
You have stolen it from us. ಹೌದು.
the process
ಹಂಗ್
of-
ಮಾಡ್ಬಿಡಿ, 17
ಯಾವ್ದು ಇದೆ, the process of making it available to the court is not to be looked into, the document is to be looked.
ಹಂಗ್ ಮಾಡಿದ್ದಾರೆ. But in America, there is one judgment which says, since we have adopted the due process of law as a constitutional doctrine, they say even the obtainment of the evidence
The means
should be
must-
lawful.
Means must justify the end.
ನಮ್ಮಲ್ಲಿ ಹಂಗಿಲ್ಲ.
That borrowed from Australia. Privy Council ಯಾವಾಗ ಅಲ್ಲಿ jurisdiction ಇರುತ್ತಲ್ಲ ಅಲ್ಲಿ.
Yes. ಆಯ್ತು. Next is the other one, right? First evidence. Fourth.
Nothing. No, nothing today.
ಬೇರೆ ಮ್ಯಾಟರ್ಸ್ ಇದ್ದಾವ? ಇಲ್ವಾ? First on fourth for further hearing. Yes. Three.
Advocate for the petitioner.
Lords, kindly
They're all-
stand on the respondent side, though I am
Right.
appearing for the petitioner.
There are cases of sub-registrars and senior sub-registrars who have en masse been sought to be transferred by the impute transferred order on the ground. And specifically on this, the challenge lies as far as my petition is concerned, on the ground that they have been in these areas for extended periods of time and that there are disciplinary proceedings against them, and therefore we are transferring them. Ex facie, if those are the grounds on which the transfer order and this classification has been made, that is punitive transfer, that must be stayed and set aside. This is the limited submission that I'm making in my petition. Moreover, there is already a general transfer guideline governing, which my lords are aware, of 2013, slightly tweaked and modified in 2024, June 2024, Ivaga, June 2024, where there are reasonable restrictions on transfers, that there will be a cap of 6%, so that there is no en masse transfer, that the activities or the administration of the department should not get adversely affected. Spousal considerations, children's considerations, academic considerations, none of that has been considered. All that they are saying is that you people as a gang
I have been working in BMRDA and 10 municipal corporations for the last so many years. It is, on that ground, my simple answer is this: it is not my fault. You could have transferred me at any point of time. If you chose to transfer me incorrectly and I happen to invoke the law for my protection and I am allowed by law to remain where I am, it is not my fault. Nothing tied your hands in transferring me in accordance with law. Therefore, to say that I have been in this position for the last 8 years, 10 years, as if it's my fault or I am supposed to feel guilty, there seems to be no justification. And the transfer order explicitly says, and in their objections, they explicitly say that one of the factors we have taken into consideration for identifying this separate classification is the number of disciplinary proceedings going on against you. That is conviction prior to inquiry. And that is punitive transfers. I mean, if there are disciplinary inquiries going on, nothing prevents you from finishing those inquiries. These inquiries have been pending for 8 years, 9 years. Reports have not been submitted. These are the grounds on which I am urging. I learned colleagues will also urge other grounds.
The main ground is Milord. DPA has framed the transfer guidelines right from 2001 according to the allocation of business rules. 2001, the first the administrative committee headed by the then law minister Ramaswamy, Arnaldi Ramaswamy. Then guidelines are framed 2001, 22/11/2001. Then this court held they have statutory force in H.N. Chandru's case. Then 7/6/2013 guidelines are again framed, modified by the DPR. Then 25/6/2024 guidelines are framed by the DPR, stating that these guidelines are applicable to all governments except wherever rules are holding the field, that department independently can do according to rules. Act or rules. There are 8 departments have framed the act and rules. Number 1, medical department. Number 2, education. Number 3, forest. Number 3, Panchayat Raj, police, forest. I have produced all those rules. Can they, the revenue department give an independent policy, which is contrary to the allocation of business rules. There are 37 departments in all of them.
Allocation of business.
Yes, I have produced it.
ಯಾವ section?
Schedule 2.
ಏನಂತ ಹೇಳ್ತದೆ?
Yes.
Service rules.
Page 258.
Yeah.
Directly, 258.
ನಿಮ್ಮ petition ದಲ್ಲ?
It petition number
29309.
Location.
29309. And this is preamble 8, page 258. These rules are framed.
Page number?
258, 258, A18. In excess of the power conferred by clause 2 and 3 of the Article 160 of the Constitution of India, the governor,
ಬಿಡಿ, ಅದು rules ಆಯ್ತು, ಮುಂದೆ ಹೋಗಿ.
then all allocation of business government among department of the secretariat, business of the state government shall be transacted in the secretariat.
ಆಯ್ತು, ಮುಂದೆ ಹೋಗಿ. ನಿಮ್ಗೆ ಎಲ್ಲಿ
next
power
one,
allocation ತೋರಿಸಿ.
Allocation for directly. Kind is 259 service rules. B.
Recruitment rules.
ಹೌದು. Then my lord, J,
applicable to.
page 260.
Of
Conditions of service.
service.
Appointed to service of the court in connection with the affairs of the state, excluding
Salaries, allowances, leave and pension, but including contract rules, etc., etc. Now, my lord, see, if an executive order is passed in lieu of making a service rule, it
Then-
would be covered by item 2 under
Item
category B of the business allotted to DPAR.
Then my lord 260.
1 second. ಅವ್ರು ಏನೋ ಹೇಳ್ತಾ ಇದ್ದಾರೆ. ಎಲ್ಲಿ ಕವರ್ ಆಗತ್ತೆ ಅದು?
It will be covered, my lords, making of any service rule or executive order where there is no service rule.
ಎಲ್ಲಿದೆ?
It will be covered
Rules
by
Relating to conditions of service of.
conditions of service. Transfer is a condition of service.
So rules relating to the conditions of service of persons appointed to service and posts in connection with the affairs of, that is civil servants.
Civil servant.
Salaries, allowances, leave and pensions. But it will not include Roman 1 to Roman 6.
Yes, Roman 6, that is called, but including.
But including.
Huh?
Including.
It includes conduct rules, CCA rules,
It includes.
Yes, my lord.
probation rules, seniority rules, medical attendance rules, confidential report rules.
ಅಲ್ಲ,
And-
but ಅಂತ ಯಾಕೆ ಬಂತು ಗೊತ್ತಾಗ್ತದೆ.
ಅದು ಬಟ್ ಎಕ್ಸ್ಕ್ಲೂಡಿಂಗ್ ಅಂದ್ರೆ ಬಿಕಾಸ್ ಸ್ಯಾಲರಿ
ಎಲ್ಲಿದೆ?
ಸ್ಯಾಲರೀಸ್ ಏನಾಗುತ್ತೆ ಅಂದ್ರೆ
Where is excluding? Where is the word excluding?
with the affairs of the state excluding salaries, allowances, leave and pensions.
Where you are reading?
That is, my lords, line 3, rules relating to the conditions of service of persons appointed to service and posts in connection with the affairs of the state, excluding salaries, allowances, leave and pensions,
But including.
but including,
ಅಲ್ಲಿ transfer ಅಲ್ಲಿ exclude ಆಗ್ತದೆ.
transfer does not exclude.
Is not excluded at
It
all.
is
it's
not
your stand.
excluded. Even if an executive order is to be made, it can be done only by the DPR.
No, if these rules are made, these are the norms.
Yes, ma'am.
ಇದು ಬೇರೆ ರೂಲ್ ಮೇಕಿಂಗ್ ಪವರ್ ಕೊಡತ್ತನ ಇದು.
My lords, rule making, what normally, my lords, after the Karnataka State Civil Service Act has come into force, everything related to conditions of service will have to be made by a rule under section 3 and section 8 of the Karnataka State Civil Services Act.
Even
Sometimes,
309 is excluded.
yes, ma'am, so that service rule has to be made only by the DPR according to this. Now, here we are with us in a situation where there is no rule made regarding transfer insofar as revenue department is concerned.
Correct.
Now, my lords, in exercise of this power under clause 2, a general transfer policy has been made by the state government on 25/6/2024, which applies to all the departments except where something is governed by either an act of the legislature or a rule made under the Karnataka State Civil Services Act.
ಇದ್ರಲ್ಲಿ ಮಾಡಿದಾರ ರೂಲ್ ಅಥವಾ act?
ಇದರಲ್ಲಿ ಮಾಡಲಿಲ್ಲ. So executive order has been issued by 25/6/2024 by the DPR, which clearly says that what are the exclusions? Exclusions, it clearly says, ಈ ಮಾರ್ಗಸೂಚಿಗಳು 2024-25ನೇ ಸಾಲಿನಿಂದ ಜಾರಿಗೆ ಬರುತ್ತವೆ. ವರ್ಗಾವಣೆ ಉದ್ದೇಶಕ್ಕಾಗಿ ಈಗಾಗಲೇ ಹೊರಡಿಸಲಾಗಿರುವ ಪ್ರತ್ಯೇಕ ಅಧಿನಿಯಮ, ದಟ್ ಈಸ್ ಲೆಜಿಸ್ಲೇಟಿವ್ ಆಕ್ಟ್, ನಿಯಮ, ಎ ಸ್ಟ್ಯಾಚ್ಯುಟರಿ ರೂಲ್ ಅನ್ವಯವಾಗುವ ಸರ್ಕಾರಿ ನೌಕರರಿಗೆ ಈ ಮಾರ್ಗಸೂಚಿಗಳು ಅನ್ವಯವಾಗುವುದಿಲ್ಲ.
ಹಾಗಾಗಿ ಅವ್ರು ಹೇಳೋದು ಆಕ್ಟ್ ಅನ್ನು ತೋರಿಸಿ ರೂಲ್ಸ್ ಅನ್ನು ತೋರಿಸಿ ಅಂತ.
I am also, I am siding with this same.
All of us are saying.
That is why
Same boat.
ನಾನು first again.
You said that you are standing this side.
Well, I am standing this side with my lord's leave, though I am leaving. ಯಾಕಂದ್ರೆ ಆ ಕಡೆ ರಶ್ ಜಾಸ್ತಿ ಆಗ್ಬಾರ್ದು. ಒಂದೇ ಟೇಬಲ್ ಇತ್ತು, ಆರ್ಗ್ಯುಮೆಂಟ್ ಇಲ್ಲ ಆರ್ಗ್ಯುಮೆಂಟ್ ಟೇಬಲ್ ಒಂದೇ ಇತ್ತು, ಅದಕ್ಕೋಸ್ಕರ ಈ ಕಡೆ ಬಂದೆ ನಾನು ಅಷ್ಟೇನೆ.
ಅಲ್ಲ, ಈಗ nowadays changing sides is not a new thing to us. Anyway.
My lord. My lords may not attach that to me, my lord.
Mr. Patil ಏನು?
Legal aspect is this.
The exclusion is where the field is occupied by the legislation or a subordinate legislation.
Or a subordinate legislation.
ಅಂತ ನಿಮ್ contention.
ಅದು ಇಲ್ಲದೆ ಇದ್ದಿದ್ದಕ್ಕಾಗಿ the general transfer notification which is issued
Will apply.
applies to all of us.
ಅದು ಅಪ್ಲೈ ಆದ್ರೆ ಏನಾಗತ್ತೆ?
ಅದು ಅಪ್ಲೈ ಆದ್ರೆ the transfer.
ಅದು ಅಪ್ಲೈ ಆದ್ರೆ
In fact, some of the.
ಅದು ಅಪ್ಲೈ ಆದ್ರೆ for this year we will have no transfer.
Transfers have been effected. Transfers have been effected according to guidelines. Kanditi, my lord, that also.
These
Yes, my lord.
employees only, similar
These
employees
employees.
only.
June, July after the transfer
Yes, ma'am.
24, transfers have been effected on
Effected.
subordinates
I put
the-
it, my lord.
On the basis of
of the June 2024 general guidelines.
Yes, my lord.
Which replaces.
which provides for exclusion also in that situation.
Yes, my
Where
lord.
field is occupied by legislation or a rule.
That's. And this argument is not, currently. we were-
How court has treated this
Yes, my-
argument?
My lord,
Not,
you
sir.
see,
Court has
in
noticed
the-
all the
in the
arguments, but declined to answer any argument
Yeah.
on the
Page-
ground. My lords may kindly turn to
34.
para 16 of the judgment, order, my lords. What it says is, looking to the arguments points of the learned senior counsel for the applicant side and the reply arguments by the learned additional advocate general, they are touching to the entire merits of the main application. As the learned counsels at the beginning of their arguments made it clear that they are arguing on the interim prayer of stay, we are confining our discussion only so far as interim prayer of stay is concerned. Otherwise, any
Matter ಇನ್ನೂ
discussion.
still pending ಇದೆ ಅಲ್ಲ
Yes,
legal?
my lord.
And that main matter is now listed for 11th of November for hearing.
In fact, my lord. you see
Readings are
para-
complete.
Lords.
One way of looking at this is, my lords, there are 8 working days remaining. According to the state, why they made the policy, what they said is, in the last 8 years, more than 5 years, we have been at existing places. All that I am saying is, if we have been there for 5 years out of 8 years here, by continuing us here for next 8 days, nothing is going to happen. Therefore, my lords, one way of looking at it is, anyhow, pleadings have been complete. They filed their reply statement. We have filed our rejoinders. Hearing date is also fixed on 11th of November. If status quo is maintained, till it is decided on merits, because the tribunal notices all our arguments and says that we do not want to give a finding, because if we say now, prima facie the policy appears to be wrong, then government's arguments will be shut out. If we say that it is valid, applicant's arguments will be shut out. It is like telling, my lords, I don't want.
ಕೇಸೇ ಅಷ್ಟೇ ಇದೆ.
Yeah.
ಅದ್ ನಿಮ್ನರ ಶಟಪ್ ಮಾಡ್ಬೇಕು ಅವ್ರನ್ನ ಆಪ್ಷನ್ ಇಲ್ಲ ಅಲ್ಲಿ court ಗೆ. ಮುಗಿಸ್ಬಿಟ್ರೆ ಆಗಿ ಹೋಗ್ತಿತ್ತು.
Allah, my
No,
lords,
in fact, one
this
submission.
is like saying, my lords, unless trial is concluded, I will not grant bail. Because one way or other, if I say, it will affect the,
Trial dates.
that is, my lords,
Yesterday, we had completed our pleadings on the day before yesterday, my lords. Yesterday, the matter was set out for hearing. At the beginning of the hearing itself, the court asked us, on behalf of the state, we said we are ready for both for interim and final. The court asked the petitioners, all the senior counsels who are appearing, do you want to argue on main or interim? They chose, my lords, to argue on interim. And my lords, matter went on for 2.5 hours. At the end of the hearing also, I made a submission. The 2.5 hours has already been
ನಾವು
spent.
ಬಿಟ್ರೆ ಇಲ್ಲೂ 2.5 hours
ಇಲ್ಲ, ಇಲ್ಲ, ಬೇಡ. ಅದಕ್ಕೆ ಅಲ್ಲಲ್ಲ ಅದಕ್ಕೆ ಜುಡಿಷಿಯಲ್ no, one
15 ನಿಮಿಷದಲ್ಲಿ ಮುಗಿಸ್ಬೇಕು.
ಅದಕ್ಕೆ 2.5 hours matter went on, and in fact I made a submission that in the event court is also it has also already heard the matter. My submission, my lords, was on merits in so far as the prima facie case that they're trying to make out. My lords, entry 6 in the same page of 259 covers transfers. 6 my lords, page 259 my lords, schedule 2 a public services ಅಂತ ಇದೆ ನೋಡಿ ಸಮ್. My lords, get it?
6 postings, appointment posting.
Appointments, this is DPR, my lords. Appointments, postings, transfers, leave and control of officers and other staff under the administrative control of the Department of Personal and Administrative Reforms, Deputy Commissioners, District Superintendents of Police. Now each department, now kindly see the Revenue Department, my lords, which is at page number, it's 277 start ಆಗುತ್ತೆ. At 277, my lord, schedule 14 is Revenue Department.
ಅಲ್ಲ ನಿಮ್ಗೀಗ
Lords, please.
understood now. Point is,
Lords, what we have actually done is this. Lords, there is a general transfer guidelines. I'm sorry, my lords.
ಆರ್ಗ್ಯುಮೆಂಟ್ ಹೆಂಗಿರ್ಬೇಕು ಅಂದ್ರೆ ಕೋರ್ಟಿನ ಮನಸ್ಸಿನಲ್ಲಿ ಎದ್ದಿರುವ ಪ್ರಶ್ನೆಗಳನ್ನ
Please.
ಉದ್ದೇಶಿಸುವ ವಾದ ಇರಬೇಕು.
I'm sorry.
ಇಲ್ಲಪ್ಪ ಅಂದ್ರೆ ನೀವು ನಿಮ್ಗೆ ಹೇಳ್ರಿ ನಮ್
ಇಲ್ಲ, ಇಲ್ಲ, sir. No.
ನಮ್ಮ ಮೈಂಡ್ ನಲ್ಲಿ ಏನಿದೆ that
Please.
you have to read now.
Please.
We are telling it now.
Please.
They say 24/6 June 2024 GO,
Please.
which is almost its counterpart is held to be statutory because of Chandru versus state, etc. Now, full bench.
Oh,
So the same principle applies to this also.
please.
It is an instrument having force of law. Number one. That instrument has an exclusionary clause,
Please.
which says these norms will not be applicable to such of the departments of the government
which have the advantage of matter being treated by a statute or rules promulgated under a statute. In the absence of such statute and rules, you cannot do all these things because government is normative in its process. At our argument.
For the answer is simple, my lords. The general transfer guidelines, my lords, are traceable to 162 power, executive power of the state. And in Chandru's case, my lords, 2001 guidelines, 2013, this honorable court has held it statutory force.
Okay.
In Gangadhar's case, it also held that 2011 is replaced by 13. So therefore, 2011 is one is held to have statutory force. 2013 also will have statutory force. On the same logic, 2024 also will have statutory force, my lords.
It has been
Now,
held so.
Please, 2024 will also have statutory force. What it is a general executive order, my lords, applicable to all the entire state.
No.
If I'll just make this up. My lords, if a special executive order is made, that also will have statutory force. My respectful submission is the executive order that I have now issued with the concurrence of the DPR and with cabinet approval also has statutory force because it is also a transfer guidelines applicable to a particular department. What exception has been carved out in the general transfer guidelines is this guidelines will not apply to such of the post
where
act rules have already been made.
You have already made in respect of 8 departments.
I have made. But my lords, the question, my lords, is this. If I have already made act and rules, I have the liberty to make act and rules for this department also.
Madi.
But do I have, my lords, the question I ask myself is, don't I have the power to issue a special executive order if there are two executive orders operating, one a general, a special. A special will prevail over the general is my argument. That, my lords, the court has to, my lords, answer. That is an argument, my lords, in law on the basis of Chandru's case and Gangadhar's case, full bench judgments of the Supreme.
No,
of
they
this honorable.
refer not only executive.
Please, my
They
lords.
say,
Please.
Gangadhara Swami's case.
Please.
The one judgment is Justice K.L. Manjunath, Chandru.
Yes,
Chandru.
B.S. Patil, Lordship
the
Justice B.S.
other-
Patil wrote for the division full bench.
Bench.
K.L.
ಅಲ್ಲಿ
Manjunath,
they
they
refer
was
to
heading the
Rule
bench.
8 ರೆಫರ್ ಮಾಡಿದ್ರ KCSR ನಲ್ಲಿ ಯಾವ್ದೋ
Rule
rule eight-
KCSR
eight-
rule 8 ರೆಫರ್ ಮಾಡಿ,
ಹಾ, eight
definition
refer
of
ಮಾಡಿ.
transfer ರೆಫರ್ ಮಾಡಿ.
See, these whatever you may call this.
Please.
These are in administrative law terminology, these are subordinate legislations. You call it as executive instructions with very difficult to agree. If they were to be executive instructions, their infraction would not have given cause of action to them at all. Going by Fernandez versus State of Mysore.
J.J. Fernandez.
J.J. Fernandez.
That's not the case.
Please.
They have said these are normative subordinate legislations.
No, no, so what the court has said is in Chandru's
No,
case.
these words are not used there.
No,
I have read all the 3 judgments.
they refer to 162 only, my lords.
Once correct. Even 162
Please, my lords.
is a power akin to executive power of the state in the light of Ram Javaya Kapoor,
Please.
the state of Punjab.
Please.
But they have referred to Rule 8 also. Number 1.
Please.
Number 2, in one judgment of expert said,
Please.
whether the executive instructions are given in such a way as to be bound by the maker, then they have got statutory force. The first general order says, if you have act or rules made under the act, then you are entitled to do
If you have already made.
Where is the act?
That is what it says.
Rule.
If it is already made ಅಂತ ಹೇಳುತ್ತೆ general transfer guidelines, not to be made ಅಲ್ಲ.
That
is-
will
if it's
cover
already
the,
made.
will be made also.
Made ಎಲ್ಲಿದೆ?
ಅಲ್ಲ, not in respect of this department. No, let's what we have done is this. In respect of the departments of stamps and registration.
That is one argument.
Please,
The
On-
second argument is,
please,
which heavens are falling down
please.
before 11th of November?
No, my lords. In fact, I was on the interim arrangement only. In fact, before the tribunal, when I concluded my submissions, I said that
ಅಷ್ಟು
matter is.
ಹೇಳ್ಬಿಡಿ ಅವರಿಗೆ.
ಇಲ್ಲ,
ಏನ್ ಗೊತ್ತಾ?
ಇಲ್ಲ.
11ರವರೆಗೆ ಏನು?
ಇಲ್ಲ, no, no,
Otherwise they will lose. See,
No, all we are interim arrangement ಬಗ್ಗೆ one submission.
ನಾವು ಒಂದ್ ಸ್ವಲ್ಪ
ಆಯ್ತು.
ನಮ್ದು ಒಂದ್ ಸ್ವಲ್ಪ ಆರ್ಗ್ಯುಮೆಂಟ್
Please,
ಕೇಳ್ಬಿಡಿ.
please, please.
ನಾವೇನಂತೀವಿ ಅಂದ್ರೆ 11th, before 11th,
Please,
during Diwali,
please.
whether heavens are going to fall down?
Certainly not, my lords.
Certainly.
No.
So you hold your hands off now.
Please,
Will request the tribunal
please,
to take this matter
please,
out of the term
please,
and decide it.
please,
Till then,
please.
you just keep quiet. Nothing is, the soldiers will work in the border,
Other-
tillers will till the land, farmers will till the land,
Please,
laborers will work in the factory. Nothing is going to change
please, my lords. I get it.
in before 11th of November.
Please.
Number is just, it's.
I know, Milords, one more week, not next Monday, the next Monday after that.
That's the.
May I just make my submission, Milords, on the interim arrangement?
Head.
Milords, we had made a submission, Milords, yesterday at the fag end of hearing, that matter was literally heard in extenso. So judicial time is a scarce thing. So what happens is, you can hear it immediately thereafter, but they insisted, no, let there be an order on interim prayer. One
Anxiety.
anxiety. Now, Milords, what we had done is, this is special policy, Milords, for only 3 cadres, sub-registrar, senior sub-registrar, as a reformative process in respect of the registration process.
ಅಷ್ಟು ಪ್ರಾಫಿಟಬಲ್ ಇದಾವನು ಆಫೀಸ್ಗಳು.
They are, in fact,
ವ್ಯವಹಾರ
my lords have addressed the elephant in the room. My lords have addressed the elephant in the room. We are doing a reformative. What we are saying is this: one submission, on interim arrangement. Lords, Monday, today was the counselling to be scheduled. Yesterday order came late, so I postponed the counselling to Monday. Now, my lords, I will say that in the process of counselling, we had also set the exemption under the general transfer guidelines with regard to
ಕೌನ್ಸಿಲಿಂಗ್ ಮಾಡಿ.
counselling ಮಾಡ್ತೀನಿ, effect ಕೊಡಲ್ಲ.
ಇಫೆಕ್ಟ್ ಕೊಡಬಾರ್ದು.
ಅಷ್ಟೇ ಸೊ.
ಎಲ್ಲರಿಗೂ ಕೌನ್ಸಿಲಿಂಗ್ ಮಾಡಿ.
Let them participate.
ಬಹಳ ಕೌನ್ಸಿಲಿಂಗ್ ಅಗತ್ಯ ಇದೆ.
I will not give effect to that. Counselling, let them participate.
On
Profitability.
that only one submission on this counseling ಮಾಡಿ ಅಂತ ಹೇಳಿದಕ್ಕೆ only one submission.
ಜೋಶಿ, ಈಗ ನಾವು ಕೌನ್ಸಿಲಿಂಗ್ ಮಾಡ್ಬೇಡ್ರಿ ಅಂತ ಕೊಟ್ರೆ, ನಾಳೆ ಬಿಫೋರ್ ದ ಇಂಕ್ ಆಫ್ ಅವರ್ ಆರ್ಡರ್ ಡ್ರೈಸ್ ಅಪ್, ಇಟ್ ವಿಲ್ ಬಿ ಸ್ಟೇಡ್ ಎಲ್ಸ್ವೇರ್. Don't give that chance.
The only concern that we
Because my
have
lords asked about the
are in my lord's
profitability.
hands. The only
My lords asked about profitability of the office. May I just make one sentence?
Then not necessary.
ಅಲ್ಲ.
Yeah, that everybody has lost.
ಅಲ್ಲಲ್ಲ.
Laughter says.
ಅಲ್ಲಲ್ಲ, ಟ್ರಾನ್ಸ್ಫರ್ ಆರ್ಡರ್ ಮಾಡೋರುನು ಅವ್ರ ಪ್ರಾಫಿಟ್ ಗಮನದಲ್ಲಿ ಇಟ್ಕೊಂಡು ಮಾಡ್ತಾರೆ. ಯಾಕಂದ್ರೆ every transfer is imminently reversible.
the only
From this forum, we don't subscribe to that.
the only concern.
I never expected my lords to subscribe to that.
Let me hear only this submission on the counseling.
ಬರ್ಕೊಳ್ಳಿ.
One submission, the counseling.
Please be seated. Be seated. ಎಲ್ಲರೂ ಕೂತ್ಕೊಳ್ಳಿ. ಟೈಮಿಂಗ್ ವೇಸ್ಟ್ ಮಾಡಿ 2.5 ತಾಸು ಆರ್ಗ್ಯುಮೆಂಟ್ ಆಗಿ ಟ್ರೈಬ್ಯುನಲ್ ಯಾವ್ದಕ್ಕೆ ಆರ್ಗ್ಯುಮೆಂಟ್ ಆಗಿದೆ 2.5 ತಾಸು. ಬರ್ಕೊಳ್ಳಿ. All these applications by the civil servants call in question common order or independent order?
Common order.
A common interim order of the service tribunal whereby reprieve has been denied, fixing 11th of November 2024 as the date of hearing. Full stop. All the senior advocates ably assisted by other advocates on record in chorus submitted inter-alia that in the absence of a legislation or subordinate legislation promulgated under such legislations, the transfer guidelines promulgated wide government order dated 25/6/2024 would govern the transfer and deployment of civil servants. And there being no such legislation or para-legislation, these general guidelines of transfer would govern the issue. Full stop. In support of that, they drew our attention to the provisions of allocation of Karnataka allocation of business rules.
Karnataka government allocation of business rules 1977.
Business rules 1977.
77.
Full stop. They also wanted to argue more, but we stopped them as a concession to shortness of human life. Full stop. Learned additional advocate general mentioning 2 full bench judgments of this court and 1 division bench judgment. Although
Gangadhara Swami division bench, full bench, adu. All the three are full bench.
Only two.
Latest two plus H.V. Sudhakar, which has come after 2024 guidelines. Division bench.
Two full bench judgments of this court submits that regardless of the nomenclature of these guidelines, comma, essentially they have been promulgated in exercise of executive power availing under Article 162. Correct?
Correct.
Of the Constitution in the light of Ram Javaya Kapoor versus State of Punjab. And they do not, there is no distinction between one set of such executive instructions qua the other set of executive instructions, comma, and therefore the tribunal has rightly denied reprieve to the petitioners. First stop. In all fairness, he also said that let the ongoing counseling be continued in its usual course, subject to outcome of the pending applications before the tribunal. Full stop. Next paragraph. Having heard learned counsel appearing for the parties and having perused the petition papers and also having adverted to cursorily adverted to the ruling cited at the bar, we are of a considered opinion that the status quo qua the places for postings be maintained till after the tribunal takes up the pending applications for consideration and disposal. First up, we request the tribunal to take up the pending applications. For that purpose, at the earliest. First stop. Next paragraph. Ordered accordingly and writ petitions are disposed of. One sentence had made. We don't propose to treat the pure question of law raised at the bar, debated before the court, since that happens to be the fulcrum of the case before the tribunal. One sentence had made.
It's counseling.
One
Counseling
concern
will
I
be
was-
held on for, but not effective.
ಬರ್ಲಿಲ್ಲ. We make it clear. ಅಲ್ಲ, ಮೇಲ್ಗಡೆ ಸ್ವಲ್ಪ ಅಲ್ಲೇ. It is made clear that the ongoing ಅಲ್ಲಿ ಬಂದಿದೆ.
ಇಲ್ಲ,
ಓದಿ ಒಂದ್ಸರಿ.
ಇಲ್ಲ, my submission.
ಅಂದಾಗನೇ ಓದಿಸಿ ಬಿಡ್ಬೇಕು. ಓದಿ. ಅದು ಬಂದಿದೆಯಲ್ಲ ಅನ್ನೋ ಬಗ್ಗೆ ಆರ್ಗ್ಯುಮೆಂಟ್ ಮಾಡಬಾರ್ದು. ಅದು ಬಂದಿದ್ರೆ ಇರತ್ತಿಲ್ಲ. ಓದಿ ಬಿಡಿ. Adverted to post placement or postings. You're right. Barkade. ಅಲ್ಲಿ ಹಿಂದ್ಗಡೆ ಬಂದದೆ. ನಿಮ್ಮ ಆರ್ಗ್ಯುಮೆಂಟ್.
My submission is.
You are right. ಅಲ್ಲಿ ನೋಡಮ್ಮ, ಅಲ್ಲಿ ಬರ್ಕೊಳ್ಳಿ ಒಂದ್ಸರಿ. The ongoing counseling process is not halted and its result shall not be given effect to till after the disposal of the pending application.
Grateful.
Great.
Plus 1 week, but in case the tribunal goes against us, we may have some opportunity to approach this court.
That is always with you.
Sir,
There's a fresh cause
the-
of action.
No,
My lord, on the counseling, just.
Yesterday,
the-
5:30 it
My lord, the order has been dictated. Just one concern I had to bring to the attention of the court.
Please do not waste our time. All petitions disposed of, no cause. Yes. ಅಲ್ಲ ಆ ರೂಲಿಂಗ್ಸ್ ಸೈಟೇಷನ್ ಕೊಡಿ ಅವು ಫುಲ್ ಬೆಂಚ್ ಅದು ಎರಡು ಗಂಗಾಧರ ಮೂರ್ತಿ ಅವಾಗ ಇತ್ತಲ್ಲ ಗಂಗಾಧರ ಸ್ವಾಮಿ
But it is cited
ಚಂದ್ರು.
in the,
ಕೊಡಿ,
it is
ಬರ್ಕೊಳ್ಳಿ.
cited in the very order.
I'll-
Into order. I will get.
ಎಸ್ ಅದ್ ಮೇಡಮ್ ಅದನ್ನ ಸ್ವಲ್ಪ ರೆಫರ್ ಮಾಡ್ಕೊಂಡು ಬರೀ
H N Chandru is cited.
ಸೈಟೆಡ್ ಎಟ್ ದ ಬಾರ್ ಇದೆಯಲ್ಲ ಆ ಆರ್ಡರ್ ನಲ್ಲಿ ರೆಫರ್ ಆಗಿದೆ ಜಸ್ಟ್ ಸ್ಟ್ರಕ್ಚರ್ ಎಸ್
ನೀವು ಫೈಲ್ ಓಪನ್ ಮಾಡೋ ಅಷ್ಟೊತ್ತಿಗೆ ಡಿಸ್ಪೋಸ್.
33. ಮಂಗಳವಾರ.
Madam, page 58 ಅದಿದೆ. Citations.
Sir.
ಅದೇ
next to
same
cyber single
repetition.
figure.
29309 ಇದೆಯಲ್ಲ? 29309 repetition.
One day ಮುಂಚೆನೆ ಗೊತ್ತಾಗಲ್ಲ.
29309. ಅದರಲ್ಲಿ
ಹೌದಾ?
page 58, paragraph 15 ಅಲ್ಲಿ ಇದೆ. ಅದು ಭಾಗವತ್ ಅಸೋಸಿಯೇಟ್ ಮೂರದು ಸೇಮ್ ಪೇಜ್ ಅದೇ. ಥ್ಯಾಂಕ್ ಯು.
34.
ಸೀರಿಯಲ್ ನಂಬರ್ ಎಷ್ಟು ಮೇಡಮ್?
ಯಾವಾಗ
ಸರ್ ಈಗ ಮ್ಯಾಟರ್ ನಡೆದಿದೆ ಸೀರಿಯಲ್ ನಂಬರ್ ಎಷ್ಟು? ಅಲ್ಲ ಈಗ ನಡೆದಿದ್ದ ಮ್ಯಾಟರ್ ಸೀರಿಯಲ್ ನಂಬರ್ ಎಷ್ಟು?
1.5 year ಆಗೋಯ್ತು.
ಹಾ?
Last week ನನ್ನ ಮ್ಯಾರೇಜ್
ಹಲೋ
ಸರ್ ಒಂದು
ಈಗ ನಡೆದಿದ್ದ ಮ್ಯಾಟರ್ ಸೀರಿಯಲ್ ನಂಬರ್ ಎಷ್ಟು? ಈಗ ಡಿಸ್ಪೋಸ್ ಆಗಿದ್ದ ಮ್ಯಾಟರ್ ಸೀರಿಯಲ್ ನಂಬರ್ ಎಷ್ಟು ಮೇಡಮ್? ಈಗ ಡಿಸ್ಪೋಸರ್ ಆಗಿದ್ದ ಸೀರಿಯಲ್ ನಂಬರ್ ಎಷ್ಟು? ಈಗ ಡಿಸ್ಪೋಸಲ್ ಆಗಿ ಸೀರಿಯಲ್ ನಂಬರ್ ಎಷ್ಟು ಸರ್? ಸರ್ ಇವಾಗ ಡಿಸ್ಪೋಸ್ ಆಗಿದ್ದ ಸೀರಿಯಲ್ ನಂಬರ್ ಎಷ್ಟು ಸರ್?
ಸರ್ ಡಿಸ್ಪೋಸ್ ಆಗಿದ್ದ ಫೈಲ್ಸ್ 4 o'clock ಬಂದಿದ್ದು ಔಟ್ ಆಫ್ ಟರ್ನ್ ತಗೊಂಡಿದ್ದು ಫ್ರೆಶ್ ಮ್ಯಾಟರ್ಸ್ ಅದು.
ಫ್ರೆಶ್ ಮ್ಯಾಟರ್ ಸರ್, ಅದು ನಂಬರ್ ಹೇಳಕ್ಕಾಗತ್ತಾ ಸರ್?
ನಂಬರ್ 9 ಇದೆ ಸರ್, 9 ನಂಬರ್ ಹೇಳಕ್ಕಾಗತ್ತಾ?
ಒಂದು ಹೇಳಿ ಸಾಕು.
29361
29361
of 24.
24
ಹಾ
WP ನ ಸರ್?
WP ಸರ್.
ಥ್ಯಾಂಕ್ ಯು ಸರ್. ಥ್ಯಾಂಕ್ ಯು ಥ್ಯಾಂಕ್ ಯು ವೆರಿ ಮಚ್.
ಅವ್ರು ಮುಂಚೆನೆ ಹೇಳ್ಬಿಟ್ಟಿದಾರಲ್ಲ ಎಷ್ಟು ಫೈಲ್ ಬಂತು ಅಷ್ಟು, ಬಾಕಿ ಎಲ್ಲ ಕಾಪಿ ಪೇಸ್ಟ್.